broadcast going. So welcome to the second hearing of the Committee's inquiry into the Workers' Compensation Legislation Amendment Bill 2025. I acknowledge the Gadigal people of the Eora Nation, the traditional custodians of the lands on which we're meeting today, and I pay my respects to Elders past and present and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and waters of New South Wales. I also acknowledge and pay my respects to any Aboriginal and Torres Strait Islander people joining us today or watching us online. My name is Abigail Boyd and I am chair of this committee. I ask everyone in the room to please turn their mobile phones to silent. Parliamentary privilege applies to witnesses in relation to the evidence they give today. However, it does not apply to what witnesses say outside of this hearing. I urge witnesses to be careful about making comments to the media or to others after completing their evidence. In addition, the Legislative Council has adopted rules to provide procedural fairness for inquiry participants. I encourage committee members and witnesses to be mindful of these procedures. So I now welcome our first witnesses. Thank you very much for making the time to give evidence. And if I could get each witness, starting on my left, to state their name and position title and then swear either the oath or the affirmation.
Good morning. I, Susanna Marie Harwood, Assistant Auditor General, Performance Audit, solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
Bola Yetunji, the New South Wales Auditor General. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you very much. And would you like to make a short opening statement?
Yes, if that's all right, Chair.
Yes, please.
Thank you for the invitation to inviting me to provide evidence in this inquiry. I would like to begin by noting that some aspects of the terms of the reference of this inquiry may fall outside my remit as Auditor General. As you'll be aware, the Government Sector Audit Act 1983, which establishes the role of the Auditor General as an independent and accountable statutory officer, prevents the Auditor General from questioning the merits of policy objectives of the government. So this restriction limits my ability to comment on the details of the Workers' Compensation Legislation Amendment Bill 2025. However, the Auditor General's mandate includes conducting financial and performance audits that relate to workers' compensation schemes in New South Wales. A review of the relevant Audit Office reports to the New South Wales Parliament over the past 15 years shows that there have been long concerns about the financial sustainability of workers' compensation schemes in New South Wales. For example, in 2011, the Audit Office reported that the financial position of the New South Wales Work Cover Scheme, as it was then known, was deteriorating, with workers' compensation liabilities increasing significantly. The report warned that the scheme may not be collecting enough premiums to meet its requirements to sustain long-term funding. The report suggested that the issues with the operations of the scheme required proactive management. The Audit Office reported an improved financial position for work cover in financial years 2012-13 and 2013-14. This was attributed to high investment returns and lower outstanding claims liability as a result of the reforms introduced in 2012. Our financial audit reports in 2019 and 2020 drew attention to the fact that the financial position of both the private and public sector workers' compensation schemes was again deteriorating. Further, our financial audit reports in 2021 and 2022 made findings regarding the decline in the key measures of financial sustainability of workers' compensation schemes and made recommendations about the need to address inaccuracies in payments to injured workers. Most recently, in April 2024, the Audit Office tabled a performance audit report titled Workers' Compensation Claims Management. This audit assessed the effectiveness and economy of IK's management of workers' compensation claims and the effectiveness of the state insurance and regulatory authorities' oversight of workers' compensation claims. The report found that IK was implementing major reforms to its approach to workers' compensation claims management, but was yet to demonstrate these changes were the most effective or economical way to improve outcomes. IKEA's planning and insurance processes for its reform had not adequately addressed existing claims models or analyzed reform options, and that IKEA's activities are not focused enough on the core responsibilities of improving return to work and maintaining financial sustainability. The report made several recommendations, including that IKEA should increase the transparency of its operations by ensuring its annual statement of business intent clearly sets out its approach to achieving legislative objectives for the workers' compensation scheme. IKEA should develop a monitoring and evaluation framework to assess the effectiveness of its recent reforms to workers' compensation scheme, and that the New South Wales Treasury should work with agencies, including IKEA, SIRA, and SafeWork, to identify actions to improve the long-term financial sustainability of the schemes. In addition to the Audit Office's historical interest in the financial sustainability of workers' compensation schemes and the efficacy with which those schemes are managed, I have a continuing interest in this topic. So as of yesterday, I sent a draft of my audit work program to New South Wales departmental secretaries, setting out my audit priorities for the year ahead. In this program, I've included a proposed performance audit of workers' compensation schemes, which is an audit I plan to conduct this financial year. The scope of this audit will complement the work of this inquiry by focusing on the efficiency and effectiveness of service delivery to improve outcomes for injured workers. So we're happy to take questions if there are any.
That's excellent news. Thank you. We will commence with questions from the opposition.
Well, in fact, that is the first we've heard of your interest in the manner in which IKEA are currently managing claims managers. However, in 2024, the Auditor General made this observation. IKEA reforms for the TMF in recent years have not given sufficient attention to the key issue of the increasing number of psychological claims, which poses substantial risks to the financial sustainability of the TMF. So that was an observation made in 2024. Are you aware, or have you had it drawn to your attention, what steps, if any, the TMF or claims managers have taken in relation to seeking to maintain the financial viability of the scheme since April 2024?
In current times, I've not had any opportunity to do any audit process or follow up on what was reported. What I will say is I've had meetings with the IKEA management referring to some of their programs and approaches to improve the sustainability of the schemes. And that is where I think for me to be able to answer that question directly will be when we go there this year to do the assessment. And if you look at the report talked about the psychological injuries increasing from 11% to 20%, still at a very high 17% of the total claims. So that is a significant increase in the psychological claims that we're seeing, and hopefully a very good proactive management of that will be a focus on what needs to be done in that space.
So just let me understand that your position, that the manner in which you say the key lever for, I suppose, dealing with the increase in psychological claims is proper claims management.
Two things, though. So that's one, proper claims management. The other one, if you just recall the report we tabled on the well-being of mental health and well-being of New South Wales police officers, one of the things we looked at in psychological claims is to look at the root cause, of some of these issues coming through. And the root cause and the data that is available and the analysis of that data can help not only before it gets to the claims, the preventative measures, which becomes important, and again, some of the training and engagement with employers, so that we have preventative measures before we get to claims management.
So, if just focusing on claims management, so there appears to be two aspects to what I understand is claims management and collection of data for understanding the manner in which claims are arising or whatever.
Yes.
In dealing with claims management, what do you see are the issues relating to claims management within the perspective of the Auditor General?
Yes. And that your question goes into how we're going to scope the next audit. Because the claims management, and we've reported oversight by ICAP, SIRA, and the question will be, before I finalize the scope, or just the teaser is actually maybe going through to the claims managers. We've not done it before. We have the follow the dollar powers. That could be something that we're part of complementing what this inquiry is doing. Because, we've heard a lot of discussion about claims management. I've received, a lot of information from the public about what is wrong with the claims management, but because we've not audited it, at this point, I'm not able to have a definitive answer what the problem is there, but we're going to go there.
I don't know whether you've had an opportunity of reviewing any of the other submissions which have been made to this inquiry.
Yes, I have, at a high level, yes.
Have you had an opportunity of reviewing the submission made by the Bar Association?
I can recall specifically.
The Bar Association makes certain observations relating to the manner in which, for example, the cost of rehabilitation reports are provided in terms of capacity for work and whether they are appropriate use or of expenditure in terms of the manner in which claims managers are dealing with return to work issues, whether they are potentially value for money in respect of which psychological claims would be handled. Is that something within the scope of your inquiry that you would be looking at? Is the cost effectiveness of decisions being made, bureaucratic decisions being made, for the purposes of assessing work capacity of an injured worker?
I believe it should and it will, because I've included the efficiency aspect of the performance audit there. So we'll look at that as part of that process. Again, part of what I think we were just discussing before, which is where we're going to look at the details of the transcripts of this inquiry, so that when we are formulating the scope of the next audit, it's robust enough to address some of the fundamental issues that will help, again, improve outcomes for injured workers, because, again, that is what everyone is looking to do. How do you drive, some of the efficiency, some of the expenditure controls? A few people in the public will write me and talk about, some of the pricing of some of the services they get. They think it's incorrect, it's probably inflated. Those are the things they tell me. And again, as Auditor General, it's my role to independently verify that and report to Parliament.
Well, is it within the scope of the work that you would do that you would look at the potential effectiveness of commutations of claims?
I've not considered that, but it's something that we can discuss.
Well, if in fact it provided downward pressure in relation to the financial pressure on the scheme, is that something which you would look at for the purposes of making recommendations as to the potential future viability of workers' compensation in its current form?
Yeah, it's something we can consider, because that leads to the efficiency of the outcomes of the scheme itself, because if it puts downward pressure on the liabilities, then that drives efficiency in the scheme.
I must say this is the information you've provided this morning probably is a window into the consultation process which has gone on before this bill. The fact that we're doing this now would seem to me potentially to give much more information as to where the financial pressures are on this scheme currently, which would possibly educate the legislators for the purposes of making sure that they got all the parameters right. That's an observation by me, but what I'm wanting to know is the broad ranging nature of potential your inquiry to make recommendations or findings in respect of the way claims management is currently being run, but potentially other things in respect of the scheme which should be looked at.
Yeah, that's correct. And I think I've read through, as I said, some of the transcripts. It's been useful to understand where the key drivers are. Some of the new things, I learned from reading this transcript that, again, when we're formulating our own scope, we'll definitely put it there. There's other fundamental issues, that I've not settled in my head yet, so I'm unable to make it public, that I'll also be looking at in terms of the structure of the scheme itself. So there's a lot of things that hopefully we can add value to what this inquiry is doing. So if I get my scope right, there would not be any duplication, but there will be something that will complement, so to get the right outcomes, for the injured workers.
One of the concerns also raised by the Bar Association was the potential cost shifting from the compensation scheme to other welfare agencies, whether it be NDIS or the public health system or the like. Is that something also your inquiry will address? Is if in fact we increase the whole of person impairment to 31% for continuing claims, will your inquiry look at the extent to which that involves cost shifting to other agencies?
It will unlikely include that, Mr. Chidiho, because it will be too broad, for a normal cycle performance audit. And it will also, if I understand the way you've described it, it may also be moving towards what I'll call a policy of government.
How long do you think this audit will take?
If I get it right, I want to table by June 2026. I want to make it quick and fast.
Thank you. Thank you for appearing today, and I know it's the work under your predecessor, but the Workers' Compensation Claims Management audit report has been incredibly useful for my understanding of what's going on here as well. One of the issues that keeps coming up is the sort of nebulous assumptions on which a lot of the valuations are based on, and I'm hoping you can sort of clarify some of this for me. You identified the assumptions in the I believe it was the nominal insurer liability valuation as a key audit matter. Obviously, with these long-tail insurance schemes like workers' comp, even very small changes in assumptions can have quite a large impact on what sort of forecast to occur in the future and how much money the scheme needs and how financially stable it is. What I've noticed is that there is a bit of debate in the documents between various auditors as to how these assumptions should be crafted. And I'll bring you to one of them. Finity, in their actuarial evaluation for the nominal insurer in June 2024, had an assumption that there would be a decreasing proportion of WPI 15 plus psychological claims after March 2022, after that accident year, but then another firm comes in and questions that assumption and essentially says that if you get that wrong, the impact will be quite large. And so as a result, Finity then revised that assumption upwards and now assumes a much worse case scenario looking into the future. Obviously, there's this enormous level of judgment that goes into things, but how do you, I guess, as the Auditor General looking at that, work out where the sensible assumption is? How should we be thinking about those assumptions?
Yes. Those valuations are very complex, and again, if you look at the actuaries, even they use central estimates, so it's just a lot of judgment and reasonableness, and I think the central estimate, probably probability of 50%, right or wrong. Now, so what we look at is, and this is where you start picking the key drivers, that will impact valuation. I remember a long time ago, one of the key drivers was the cost of, medicals, So you start looking at that, and I think the actuaries will use what they call claims experience, So if, so the rate is going up is what they'll project to the future. Now, there could be, so if you, and an actuary could look at a certain aspect of the assumption, and based on legislation reforms, assume that may tamper down in future. Now, one of the things that then could happen is once you start, and I think they do that every year, once you start seeing a change, that you're getting the assumption right, and that's why they do it every year, then they change the valuation. So that's why the valuation, can move very quickly up. Now, also then, what the actuaries have perfected is now, and this is where I think with data, a lot of these things will be perfected better when you have, quality and complete data, is when what used to cause problems will be discount rates. It can go up and down depending on what the discount rate is. But the actuaries now have in a process, I think they use the gap, between, the CPI and the discount rate. So that allows the consistency of the valuation. So, yes, so what we do, and I must say, we also then, and this is where we also then bring in our experts, because, if it's not an area where you have expertise in, we then bring an expert to have a look and have that discussion. So it's, and that complexity, requires that. Now, what then helps us as the audit office is we now look at all the assumptions and look at the data backing the assumption and how reasonable it is. That's what we determine, which of the assumptions it fits into the evaluation.
So just on that, in the claims management audit report, there was discussion about how when iCare moved to a single claims manager, the return to work rates fell quite significantly. And in that report, it notes that the impact of that lower return to work rate is felt for many, many years before it sort of flows out of the system. The report also notes that moving again, basically every time you make a change to the claims service provision and the models, it will then take a period of time for that to flow through as well. I guess given that, how much should we be relying on the sort of the changes over a couple of years versus looking at a much longer period of time when we're thinking about whether or not to make changes to workers' compensation schemes?
I believe, it's a longer term that, most actuaries and valuers would use anyway. I think what we pointed out in the report, and I think there was a reason why it was done for that year because of the new contracts and, giving them time to, settle in and, get their processes right. But the key part of it is once you lose it for 1 year, the compounding effect will be felt, going forward. So it's the compound impact of even losing 1 year. It just doesn't restrict to 1 year. It can stay for a longer term. But that's why I suppose the IKEA with their reforms and some of the strategies, the proactive management, should be picking some of these things and should be agile enough to adjust, as we go forward. And I think even when you mention the lawyers, sometimes they're also part of the process where if you can have a reform and you can have a good reform if they pick gaps in it and maximize what the outcome is for their clients. That's why there's a continuous process, and it's a complex environment. Sometimes if reading through some of the transcripts, the experience of the claim managers too. If the claim managers are not experienced enough, to start looking for some of these problems and loopholes and manage it well, then we'll have a system that will continue deteriorating if you don't manage it well.
Thank you. I'll now go to the Honourable Mark Latham, who is online.
Thank you, Chair, and thank you to our witnesses. And can I thank overall the Auditor General and his office for the outstanding work they do in New South Wales. The current government we've got is the least accountable and least transparent since the time of Askin. So you're obviously a very busy office, and we look forward to the work you're doing in this workers' compensation space. But have you looked at the competence and accuracy of actuarial modelling at iCare? We had their actuarial guy at the committee, and you'd think this was just his bread and butter 101, that he'd have at his fingertips the cost of amendments that were made to this particular bill in the lower house. He had no such thing. He just looked completely flummoxed and incompetent, nor could he tell us the time frame in which he was asked to provide any information about those lower house amendments. A lot of focus on potential upper house amendments, like they're a bolt of lightning that's hit everyone. But this actuarial guy presented in a way where I have no confidence at all in his ability. And I also wonder, as someone with a bit of a background in economics, what are the assumptions they use for this type of modelling, particularly on things that have never happened before and would be very subject to behavioural economic variations, reactions in human nature to how people respond to their opportunity to get into the scheme, and then what happens once they're in. So if you've got any comments on that, please, Auditor General.
Yes, Mr. Latham. What they would do normally is what we call scenario analysis, and within that scenario, they have the probability of what will occur. But I'm also saying, though, that when you talk about the actuaries, they also have, and I think IKEA also will have, specialist actuaries that is advising them. So the witness probably will not be the only actuary that will be designing the model. They will also have experts, because it's actuary is a very, it's a very complex and highly technical profession. So I think those who do it well actually use the panel to think through some of the judgments and as you said, and as I said before, if something has not happened before, you model the scenario and use probability to do the initial cut. And then what they do is what they call using the claims experience or claimant's experience to now start revising it. So what we then look at is just to make sure that all those assumptions are reasonable, and we then again, as I said, we use our own experts. So there's a lot of experts before the final figure is struck, Mr. Latham, before and that's the within the actuary standards, that's what we accept.
Yeah, well, so you're saying they're matters of judgment and probability based on things that have never happened before. So in the world of economics, we normally decode that as guesswork, and that's how it appears to me. When the current Treasurer was in opposition, it's legend around Parliament House, he thought that the I in iCare standard for incompetent, and he was so rigorous in his examination of iCare witnesses at committees like this that he put a couple of them into mental homes and mental care. Have you noted any improvement in the competence of iCare from those times, and also the revolving door? I've seen a fair bit about iCare in my time as a parliamentarian, but they must have had 4 CEOs in the last 6 years and other changes. Surely this revolving door of senior management has led to instability and further incompetence.
What I would say, Mr. Latham, is the new CEO that started in March. I've met the CEO. I'm meeting her again in a couple of weeks. I've met the chair of the Audit and Risk Committee, and I've also made a request to meet the chair of the board. So what, again, my answer to you is, I'm just, it's important for me, to have my own initial assessment, and to be able to then at least hold them accountable to what our recommendations have been and what they've put out they're going to do. And that is my approach to make sure that I have that engagement with them. But at this stage, it's too early for me to make any strong comment.
Okay, well, I just flagged that obviously management stability and competence is a big part of a performance audit, so we look forward to your findings in that regard. Have you got any thoughts for us about industrial scale rorting of workers' compensation in this psychological injury field, where clearly, and I've given one famous example of it that is kind of surreal, that psychs out there, the word on the street is that if you're an honest psych and you're giving an honest assessment about patients who tried to coach themselves to get these WPI gradings, and you find that, well, no, they're not really haven't got a psychological injury, you lose a lot of business. So there's a cottage industry out there of psychs who are verifying anything, someone who's completely functional, vibrant, active on Instagram, getting things done in the workplace, can be said to be dysfunctional and can't go to large gatherings. So how do we clean this out? The sensible people in this space, led by Unions New South Wales, identify medical and legal fraud in this area as off the radar and absolutely essential to bringing down costs while not punishing those who have genuine long-term psychological injuries and deserve genuine long-term income support.
Yes. So what I've not heard, and in the inquiry, and maybe I've missed it, is the power and the use of data, and data analysis and data analytics, because what you've described is where you have enough data and you have enough analysis, you can actually pick where the red flags are. And if I believe we use data analytics properly, and we've started using a significant amount of data analytics in our work, we hopefully, some of this will help decision makers at least to have the information. So, which is where the thing we don't have now is, you described some problems out there. What we need is then data to back it up and make sure that decision makers are using the data to improve the process. But if I answer your question, I believe, yes, we've heard it's there. I've been reaching. I've got some message from the public, what is happening. But I just need to make sure that I get enough data as evidence to then have the right recommendation of how we move forward, so that, again, we want to minimize, those who are gaming the system. Will people game the system? Of course, yes. But if we can reduce that percentage to what you call statistically insignificant amount, then we're in the right trajectory to improve the sustainability of the schemes.
Well, I appreciate that. I think Auditor General, like me, you appreciate accuracy and exactitude in your work life. But haven't we got a basic problem in terms of data, the accuracy of this data, that We've got X-rays for the back. We can see he's got a physical back injury. We've got no X-rays for the brain. Medical science in this area is still unformed, and it's said we know everything about mental illness, psychological injuries, except what causes them and what fixes them. So we're a long way off having data that anyone can rely on. Haven't we got to get to the point of government being serious? I mean, they're out there deregistering and harassing tobacco shops where people are trying to get a big cigarette. But these spikes,
order. Sorry, Mr. Latham. Your time did run out.
Order of the psych industry, please.
Apologies, Mr. Latham. You can't hear the bell, but your time ran out about a minute ago. I will just allow the witnesses to answer if they would like, and then I'm going to hand over to government time.
Oh, thank you. Sorry, Chair.
That's right.
But again, I'll take that on notice.
Okay.
Yeah, because I think it's it's
well,
an important.
A wonderful thing, isn't it, in a parliament that dances around the mulberry bush with a treasurer who does that. So anyway, if you can take that on notice, I appreciate it. Thank you.
Yeah, thanks, Mr. Latham.
Thank you. Government members.
Thank you, Chair, and thank you for your evidence this morning. Could I just come back to the actuarial analysis that's been undertaken by iCare? Have you or your office reviewed it or inspected it?
Yeah, so every year before we sign off on the financial statement, we do review it, and we also have our own experts actually to have a review on it, and that's the basis we sign off the opinion in the financial report.
So from a public accountability perspective, you believe the iCare actuarial analysis is a reasonable basis for assessing financial risk to the scheme?
Yes, as at the 30 June 2024 that we've audited, yes, that's correct.
If I could refer to your predecessor's report into workers' compensation claims management from last year, it made the observation, and I quote, "Over the last 5 years, the NI's financial position has deteriorated from a net asset surplus of $1.6 billion at 30 June 2019 to a net asset deficiency of $1.8 billion at 30 June 2023. The negative net assets mean that the NI does not hold sufficient capital to meet the estimated present value of its future payment obligations." Now, obviously, those numbers have gone to $6 billion this year, deficit, and it holds 78 cents in assets for every dollar, a future liability. For a layman, it appears as though the scheme doesn't hold enough capital to meet the value of its current and future payments. Is that an accurate assessment?
At the point in time, that's correct.
Would it be fair to say that for employers, for workers and the public at large to have confidence in the system and in the scheme, it should be fully funded? That the public ought to have confidence that there's a scheme that supports workers in the short and long term in a way that is self-sufficient without these recurring deficits?
Yeah, that's correct, because you need the confidence that it's fully funded. You need the confidence that the injured workers will have funding to pay for their continuous treatment, and otherwise, and also, which is probably the complexity of it too, is you also want to make sure that the employers and the premiums are reasonable, so that you don't lose employers to other states or they go under. So again, to answer your question, a fully funded scheme is the only way that employers and employees will have confidence in the scheme.
Now, you say that that's an assessment at a point in time, but obviously the issues and the deficits that the scheme face are a factor of what has happened, not just in the current financial year, but what has happened over historic trends over a significant number of years. There have been a number of criticisms of claims management, particularly in the past, which has no doubt contributed to the current shortfall in the scheme. We've had now the McDougall review, we've had the Dorr review, we've had the Auditor General's Office 2024 review into aspects of the workers' compensation scheme. Can you just outline for the committee improvements that you have seen over that period to the scheme's administration and operation, including but not limited to claims management?
I think we'll be able to answer that question when we do the new audits, in the sense that I don't want to speculate because I've not audited any aspects, of what is happening currently. So we will put that as part of the scope of a new audit. I must say, though, that the reason why I said it's a complex structure is that even if you get the scheme to be fully funded, there needs to be enough rigor and proactive management to make sure that it continues. And this is what I believe, again, which we'll audit, in the next year. That I've been in my discussion with the current management of ICARE. That is what they plan to do, and that's what their new approaches and reform is intended to do. Because, as I said before, if you have your eye off the ball for 1 year, the compounding effect takes longer to correct. So sorry I'm not able to answer your question directly, but I believe the audits that we'll do this year will be able to do that.
Could I perhaps ask that you take on notice, particularly in terms of recommendations that arose from the Auditor General's 2024 review into claims management, but as well as the McDougall and Dorr reviews? There are a number of significant reviews with significant recommendations, many of which claims providers and ICARE are saying have been implemented and are starting to bear fruit. So I'd be interested in your analysis as to whether that is accurate or not. So if you could
we can take that on notice.
Thank you. The Secretary of the Treasury Department has provided evidence to this committee that Treasury has taken the view, following their operational review into ICARE, that where it can and should save money, they have done that. And at a high level, and I quote, "Our benchmarking indicated that once you've delivered those savings, ICARE looked to be, at a high level, a relatively efficiently run organisation." Would you have any reason to question that conclusion by the Secretary?
No, I think that's what the Secretary of Treasury should do. So I don't have any question about that.
Well, he would say that, wouldn't he?
Now, in the event that the scheme can't return to, in the event the deficit can't be reduced through a series of non-legislative reforms, McDougall suggested that changes to benefits should only be considered if they are seen to create perverse disincentives to recovery, or if they're placing an unmanageable burden on the scheme. The Victorian government recently introduced a series of workers' compensation reforms. Their advice was that prevention and claims management initiatives alone were not sufficient to address the financial challenges that scheme was facing, which is very similar to the challenges facing the New South Wales scheme. In the event that those non-legislative changes don't restore the scheme to a financially sustainable position, is it prudent for the government to explore legislative reforms, including those to eligibility of benefits under the scheme?
That will be a matter for government, and I don't think I can comment on that, if that's all right. But broadly, if you know, if a scheme will not return to surplus, what I'm hearing you say is you move from a band-aid to surgery, and there's nothing wrong in that. But specifically, though, regarding government policies to this, I'm unable to comment on that.
Well, the committee has received evidence that the single element or driver that's causing the greatest deterioration to the Treasury managed fund and a nominal insurer is, and I quote, the trend of ever rising whole person impairment assessments combined with the rising number of new psychological claims coming into the scheme. That is the single element or driver causing the greatest deterioration. The committee has also received evidence that while improvements to return to work rates, improvements to claims management processes are obviously welcome, compared to the multi-billion-dollar challenges facing the scheme, those savings are helpful but not game changers. Will you be looking at that in your review?
Yes, we will. And again, just even the reports that I quoted on the mental health and well-being of police officers, part of what we'll be looking at is some of the root cause analysis. Because if you look at the psychological injuries, that has suddenly increased significantly. I think if you get to the bottom of it and the root cause of it, it's a significant thing that needs to be done. Otherwise, and also, I was also looking at the evidence, and some of the confidence people have on the PR. Now you mentioned some of the, the psychological injuries. If we don't have trust in how accurate, some of these things are, these are the things we need to look at. It's a broad, spectrum of issues in this complex area. So that's why I'm actually also, again, looking forward to your report, actually, because it's complex, it's important, and we need to get it right. And that's why we are looking at this also very seriously and looking at the evidence here and making sure that when we scope our audit, we don't go light, we go deep into what the issues are.
Thank you very much. That does conclude our time. Thank you very much, Mr. Oyotunji and Ms. Harwood, for attending today. We do enjoy, as a committee, working with you and your team, so thank you very much for making yourselves available again. To the extent there were questions taken on notice or any supplementary questions, the committee secretariat will be in touch, but that concludes this session. Thank you.
Thank you very much. Thank you.
Thank you so much. I now welcome our next panel of witnesses. Some of you have appeared before. I thank you again for that appearance and for coming again today. Those of you who have appeared before do not need to be sworn again, but for those of you who are new to our hearing, I will ask each of you. If I could start with Mrs. Kalkaludis. Sorry, I probably said that completely wrongly.
That's okay.
Please correct me. If you could state your name and position title and then swear either the oath or the affirmation.
Yes, Sonia Kakalaitis, Head of Workers Insurance Claims and Contracts, GIO.
Thank you. And then either the oath or the affirmation.
I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you, Mrs. Kakalaitis. And then I've got Mr. Rodwell.
Thank you. Matthew Rodwell, General Manager, EML TMF. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you very much. And Mr. Nicholson.
Yeah, Pete Nicholson, I'm the CEO of Gallagher Bassett in Australia. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you. Mr. Newbury.
Josh Newberry, Acting Executive General Manager, New South Wales and South Australia. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Finally, Dr. Alsop.
Thank you. Nick Alsop, Chief Reserving Actuary, Australia Pacific at QBE. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. Would any of you like to make a short opening statement? If so, I will start sort of over this side on my left.
Yes, I would. Thank you. Thank you, Chair. I appreciate the opportunity to make a short statement and for inviting us again to participate in the hearing. GIO has been operating the New South Wales Workers' Compensation Scheme since 1927. As part of the Suncorp Group, we are the largest personal injury insurer in Australia. We operate in all privately underwritten schemes across Australia via the CTP and Workers' Compensation schemes. On a personal note, I have been privileged to contribute to the New South Wales scheme for the past 21 years, having joined GIO in 2004 as a claims advisor. Over the course of my career, I have remained dedicated to supporting injured workers and employees across New South Wales, progressing to now lead the New South Wales business. My entire professional journey has been shaped by a commitment to this scheme and the value it represents. GIO has an extensive experience in every aspect of claims management. Our expertise ranges from handling the most intricate and long-term claims within the scheme to efficiently managing short-term return-to-work cases and medical-only claims. Our role as a claims service provider is to deliver fair and sustainable return-to-work outcomes for the scheme, to assist injured workers back to work and back to life. As part of the New South Wales Workers' Compensation Scheme, GIO has contributed to arguably the two biggest scheme changes, the 2012 reforms and the largest transition of open claims and finalised claims in 2017. The 2012 reforms brought major changes to New South Wales Workers' Compensation. GIO quickly adapted, guiding stakeholders through the transition while keeping fair and sustainable outcomes. This showcased our reliability and ability to thrive in legislative change. In 2017, GIO proved its agility, swiftly taking in over 25,000 open tail claims and maintaining strong performance throughout the rapid transition. This highlighted GIO's reputation as a reliable partner for iCare and showcasing its capability to manage large-scale complex programs of work. The scale of GIO and Suncorp means we can leverage our extensive experience in personal injury to ensure we are at the forefront of best claims management practices. We are committed to administering the legislation to the workers and employees of New South Wales and here to assist the committee in delivering better outcomes for all those who may need to access workers' compensation or interact with the scheme. We thank you for your time and are happy to answer any questions you may have.
Thank you. EML.
EML would reiterate its opening statement from the 17th of June, Chair.
Thank you very much. Allianz.
Likewise, Chair, we reiterate our previous opening statement.
Great. And Gallagher Bassett.
No opening statement from us, thank you.
Excellent. And QBE.
No opening statement from us either, thank you.
Fabulous. Short and sweet. So we will now start with questions from the opposition.
Thank you very much for all coming back. there's been a fairly significant focus on claims providers and claims managers. Can I just start by potentially going through each of you and asking, in terms of assessing work capacity, under section 44B, there is a work capacity assessment which is obliged to be done. Generally, when is that work capacity assessment done? Can we start on the left?
Yes, I'll answer that question. Thank you. Any time a work capacity decision can be made, we assess it on an ongoing basis. But essentially, if we have the evidence to make a work capacity decision and the time is right, we do that.
So when, generally, do you monitor the data as to when a work capacity assessment would be made?
Yes, we do. So if a certificate warrants and there is a capacity to work, we undertake a number of assessments to determine that.
So, again, just returning to the question, when, in terms of the time from the initiation of the claim to the first work capacity, do you have any data which says the average time for doing a work capacity test?
No. We do it when it's when the evidence is there.
Well, what's that evidence?
A certificate of capacity where the evidence is that that person can work.
Where do you get that from?
The doctor. So that's a nominated treating doctor. So if they say they have evidence, we might get an independent medical assessment that says that the person has the capacity to work. Clinical notes, we might receive information from a physiotherapist that the person has capacity, and we might then test that capacity with the doctor, particularly if the person is unfit, and we determine through the process that they have capacity, well then we will undertake that test.
Do you ever test the assumptions relating to these certificates which are provided to you?
Yeah, if we have a number of parties that suggest otherwise, that the person has capacity, yes, we undertake that work capacity decision or test.
Does anyone else disagree or want to make some other observations in relation to the manner in which, or the timing in respect of which, work capacity tests are undertaken?
From an EML perspective, Mr Tudor Hope, during FY25, EML undertook between 400 and 450 work capacity assessments per month. 64% of those 400 to 450 a month were undertaken 0 to 78 weeks, and there's obviously a legislative requirement that every claim at 130 weeks has had a work capacity assessment completed as part of the Section 38 process.
But you can do that more often, can't you?
Absolutely you can.
Do you?
Yes, we do. Between 2 and 2.5% of the claims in receipt of weekly benefits each month are in.
So how many would be done within the first 28 days?
I would suggest very few within the first 28 days.
Anyone else want to make? One of the observations which is made is in respect by the Bar Association is relating to rehabilitation consultants and the fees paid to rehabilitation consultants. And I'll start with EML this time, so they can make. Do you have a panel of rehabilitation consultants which you use?
No, we don't, Mr Tudor Hope. The panel is managed by iCare.
So in respect of the fees payable to those rehabilitation consultants,
the hourly rate is set by iCare as part of the contractual arrangements they have with rehabilitation service providers.
And do you ever raise concerns about the quality of those rehabilitation consultants?
At an individual level, if there's a particular matter, yes, through our provider services manager would raise that with the particular firm. We equally meet with those providers on a quarterly basis as well to discuss performance and trends.
One of the observations, in fact, made by the Bar Association was this. One is the use of so-called vocational capacity reports. It is understood that these reports cost some $3,000 to $5,000 each. They are produced by what has become a small industry of consultants who are paid the report fees by insurers and scheme agents. the report fees are then included in the claim costs for the worker in question. And then there is a significant criticism by the Bar Association in relation to the capability of those vocational capacity reports that are produced. Do you want to make any observation in relation to that?
I have read the Bar submission. I have formed a view that they have conflated an earning capacity assessment undertaken for the purposes of a WID matter with a vocational assessment undertaken for the purposes of a work capacity assessment, particularly with a reference to the figures in terms of the cost of the report. A vocational assessment for the purposes of a work capacity assessment would be in the order of between about $1,600 and $2,000, and supported by a labour market assessment, which last time I understood is between about $800 and $900 from there.
Does your contract with iCare have any key performance indicators you're required to meet?
Yes, it does.
What are the return to work rates set for psychological injuries in your contract?
There's not a specific psychological injury return to work rate set. I think we covered this ground on the 17th of June. It's a mix adjusted based on individual portfolio size, type of injury, the 40 different individual characteristics that a claim can be bucketed into, then determines the target against which we are assessed.
In relation to those targets which have been assessed to you, are you meeting those targets for psychological injuries?
The target rolls up to a whole. The 40 different buckets roll up to a single target, which is the focus from a contract perspective, Mr. Tudor.
Well, would you object to a contract being framed in terms of meeting targets in relation to psychological injuries?
Happy to enter into any sort of commercial negotiation with iCare around targets, Mr. Tudor.
Well, you'd be happy to, in fact, have targets set by iCare in respect of your performance and continuing operation as a claims manager for psychological injuries?
Yes, if that was the direction that the scheme wished to take.
Can I ask you in relation to Section 11A, how many claims are defended in respect of reasonable management action tests by EML?
Not very many at all.
Why?
As covered on the 17th of June, there's been 3 key precedent decisions in the last 12 years. There's significantly shifted away from the legislation as stated to a common person interpretation around what is or isn't an accepted psychological injury claim.
So you would welcome an amendment to 11A to give more flexibility in relation to employers to be able to defend claims on the basis of reasonable management action?
I believe that EML believe that there is a need for legislative amendment, in particularly where you now have someone's perception of events being compensable.
Does anyone else want to make any observation in relation to the reasonable management action? So none of you have a view about whether, for example, employers, lawyers ought to be able to be outsourced for the purposes of bringing those reasonable management action plans, action defences?
Mr. Tudor, from a Allianz perspective, I think that's, I'd agree with what Mr. Vickers has said. We feel that 11A is used as appropriate, and there's evidence that's gathered to determine whether reasonable management action has been taken. That involves a number of different parties, so it's not just the employer. It also looks at the worker's perspective as well, the medical evidence that's received. So we feel there's an opportunity for review, but I think we gather sufficient evidence currently.
Well, would you agree that the current framing of Section 11A provides for the reasonable management action to be the predominant cause of the injury. What would you say if, in fact, the wording was changed to a significant?
I think
would that change the potential, the outlook in relation to the interpretation of that section?
It could do, Mr. Tudor, based on the interpretation of what's significant.
Well, that's true, but would you agree that significant is...
It does clarify.
It would clarify the opportunity for employers to be able to have more say in relation to what they had done and investigate what they had done in relation to a particular psychological injury?
Yeah, depending what the overall wording is, yes, it certainly could.
Does anyone else have a view in relation to...
I'd add to that, Mr. Tudor Hope, that the definition doesn't stop the investigation to determine whether or not liability exists for a claim. Claims are not simply being accepted. In fact, that comes through in a number of the submissions to this inquiry, that people have been asked to retell their story. People feel that they are not simply being believed from there. Whether significant is a stronger word than predominant is probably then, if that was to be the change, would be something that would be tested in the Personal Injury Commission. I'd suggest very, very quickly to obtain a precedent basis of the word.
Well, there are decisions of the Personal Injury Commission, in fact, which have in fact relied on the word predominant in respect of an 11A defence, where the word predominant itself was used for the purposes of excluding reasonable management action. Would you agree with that?
I'd then come back to the challenge of particularly Hamad and Q catering, and the fact that you then, in terms of waterfalling your case management decision making, first you establish workers, second you establish that there's an injury, thirdly that the workplace is a substantial contributing factor to that injury, and then you move to 11A.
A substantial or predominant?
That was, so you'd need to, if you were to address 11A with predominant, you need to come past 9A with substantial, which isn't a change that I've seen noted in the draft or the proposed amendments, because then work would be a substantial contributing factor still. You're then coming to, or was it predominantly caused by, or significantly, whatever word you would like to have in 11A, whether it was caused by that word from there, but while you still have perception within the current framework, the injury would still have occurred, you would still require the medical evidence, and that the individual who has submitted the claim has still got a mental injury or illness from the workplace.
Can I just ask you this? Can you take me through a timeline of how you would deal with an injury once notified? What's the process which EML adopts? And perhaps this is a flow chart that you have, and it may vary from claim to claim, but generally there would be key markers which you would identify for the purposes of dealing with claims. Are you able to provide that sort of flow chart? And if so, perhaps on notice the other insurers can provide us with similar flow charts for the manner in which they say are the key markers for dealing with claims.
Absolutely.
So perhaps take that. You can do that now, and then the others can do it.
No worries at all, Mr. Tudor Hope. So obviously the claim is first lodged. Within the first 3 days of it being a significant injury, which a claim of the nature that we're talking about would be significant injury by legislative definition, you're required to complete your 3-point contacts, so your contact with the worker, contact with the employer, contact with the nominated treating doctor if that's required to clarify any information. By day 7, you're required to have determined your first liability step in terms of your provisional liability period. If your in a normal course of events, that could see the claim accepted on that day 7. Alternatively, you'd make a decision that you need to obtain further information, be it medical or factual investigation from there. If a reasonable excuse is applied for a claim, you have 21 days from receipt of a claim form to have determined your final liability decision. Provisional liability period can run for up to 12 weeks of weekly benefits or $10,000 of medical benefits. I'm not going to sit here and ask for a return of a claim form. I know that's been raised in previous inquiries, but the concept of date claim made is one that is challenging as to it becomes an individual test as to whether you've got enough information to make a decision on liability for a claim. At present, a claim form at least gave you a marker. From there, you've got 21 days from date claim made to have executed your formal liability decision and move forward with, in most majority of cases where a claim's accepted, move forward with helping someone get their life back and returning to work after injury or illness.
I don't know how to put this gently, so let me just say it. Every time SIRA conducts an audit of your collective and individual performance as claims managers, the results are not particularly impressive. When I look at the July 2023 SIRA audit, they found that collectively you breached your legislative obligations 40% of the time in determining subsequent liability decisions. In more than a quarter of cases, you failed to consider all information available when making an initial liability decision. It found that in almost 50% of cases, you failed to provide all relevant details in your written advice to workers and employers regarding the liability decision. And it found in more than 50% of cases where reasonable excuse or provisional liability decision was made, you failed to proactively follow up to obtain the information you claimed you required in order to make a liability decision. SIRA completed another audit of your performance in December 2024. We're expecting that release imminently. Should we expect more of the same poor performance? Who wants to take that?
Chair, on Allianz's behalf, the last published SIRA review actually found that on balance, Allianz's claims management of both psychological and non-psychological injuries was positive, and actually felt that the way that we were managing claims was proactive on balance. There were definitely opportunities for improvement, as there always is in a claims environment, but overall it wasn't a damning report, certainly from an Allianz perspective.
What we've heard from the Auditor General and from the Auditor General, the predecessor to the Auditor General we just heard from in the report on claims management, is that even the slightest decrease in return to work rates can have a really significant impact on the financial viability of the scheme for years and years to come. Do you accept that the statements made by SIRA in that report that non-adherence to the legislated timeframe for liability decision can lead to a delay in the injured worker being paid their weekly entitlements and is associated with higher incidents of anxiety, depression and poorer return to work outcomes? If you agree with that statement, are you not, I guess, a little sheepish about the performance that you collectively have when it comes to performing your legislated obligations?
Chair, I think that there's a number of different factors that need to be taken into consideration when we're gathering the evidence in terms of making a determination on whether it's liability assessment or treatment acceptance. Certainly there's times where our claim staff don't act on time, but the majority, they are also measured. We have internal KPIs to make sure decisions are made in a timely manner. Because we do recognise there is an impact on the worker if there is a delay in us making a decision, whether it's a positive or negative decision, and also the linkage to payments. So we acknowledge that there is, or we accept there is a connection there. I don't, and there's obviously a linkage to return to work. And our aim, as I'd like to think my colleagues is the same, is if we can establish a position of trust with the worker from the time the claim is received, that actually makes it a more conducive arrangement, not adversarial, to helping with the return to work process. Part of that is not making a delayed decision and not delaying payment, because there are factors that negatively impact on potentially the outcome of the claim.
Sorry,
please go.
I would agree with that. There are instances, of course, with personal injury management that claims advisors might have a delayed decision, but there's many factors in that in collecting evidence from the injured worker and other parties to make that decision. So I would think with GIO internally, we monitor KPIs very heavily around meeting the legislative requirements, and we have a high percentage of that, and certainly would see an improvement from 2023. But we agree with Allianz on this.
Yeah, significant improvement since December 24.
So you think that's what the SIRA report will say when it comes out?
Yes.
SIRA found multiple instances of claims where the CSP failed to take into consideration all the information to make a liability decision. It found multiple claims where determination of provisional liability was made despite there being no outstanding information identified to deter it from accepting full liability. You know, the list goes on in terms of these sort of poor claims management practices. And the comment was made by SIRA that this directly relates and directly impacts on return to work rates. Given that, you know, if you're all sitting here and the return to work rates were improving, perhaps we could accept that we think that claims management is also improving and we're back on the right track. But it paints this picture of claims management being directly responsible for the deterioration of the scheme that psychologically injured workers are now being asked to bear the brunt of. What is your response to that? And to the, I guess I'm saying to you that I think that we should be really focusing on claims management and improving return to work rates in order to bring this scheme back into some form of financial stability. What do you get some sort of, I guess, is there any financial penalty when you don't meet these performance standards? What kind of comfort can you give the committee that you are on the right track to improving your performance?
Thank you. There is penalties, Chair. As Sonia said, we monitor it closely internally in relation to our quality audit, ensuring that we're making decisions quickly, that we have the information as quickly as we can on file, so that we're not impacting return to work rates, or those individuals in contributing to a mental health injury.
So I understand that there can be penalties, but has iCare, have you actually felt the impact of any kind of financial penalty for poor performance?
Chair, there's built into our remuneration, it means we don't get paid. So,
okay, but has that happened?
Yes, it has. Yes. Nobody is achieving, that I'm aware of anyway, the maximum available remuneration where they're not meeting their targets for return to work.
Okay.
So...
but it's a structured remuneration sort of agreement, as I understand it, where there are multiple layers. So it's not like you're not getting paid.
The contract has the ability to not get paid if you're performing poorly enough.
But has that happened?
Pleasingly, EML have continued to improve quarter on quarter in terms of their performance, and it's publicly available on the iCare website, and indeed the SIRA recovery through work data that sits on their website.
I think I might follow up the specifics on notice. Sorry, go ahead.
No, sorry. For GIO, building capability is a mainstay and a priority internally, and has been for many years from 2017. So we're very well aware that there's many staff within the business. They're all individuals, they're all people, they make mistakes, but building capability and monitoring that internally is a priority, and having great culture internally to allow them to do this difficult job. So yes, there are KPIs that monitor this by iCare, and internally we monitor very closely. And yes, there are penalties if you don't meet certain areas. For the GIO, our performance is improving also over the last year.
I'll turn to Mr. Latham.
Thank you, Chair, and thank you to the various witnesses we have. And in particular, can I just say how absolutely thrilled and excited I am that the great Matthew Rodwell is on the panel as a St George Dragons fan since 1970. It's fantastic to have someone who was the Dalian Player of the Year, a rookie, at the Newcastle Knights, then went to the first Perth team, the great St George team in the late 90s, the Panthers, so successful today, and then on to England, and then CEO of the Players Association. So, Matthew, I am now suffering a psychological injury myself as a Dragons fan, and I hope you can notice some clues for me as to where the wretched joint venture has gone wrong, because I looked up the data just yesterday, and the Dragons, as a standalone club between 1921 and 97, had an over 60% win rate in rugby league, the highest in the league by far, and now we're down in this joint venture to barely 50%. So if you can take that on notice, you'll be doing a lot. Please, I beg you to ease my psychological injury in following the Dragons week in, week out. Now, having said that, let me move on to perhaps a more serious matter, although nothing's more serious than the Dragons, I suppose. What happened, Matthew, when EML lost the Woolworths contract?
First of all, thanks, Mr. Latham, for those kind comments and flattering comments. Thoroughly embarrassed, but turning my attention now, I'm not involved in that part of the EML business. That falls under another side involved with managing self-insurance. So I'm not privy to exactly what occurred in that space that you make reference to.
Right. Do you know when it happened?
Earlier this year is my understanding. The exact dates I'm not certain of.
Right, and perhaps you can take on notice, how many times do you lose these self-insurers? It must be a big contract with Woolworths.
My understanding, it was the most significant contract for EML. Again, I'm not privy to the contractual arrangements in our self-insurance space, so I'll have to take that on notice and defer to other colleagues within EML.
Thank you. And do you know the reaction of Janir Applin at the time in losing this massive contract to DXC?
I had no involvement with Miss Applin in her time at EML during that particular period, so I would not know her reaction.
Right, but it's true that EML lost the massive Woolworths self-insurance contract to DXC.
That's correct. We understand that Woolworths chose to go to DXC, Mr. Latham.
Okay, this is Mr. Vickers, is it?
Yes, it is.
Who did you play for?
I'm a long-suffering St George supporter as well, Mr. Latham. Unfortunately, my ability didn't see me take a football field in any capacity.
I once captained Parramatta under-15s before I decided study was more fruitful and foolishly got into politics. But anyway, you didn't play for anyone, but you seem to have some expertise here. Do you know the reaction of Janir Applin when the Woolworths contract was lost?
No, I don't know the specific reaction of Janir. I know that EML were disappointed to see a contract leave, as I assume everyone on the panel would be if a contract was to choose to take their business to somewhere else.
And are you aware when Janir moved on to be the head of the hapless eye care, DXC was then axed, seemingly with no preamble or adequate explanation, on the 17th of June, losing its eye care business?
I was present when you informed the panel of that decision, yeah. Mr. Latham.
Are you aware of that? Okay. Sorry, I didn't notice. I pay more attention to NRL grades. Can I just say, in that regard, are you aware of reports, very disturbing reports, that Janir Applin then rang Woolworths to say, get that up here? DXC, who you went to, has now lost its eye care business in an act of spite and completely unethical behaviour?
I've not spoken to Miss Applin other than to eye care organised meetings since her departure from EML.
And where is she today?
I don't know, Mr. Latham. She doesn't work at EML anymore.
No, well, this is the second time we've had these inquiries. It'd be nice to see the head of eye care. No further questions. Thanks, Chair.
Thank you, Mr. Latham. I might take up some of your additional time. Thank you. So just back to that, the KPIs and the the performance-based incentives. I know that when we were just talking a moment ago, I understand that there's a base remuneration, there's a couple of other things that sit on top of that. When it comes to how much you're getting paid overall, though, presumably, yeah, can you tell me, if you could just explain to me what you think this penalty is in reality for not having met the KPIs under the scheme? Are you still getting sort of 110% of your costs covered, or sort of where's the profit?
The base fee is not designed to cover 100% of the costs. IQ were very clear about that in 2022. The intent of moving towards a risk-reward based contract. In fact, the base fee goes nowhere near covering AML's operating costs.
I understand it's about 85%, isn't it, or something? And then the additional
I really wish
amount.
it would cover 85%,
Okay.
Ms. Boyd. The next step is around the quality metrics, doing things the way that ICARE would like to see them done to ensure that each worker and each employer sees a consistent experience from the scheme, irrespective of where the claim is managed, and then you move into the performance fees based on return to work predominantly. Approximately 60% of the performance fee pool is based towards front-end performance metrics and 40% towards longer tail claims management.
Okay, so when it comes to return to work, though, I understand that sort of makes 50% of that performance kind of bonus amount, correct me if I'm wrong, but when they're talking about return to work under that metric, it's my understanding that only covers someone going back to work for like an hour. Is that correct? What is the definition of return to work for the purposes of the contract?
For the purposes of the current contract, it's based on work status code, which does mean that a worker can return for an hour, and a positive work status code is applied. That would be an 02 if they're at their same employer, or an 04 if they're a different employer, in terms of the hierarchy of code set by SIRA.
And is there a higher, I guess, yeah, so from the perspective of the contract then, are there sort of multiple levels of return to work, or is it just that simple that return to work is based on a sort of a 1 hour back and that's the end of it?
It's the return to work metrics are solely based on work status code.
Understood. Thank you. Government questions?
Thank you, Chair. The Treasury has provided evidence to the Commission that the claims management model is assumed under its modelling to deliver benefits of an average of $450 million a year in avoided costs. Can you provide any insight into how that is proposed to be achieved in the coming years?
From an AML perspective, we haven't seen the modelling or been involved to be able to answer that question, Mr. Nava.
So the evidence provided was that there are going to be a series of changes with respect to administration, operational activities, tailored support for workers, particularly in the psychological injury space, further implementations of recommendations from numerous reviews. Nothing to add?
Not been engaged in conversations about that.
Okay. We've also received advice that that any savings from operational and administrative measures in the scheme, while welcome, aren't going to address the multi-billion-dollar challenges in the TMF and the NI. Could you provide your view on what the greatest contributors are to the deterioration in the scheme, based on claims that have come through the CSP process?
I think from a GIS perspective, it's obviously that the psychological component has increased post-COVID. The landscape pre-COVID to post-COVID is completely different. I don't think there's one answer to that either. I think there's multiple factors that impact the difference that we're seeing now, but the obvious one is definitely psychological claims have increased, and I would think across all CSPs, the volume that are coming in are certainly different pre-COVID to post-COVID.
Anyone else?
from an Allianz perspective, we would agree with a significant increase post-COVID of psychological injuries in the TMF contract, and similarly we've seen an increase in psychological injury in the NI contract as well.
Would you agree with the view that an ever-rising whole person impairment assessments combined with a rising number of new psychological claims coming into the scheme would be a significant contributor, if not the most significant contributor to the scheme's deterioration?
I suggest it is I don't know whether I'm using significant, substantial or otherwise contributing factor to the increase.
Are there any mechanisms within the scheme's structure that are a cause of concern for providers with respect to improving the return to work rates, particularly in the psychological space?
At the previous hearing, we mentioned there's not enough psychologists in the New South Wales scheme, and it's actually a national issue. So I'd probably take a step back and look at the actual assessment process in the first instance to determine, do we have enough people with the appropriate level of qualifications? Do we have enough of those people in the scheme to actually make a valid assessment to determine whether an injury is a valid psychological disorder, psychological injury? So that's one step I'd be looking at the very first step before we even worry about anything else. The other factor we'd look at, and I was going to reference it to a response to a question from the Chair around return to work earlier, is it is a multifactorial issue. It's not just if the claims managers were operating 100% across all the measures, there are still other factors in terms of the role that the employer plays, the role that the worker plays in terms of this is a worker is a whole person, so they do have issues around their connection with the community, the connection with their family, their financial pressures. So there are a number of other factors that come into somebody's willingness or mental ability to actually consider returning to work. So I just hesitate to think this is a very simple thing that the case managers within our businesses would make a significant contribution to improve and return to work in and of ourselves.
Agree, Mark.
Sorry.
I agree.
Any other views?
No, just the same view. And I think it's also, as it might have been identified by Mark already, it's something we see across the nation in terms of the rise post-COVID in psychological injuries. And it's also important to acknowledge that an individual psychological claim is all different, and a lot of what we see is actually interpersonal workplace conflicts, which are very different from complex mental injury that occur in other industries, for example, which are harder to treat, harder to get people back to working, for example. So what I would say is that it's treated very sensitively across the industry. I'll certainly say Gallagher Bassett's people are highly trained and skilled and very empathetic and attuned to what's going to be helpful to that poor individual that's gone to work one day and come out with an injury. But it's difficult. It's a difficult job to get right 100% of the time, and there's multiple facets in how you might actually work with someone that's experienced some form of psychological injury.
If I could just come back to the avoided costs from claims management that I referred to earlier. So the view is that improving the professional framework for case managers, high quality support earlier in the journey of a claim, keeping people connected to work, getting them back to work more quickly is what will result in those avoided costs. Are you making progress with respect to those metrics? And if so, can you
Yes.
provide some examples of that?
Absolutely. I think if we go back to February 2019, the proportion of AML workforce with 2 years or greater tenure was 16% following the changes that were implemented from the 1st of January 18. At the commencement of this contract on the 1st of January 2023, we'd just ticked over 50% of the workforce with greater than 2 years tenure, and very proud to sit here and say it's now 73% have greater than 2 years tenure. There is no substitute for tenure in experience in building capability and competence in a workforce to assist the achievement and strategic planning towards return to work outcomes.
Anyone else?
Just to back up what Matt's saying there, I think, we're in an industry that tends to be in the press only for bad reasons, when actually, if you look at our workforces, they are so motivated by helping people. And I think it's really important to say that outright, because I'm not saying that just on behalf of our organisation, but everyone else here. What they do in each day and how they help people through some really tough times in their lives is really incredible to see. So it has been an industry where it's tough, it's in the press for the wrong reasons, and it's in some ways it can be seen as a thankless task, hence the very high turnover, the stress levels that are on our workforces as well, because of the way in which often it's only the negatives that are focused upon. So similar to EML's experience, our experience and tenure in our operations has increased significantly, and we're also adding a lot of case managers with experience now to help provide even more tailored support for injured people in New South Wales.
Is reduced caseload for each case manager a part of that model?
Yes.
Categorically.
It is.
Absolutely. So from GI's
Yes.
perspective, caseloads are monitored very closely, and it's very key to ensuring that the service is delivered correctly. With empathy, caseload numbers are important. Absolutely.
Does that vary between physical and psychological injury and industry, or are your ratios pretty consistent across
They're
the board?
consistent within GIO.
Okay.
Look, from an Allianz perspective, and I think this is generally the same across all the CSPs, for a psychological injury or a complex physical injury, you'd like to have a lower caseload than you do for somebody who's broken their leg. It's quite simple, they will return to work. So we are mindful that if you're managing especially primary psychological injury or a complex physical injury, you do need to have more time with that worker to help support them through the recovery process. So there is a variation from that perspective, but I think we all have a similar approach.
Correct.
Agree.
And also size of employer can play a role as well, because larger employers would have more sophisticated return to work resources on their side, more suitable alternate duties that people can be deployed into, for example. So if you're dealing with really small employers, you might need to have lower caseloads to spend more time even helping them understand the complex way in which workers' compensation works.
Just with respect to the long-term sustainability of the scheme, there's obviously the question around eligibility for benefits and then duration of benefits. There is an interesting evidence that the committee has received with respect to whole person impairment not being conflated with capacity for work increasingly. Do you see any potential built-in incentives within the scheme that are meaning people are getting entry into the scheme and staying longer in the scheme when they might otherwise have been able to return to work sooner?
I'd articulate it slightly differently in that in a scheme that is driven by if you have capacity, you're no longer entitled to receive weekly benefits. We covered work capacity earlier. Or if you don't meet an impairment threshold, you are no longer entitled to receive benefits. That there are potentially, in a small proportion of cases, a perverse incentive and actors within the scheme that drive claims in a particular direction to achieve an outcome that's not in keeping with the objectives of the Act, which is to return to work.
Does anyone else have a view on that?
The same view. I think it's a small percentage, but it's absolutely there. I think most people actually want to get back to work, and they understand the benefits to themselves from a social, from a psychological perspective. So they're doing their best to, by and large, to get back.
Agree.
Notwithstanding, it might be a very small minority, and I accept that it would be, given the complexity in diagnosis around psychological injury, it's not getting a scan and identifying a broken arm and having a rehabilitation plan in place, but it is multifaceted, it is increasingly complex. Are there concerns with respect to nominated treating doctors perhaps being overly restrictive in their assessment of an individual's capacity to work, potentially then colliding with the WPI thresholds where they are resulting in people entering the scheme and staying in the scheme to their own detriment?
The PERS scale we covered on the 17th is largely based on an evidence interview between a consultant psychiatrist and the worker that
at a single point in time.
At a single point in time, and to capacity, or the category I'd refer to within the PERS scale is employability. The PERS scale asks, can that person work again within the next 12 months and the next 12 months only? Out of the hearing last time, the ML went away and we considered how do we obtain some evidence to deal with the statements that were being made around the ability to work again post 21% whole person impairment, and we ran a survey. So we identified that we had 226 workers who had a psychological whole person impairment claim of 21% to 30% being within the band of what was being spoken about, and that they had received a work injury damages claim, so a financial settlement. A couple of the other witnesses had spoken to, I'll use the term financial justice, and I apologise if I've used a wrong term to them. And so we went forth and tried to contact these 226 workers who'd had a resolved claim, and were successful in making contact with 167 of the 226, and pleasingly 73 agreed to participate in the survey that we had, and we asked them whether they'd returned to work, if they hadn't returned to work, whether they had an intention of returning to work, and whether there was anything else immediately following the settlement of the claim that they would like to have seen the scheme provide. Of those 73, 22 had already returned to work. 24 indicated a desire in finding work or returning to work at some point in time thereafter, and 46 of the 73, and 27 of the 73 expressed no intention or desire to return to work. Those 27 had an average age of 53, a median age of about 54, and had received an average WID settlement size of $432,000 from there. So there may be other reasons that there was no desire for those individuals to return to work, but it was interesting to learn that some had returned to work as soon as within 6 months of their WID claim resolving from there.
Are you proposing to publish those survey results?
I provided the briefing note to iCare on Friday the 18th of July.
Okay, thank you.
Thank you very much. That does end our session with you today. Thank you again for coming and answering our questions. I know it's not always easy, but it's really important evidence for this inquiry. To the extent there are questions taken on notice or there will be supplementary questions, the Committee Secretary will be in touch. But that concludes our session for now. We're going to take a short tea break. We'll be back at 11 o'clock. Thank you.
Thanks, Chair.
put the broadcast back on. Fantastic. Thank you. We are now back. Thank you to our next panel of witnesses. I believe that you all do need to be sworn in. You've not appeared before this particular inquiry before. So if I could start from my left, if you could please state your name and position title and then swear either the oath or the affirmation.
Yes, my name's Hilbert Chew. I'm a representative of the New South Wales Bar Association. I'll take an affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
David Hook. I'm the chair of the Bar Association's Common Law Committee. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Thank you.
My name is Richard DeBabner. I'm a partner at Turner Freeman and I'm here in the capacity as a member of the Injury Compensation Committee on behalf of the Law Society, and I swear an oath. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Thank you.
My name's Tim Concannon. I'm chair of the Injury Compensation Committee of the Law Society, and I'll swear an oath. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Thank you.
My name is Shane Butcher. I'm a partner at Law Partners and I'm here today as the ALA's New South Wales Branch Workers' Compensation Subcommittee Chair. Affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. And Mr. Jones online.
Yes, thank you, Chair. My name is David Jones. I'm a partner at Carroll and O'Day Lawyers. I'm a member of the Australian Lawyers Alliance and a member of its New South Wales subcommittee. I will take an oath. I swear the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you very much. And would anyone like to make a short opening statement? I'll start on my left with the Bar Association.
Yes, thank you, Chair. The Bar Association thanks you for the opportunity to appear before the committee today. We acknowledge the critical work being undertaken by all members and look forward to contributing to the committee's examination of the workers' compensation scheme and its inquiry into the New South Wales Government's Workers' Compensation Legislation Amendment Bill. Members of the Bar Association provide legal representation and support to all parties affected by the New South Wales Workers' Compensation System, including workers, employers and insurers. Among the Bar Association's Common Law Committee, which Mr Chew and I have the privilege of leading, our members have many decades of experience and expertise relevant to this inquiry. Could I start by saying that it ought not need to be said in 2025 that a comprehensive system of workers' compensation is one of the hallmarks of an advanced and civilised society. It is integral to such a society that it protect and provide for its most vulnerable members. The submissions of the Australian Lawyers Alliance at paragraph 4 direct attention to the objectives set out in section 3 of the 1998 Act that forms part of this scheme. When one has regard to those objectives, it's quite alarming that a worker who was injured 100 years ago had more valuable and secure rights than a worker injured today, and all the more so under the proposed amendments to be wrought by the bill being considered by the committee. The Association acknowledges that the scheme can and should be more cost efficient. Our written submission to the committee sets out a number of ways of improving the scheme's efficiency without impinging on the rights of injured workers. If the committee is of the view that these measures are insufficient to address the sustainability of the scheme, then the Association recommends that it consider potential amendments to the bill's definition of bullying at Section 8, capital A of the bill. We would welcome the opportunity to discuss some of these measures at this morning's hearing. Stakeholders and the wider community continue to be working at a significant disadvantage when considering potential measures to improve the viability of the scheme. Many stakeholders, including our association, have consistently called for the government to release meaningful data and actuarial modelling to transparently understand and address the purported financial problems faced by the scheme, as well as the projected savings from the proposed reforms by reference to the assumptions underlying the modelling. This has not occurred. Without this information, experts and stakeholders are hamstrung in their ability to work constructively with government and with this committee to test whether the financial impacts of the proposed reforms really justify their considerable detriment to workers, or to develop alternative solutions for the true improvement of the scheme. That said, the Bar Association has undertaken a close analysis of the bill, provision by provision, to understand its effect on workers, employers, insurers and the scheme more generally. The fine detail has been set out in our written submissions. Based on this examination, we make the following introductory comments. First, this committee and the Standing Committee on Law and Justice before it has received a substantial body of evidence about the devastating impact that this bill will have on those who suffer a psychological injury at work. The bill substantially reduces the rights of injured workers to receive benefits for medical treatment for their injuries and to receive weekly payments while they are out of work due to those injuries, by imposing arbitrary caps on the duration of these benefits. These and other reductions in rights are primarily directed to workers with psychological injuries, but the proposed changes, such as those that go to the mechanism for assessing claims, are likely to adversely impact all injured workers. Many of these provisions are cruel, unjustifiable and should not be supported by this committee. Secondly, according to this bill, those who suffer a psychological injury at work are less worthy of care, support and compensation than those who suffer a physical injury. This is despite what we've learned over many years about the devastating lifelong impacts that conditions like PTSD can have on individuals. Again, this should not have to be said in 2025. However, this bill demands that it be repeated. Psychological injuries are just as real as physical injuries. Treating them differently, as this bill does, is illogical and not only serves to perpetuate the stigma that those who suffer psychological injuries are somehow less worthy of our care and support. Thirdly, the New South Wales Government has consistently told us that its priority is preventing psychological injuries in the workplace. If that is the case, then it is appropriate to enact improvements to workplace safety, including the government's recent industrial relations reforms and the proposals contained in the Bar Association's written submissions, before considering drastic cuts to workers' entitlements. These workplace and industrial relations reforms should be given sufficient time to operate and then be measured to see if they result in safer workplaces, which in turn drive down the number of workers' compensation claims. Cuts to workers' entitlements should only be considered as a last resort. Fourthly, among the various cuts proposed by this bill, the most egregious are those that erode the fundamental rights of any modern workers' compensation system, those being medical payments and weekly benefits that allow for injured workers to live with dignity. By introducing new time limits and threshold requirements, as I've said, a worker injured 100 years ago will have had substantially superior rights compared with a worker who seeks support under this proposed remake of the scheme. This will devastate those who have already been profoundly disabled by psychological injuries, It will make it harder for injured people to return to work, and it will shift significant costs onto an already overburdened public health system. Fifthly, as well as removing substantive rights from injured workers, this bill creates unnecessary and avoidable complexity within the two principal acts which establish and regulate the workers' compensation scheme, generates an untenable conflict of interest for the State Insurance Regulatory Authority by placing it in the position of both regulator and umpire, strips the Independent Review Office of much of its independence, reduces parliamentary oversight of the system, and creates further inefficiencies across the scheme which will only increase costs. For all these reasons, the Bar Association does not support the Workers' Compensation Legislation Amendment Bill. We've engaged in good faith with the content of this bill and suggested significant amendments to reform its operation, which are comprehensively outlined in our written submission. However, and fundamentally, we believe that there are better and fairer ways to reduce costs to the workers' compensation scheme without radically reducing the rights and entitlements of injured workers. As explained in our written submission, lasting reform of the current scheme is required. But this is a task that must involve at least a thorough examination of the objectives of workers' compensation in a changing workforce, the true problems and inefficiencies in the operations of the current scheme, of which we have identified some, and perhaps a complete rewrite of the existing legislation. It is not something to be rushed. Thank you, Chair.
Thank you. Law Society, did you have a...
Thank you, Chair. Yes. Thank you for inviting the Law Society to give evidence at today's hearing. I'm here in my capacity as Chair of the Law Society's Injury Compensation Committee. I'm joined by Richard Dababner, a member of the Law Society's Injury Compensation Committee. Our members who represent claimants, insurers and employers recognise that reform of the New South Wales workers' compensation legislation is overdue and understand the importance of ensuring a scheme that is financially sustainable and safeguarded against potential abuse. In our view, the bill fails to achieve the intended objectives of this reform and should not proceed. We suggest that the proposed reforms are likely to prevent injured persons from accessing treatment, rehabilitation and appropriate compensation and having their claims professionally represented. We remain deeply concerned that the proposed changes, particularly the 31% whole person impairment threshold, would effectively preclude most individuals who experience a workplace psychological injury in New South Wales from accessing appropriate compensation and support. We suggest that rather than relying on a significant reduction to whole person impairment as the only way to address concerns around the financial sustainability of the scheme, a more nuanced approach is required, including a focus on improving claim management processes for persons who have sustained a psychological injury at work. The Law Society emphasises that the changes in the bill are not limited to psychological injury claims, but have wide-reaching implications for the broader scheme. Our submission addresses issues such as the joint principal assessment process, which, in our view, will increase disputes and discourage settlement. Similarly, the Law Society encourages the introduction of broader commutation provisions than those proposed in the bill, noting that such voluntary arrangements can benefit individual workers and the scheme as a whole by achieving closure of claims with high administrative costs. Further, we urge the committee to reconsider the proposed funding changes to the Independent Legal Assistance and Review Service, known as ILARS, which risks undervaluing the essential role of lawyers in supporting the efficient operation of the scheme and assisting injured workers to access justice. We welcome the committee's inquiry into the bill and the opportunity to appear today. We do regret the insufficient legislative process, including limited consultation preceding the bill's introduction, particularly given the significance and scope of the proposed reforms. Our preference is for the government not to proceed with the bill and return to a genuine consultation and design phase, one that enables a wholesale revision of the scheme, simplifies the statutory framework and better reflects the needs of injured persons in modern workplaces, including through appropriate claims management processes. Thank you again for the opportunity to appear before the committee today.
Thank you. And Mr. Butcher.
Yes, thank you, Chair. I'd also like to thank all members of the committee for inviting the Australian Lawyers Alliance, the ALA, to appear at today's public hearing. I'd like to acknowledge the traditional owners of the lands on which this public hearing is taking place today, the Gadigal people of the Eora Nation. I pay my respects to the elders past and present and to any Aboriginal and Torres Strait Islander peoples taking part in today's public hearing. The ALA is a national association whose members are dedicated to protecting and promoting access to justice and equality before the law for all individuals. Our members and staff advocate for reforms to legislation, regulations and statutory schemes to achieve fair outcomes for those who have been injured, abused or discriminated against. The government put forward these amendments with dire warnings on the financial position of the New South Wales Workers' Compensation Scheme, with call for urgent action to prevent the scheme from collapsing. The evidence before this committee and the Standing Committee on Law and Justice do not support those claims. The case for urgency has not been made out. What everyone can agree on is that the system is failing injured workers, and in particular, those that have psychological injuries. It is our view that poor case management is at the heart of many of these failings. We believe that with a renewed focus on improvements that can be made in the management of claims, the scheme can ensure that early treatment is provided, return to work rates are improved, and the costs of the scheme are reined in to levels that will continue to make the scheme sustainable and achieve the objects of the scheme in providing fair compensation to both psychologically and physically injured workers. A 6 to 12 month review of the case management systems of insurers should be ordered, with a focus on return to work outcomes and compliance with the current provisions of the legislative framework. There is evidence before this inquiry that would support the conclusion that insurers and scheme agents are failing on both fronts. We must come to an understanding of why this is to provide appropriate solutions. The insurers have not yet come forth with a sound explanation or identifying barriers preventing them from being able to reduce claim expenses or return people to work. The solution has been put forth to cut benefits to workers who many would consider vulnerable to long-term incapacity to work without early support and treatment of the scheme. The people of New South Wales should not sit idly by and accept wholesale attack on benefits to injured workers whilst other options remain viable. If the scheme reform must be made, it's our view that it would be sufficient to introduce appropriate relevant event tests along with appropriate definitions. Coupled with the review on case management, this should provide immediate forecasting savings as well as provide sufficient time to see the improvements that can be made before having to consider substantial attack on benefits. Thank you again for the opportunity for the ALA to appear before this public hearing. I'm happy to answer questions from the committee.
Thank you very much. On that basis, and I will just check that Mr. Jones doesn't have anything additional.
No, I don't.
No. Okay, great. On that basis, I'll turn to the opposition.
Thank you. Each of you has indicated concern in terms of the manner in which case managers manage claims, and that before embarking upon wholesale changes, as has been identified, we should be doing some review in relation to the manner in which claims are being managed. If I can start with the Bar Association, what do you say are the chief problems which exist in relation to the manner in which claims managers are currently managing claims?
Thank you for the question. The question's probably one more directly addressed to the Law Society and the ALA, but the association has made the observation that one of the difficulties with claim management in the current atmosphere is that there seems to be a disproportionate deployment of resources in fighting claims rather than meeting them. There are examples in some of the submissions before the committee already from workers and from other sources. And indeed there was a media report only this morning of a case study involving the deployment of $85,000 in costs in resisting a $5,000 claim for surgery. Now, one would think that on any view that is an unhealthy state of claims management to have in operation in a scheme such as this, and it self-evidently demonstrates where a lot of waste is occurring and a lot of unnecessary cost is being incurred.
Law Society, like to comment?
We would say that one of the issues is the high turnover of claims managers. The decisions themselves, I don't think adequately deal with the concept of work capacity decisions anymore in any regular manner, which was foreseen to have been the role of claims managers under the 2012 scheme. We would say, I think, that it's not just the claims management processes, but those directives given by ICARE to the claims managers as to how they're to operate in a given scenario, these so-called operational instructions. Or
do you have any evidence of that?
We hear about that on a regular basis from those acting on the other side. Regrettably, we act on for workers in these claims, the three solicitors who appear before us. So we don't directly see these operational directives, but we do hear this complaint being made on a regular basis.
Mr. Butcher?
I agree with the comments made. I agree that I'm not in a position to speak about directives given by ICARE. The Australian Lawyers Alliance is comprised entirely of people who represent injured workers, and as such we don't take instructions from insurers and see those directives. What we do hear is from our clients is stories of constant changeover of case managers, constant being ignored in terms of their requirements and their needs, disputes being managed. I think one was touched upon earlier. But if you look at the whole picture, what we do see is people not being returned to work in appropriate timeframes. There are submissions before this inquiry, at least one of a worker who's fit for duties, willing to work but not being provided any suitable duties by a government department. I think there was a submission by Roshana May that there was pointing to evidence that there was 3,500 workers with capacity in the government that haven't been able to be placed in employment. All those things contributed to cost of the schemes. And
you made some observation in relation to capacity for work tests done at an earlier date. Are you supportive of that as an appropriate return to work structure?
We are supportive of appropriate work capacities tests and assessments being done. If an employee has capacity to return to work and they can, then they should.
I noticed the Bar Association also makes observations in relation to vocational programs, which are often paid for by the insurers as potentially not fit for purpose in terms of the expenditure by insurers on claims, which could in fact be better used. Have you got more observations to make in relation to that?
Yes, in the sense that they often tend to be a fairly blunt instrument and they lack much nuance in terms of actually being targeted at getting a particular worker back to work as opposed to going through a formulaic process. The other observation we'd make about vocational assessments flows on from the ALA's submission about return to work or work capacity assessments, which were originally designed to be undertaken by a claims manager using publicly available data and the medical data available in relation to a particular worker, and the application of the two to the statutory test. But it seems to have devolved into a system where whenever a work capacity decision comes to be made, rather than the claims manager actually doing that part of their job, they farm it out to an expensive consultant. and then just adopt the consultant's report as their work capacity decision. And that just imposes a layer of cost of some substance on top of the system of employing claims managers, which was intended to encompass that very task. So it's another example of the overlay of costs in the system that we would see as something to which attention might be directed.
Does anyone else want to comment on that? Can I just ask this? One of the suggestions in relation to various psychological injuries and the potential to make claims in respect of negligence against the employer for those injuries, is it correct that under this Act, under the current Act before the Parliament, that ability to sue for the employer for negligence in relation to the psychological injury will be removed unless there is a whole of person incapacity above 31%?
Yes.
Yes.
So even in circumstances where an employer was negligent in the manner in which they dealt with a racial harassment, sexual harassment or bullying claim, that a claim for negligence could not be made against that employer unless the whole of person impairment was above 31%.
Yes.
That's a massively significant removal of workers' rights. Would you agree?
Absolutely, and indeed one can take it to extremes without being overly rhetorical about it, because the effect of it would be that an employer could have numerous reports of the bullying or harassing conduct, do absolutely nothing about it, have the injury develop, have the injury continue to deteriorate in severity, and have no liability for common law damages unless the WPI was at least 31%.
And I think your observation concluded in your submission that would in fact reduce work health and safety in the workplace.
Indeed, indeed, and it's one of the driving forces of common law rights in the workplace. One of the effects of it, and one of the objectives behind the development of common law rights in the workplace was the reduction of injury and death.
Mr. Buchanan, one of the allegations made is that there is a significant amount of coaching by lawyers in relation to psychological injuries, and in fact that's evidenced by virtue of the fact that there are very few claims between the 11 and 14% whole of person impairment, but then the after 15% there is a significant spike. How do you respond to that allegation?
Well, I just don't think there's any evidence of that at all from what I've seen. I mean, there's a concept known as you can't lead a witness. You can't. I certainly think it's inappropriate sort of to tell a particular claimant this is the way they've got to operate in order to satisfy the requirements of the peers rating scale. And that I think it may be the fact that doctors have worked out themselves based on experience over the period of time since the peers rating scale became applicable. They understand the operations of the scale perhaps better than they did at the outset.
Well, the government...
So there's also another simple explanation as to why you don't see many claims less than 15%, and it's simply because lawyers don't make those claims. There is no entitlement. So if a client of mine was assessed at 14%, we just wouldn't serve that report on an insurer. We wouldn't make the claim, and there'd be no record of that, except through IRO, who paid for the report. But the insurer wouldn't even know of its existence.
Well, the government sought to rely on various advertisements being placed by lawyers offering to I suppose, provide advice to people about how to deal with claims so that they meet the 15% threshold. Have you seen such advertisements, and what would you say in relation to relying on those advertisements?
I would say that if lawyers are doing the wrong thing and not fulfilling their obligations, that there are already regimes in place for those people to be referred, whether it to be the Law Society or the Legal Services Commissioner, for investigation.
So would you take the view, would the Law Society take the view that those sort of advertisements were inappropriate?
Well, we need to. I haven't personally seen any of those advertisements,
one of the other notions which it concerns the government in terms of the increasing financial viability of the scheme is what they identify as threshold creep. And even if you increased the holder person impairment to 21%, there would be this threshold creep that a lot more claims would be over the 21% because, as Mr. Butcher identified, doctors would assess in terms of identifying factors under the PERS scale as bringing workers within that new category. What do you say in respect of the ability of the scheme to be able to deal with threshold creep?
We address that partially in our submission. Prior to 2012, the number of thresholds that were available to be disputed up between insurer and injured worker was minimal. In 2012, we introduced a number of thresholds, and what we've seen is what was described in our submission as sort of discovery of akin to economics, price discovery. Prior to 2012, we wouldn't have a fight about what is the difference between someone who's on 19% or 21% because it simply didn't matter. As you introduce new thresholds, what you do is you're creating a dispute point, and workers, their lawyers, insurers, their lawyers are going to have disputes about that, and we're going to learn the difference between those disputes. And so it's, in my view, it's a scheme evolving, and as long as you introduce new and significant thresholds, you're going to have fights that previously didn't matter, help transition people's knowledge and how to navigate the scheme and get those results.
One of the potential assertions, of course, is that those people who are providing medical reports or psychological reports also seem to be gaming the system. Is there any evidence that psychiatrists, in conjunction potentially with lawyers, are actually gaming the system?
I haven't seen any evidence of that, but as far as the doctors are concerned, I suppose it's a question for them.
Can I start just by asking again? I think all of you made statements that some of the pressures on the scheme could potentially be relieved by improving case management. Are you able to, I guess, all of you have been involved to an extent in previous inquiries and reviews. Is that suggestion new? Is this something that has already been pointed out to various governments over the years? And I guess, are you surprised that the focus is not on that, but instead on cutting people out of the system instead? I'll start with you, Mr. Hook.
I'm not aware personally of whether it's been raised, and I'd be happy to take the question on notice to go back to review that issue. I would say from experience of the current scheme as opposed to earlier iterations of the scheme that I think there's a lot more technicality involved in the current system. There are a lot more decisions that are made by claims managers, and they then, as has been alluded to, create dispute points which end up being argued out in the Personal Injury Commission or in the Supreme Court. So it's perhaps an indirect answer to the question to say that I think there's a lot more involvement of claims management in the creation of disputes than there has been under earlier versions of the legislation and its predecessor.
Interesting. I'll go to you, Mr. Concan, as well, and I guess if I could just add to my earlier question by asking, do you think that the proposals in the government legislation will make those dispute points even will increase the number of dispute points where lawyers would be involved?
Yes, thank you, Chair. The 2023 inquiry into the functioning of the workers' compensation scheme involving Law and Justice from recollection, this issue of claims management was squarely raised in the context of what was, even at that stage, said to be surging numbers and costs of psychological injury claims. I think the Law Society, and from recollection, my friend to my left on behalf of the ALA made this point very clearly, that this problem with surging numbers has a lot to do with claims management practices. And that was in the context of EML having only just very recently stepped out of the role as sole provider under the then workers' compensation scheme. So yes, it's an ongoing issue, and I think what has been helpful since that time is the evidence we heard at the first sitting day of this committee from the insurance brokers, who have a bit more of an insight into those issues relating to operational directives, for instance, because they have involvement from both sides of the fence. So absolutely, it's an ongoing problem. It's a chronic problem, I think, that's recognised by a lot of people I speak to in the workers' compensation field.
So in the interest of time, I might ask you, Mr. Butcher, a slightly different question then. So the Independent Review Office submission points out the percentage of erroneous disputations where a claims manager or insurer has denied a claim that then goes on before the commission and is eventually approved in favour of the worker. And I understand that that's around that sort of 80% mark. Given what we know about the sort of ongoing consequences to workers, to injured workers, where they do incorrectly have their claims denied, do you see that there is room within the claims management framework and the attitude to make significant savings and, I guess, avoid the changes being proposed in this bill?
Absolutely. The success rate, I think, has long been published by IRA of plaintiff lawyers is very high. Conversely, that must mean that the decisions that have been made have either been incorrect or there's been perhaps some negotiation done between the parties. But you must wonder, I suppose, the amount of money that's been spent in cases such as the example raised during the PAR's opening of fighting over $5,000 and spending great enormous sums of money in legal fees and independent medical examinations to do that. I think there's not enough commercial decision making being done by the insurers. They are willing to spend the scheme's money to fight for a position, and the workers should be willing to also fight for the same position. It just turns out that those funded by ILARs tend to have a great level of success.
So as I guess someone who does a lot of work for workers on that sort of worker side of the equation, what is the impact you see in terms of then when someone has their claim unfairly or erroneously denied and they have to go through that process? How does that impact on things like their ability to return to work and that sort of thing?
The two biggest things would be the inability to get treatment in the meantime and the loss of wages. It can have no income coming into the family unit. Our clients speak of the significant financial stress that puts them on. To tell them, don't worry, when you win, which is our opinion, you'll get that money back, is of little consolation when the damage has already been done to that whole family unit. Not getting the treatment they need. Sometimes it might mean more significant treatment now needs to be incurred because what was a relatively modest cost for a relatively minor treatment expense, not being treated properly, gets worse over time, and now we're asking for more expensive treatment, surgical options.
Just finally, in relation to work capacity decisions, looking at the report that Finity Consulting provided in relation to insurance liabilities and nominal insurer for the last calendar year, they point to there being a significant decline in the number of work capacity decisions done. And they actually point to, they say if we get back to 2015, 2017, numbers of work capacity decisions being undertaken, that we could save up to, I think, $426 million per year, which would be a significant saving. Can you explain to the committee, I guess, in your experience, how that, like, why aren't those decisions being taken, and do you support, a higher frequency of work capacity decision?
I haven't seen that report, but our submission effectively comes to the same conclusion. I can't speak for why they're not doing work capacity decisions, having been on the plaintiff side of the fence rather than the insurer's side of the fence, but I can say our experience at the firm I work at and the colleagues at the ALA is that as the years go on, the frequency has definitely decreased in which we receive those decisions.
Does anyone else want to comment?
Can I just add to that? I think a comparison with 2017 is probably not appropriate, because between 2012 and 2017, there were a number more work capacity decisions being made. When the laws changed in 2012, it made weekly compensation finite. So the insurers had to make these decisions about people's work capacity. There's less of a need now for those work capacity decisions. So that could be one of the reasons why you'd see a difference now. You still see those work capacity decisions in practice commonly, perhaps less than a few years ago. But I think the big issue is the way that these work capacity decisions are being made, and they're basically being made based on these vocational assessments. And what that creates is a situation where you have an injured worker who has to respond to that by obtaining their own evidence, supposedly expert evidence from another vocational assessor. And it's just the ongoing incurring of these disbursements on both sides of the fence that ends up meaning the cost to the scheme is substantially more than it needs to be. So I think that there's probably less of a need for work capacity decisions, and as my friend says, it probably needs to fall back into the ambit of the case managers making these decisions based on treating evidence as opposed to hired evidence.
I think the other issue is if the case manager doesn't send it out to an internal consultant such as a vocational assessor to assess work capacity, then they're reliant on their experience of these work capacity decisions can often be several pages long. You're not going to get a junior claims officer being able to do that too readily. But when you do, it's just a lot of work, as simple as that. And if you don't have the experience, it's even harder for that to be produced. So I think that's a critical cause of why there are fewer than there were several years ago.
Interesting. Thank you. I'll go to the Honourable Matt Latham.
Thank you, Chair, and thank you to the witnesses. I had an employer once who spoke a lot about so-called labour lawyers. And are there law firms that this is their entire income base, workers' compensation? Anyone on the panel who can answer, please?
Not sure.
I can't think of any, but there's certainly, the law firms are a lot more diversified than maybe they were in the past who practice in this area. Certainly our firm is, and I think certainly my friend who's a partner at Turner Freeman, which is a large plaintiff firm as well, I think would probably say the same. So.
Well, what's your income from workers' comp as a proportion of overall revenue, profits?
I would not know.
Seriously, you're here and you don't know the proportion of revenue and profits your firm takes from workers' comp?
No, I wouldn't.
That's your evidence. What about Turner Man, please?
I wouldn't be able to answer that. I could take it on notice and provide that information, but it's I could indicate to you that workers' compensation is a big part of our personal injury practice, but it's certainly not the only part of that practice. And there are other practice areas as well.
Right, but it's been a pretty good feed and wicket for so-called labour lawyers for a long while, hasn't it?
Well, I think if you look at the cost situation with workers' compensation, it's a completely regulated area with respect to both statutory cases as well as work injury damages. So in terms of how that impacts on the scheme, I'm not sure where that's relevant. It is, if you go back 20 years, perhaps it was unregulated and there might have been a bigger portion of profit attributable to workers' compensation, but I can assure you now that it's a very minuscule part of profit, and in fact I could tell you that to run a workers' compensation claim these days it's very technical and one where unfortunately it takes a lot more time and effort and money than what we would recover under a conservative IRO regulated scheme.
Right, under the technicalities and the expertise that's needed here, I'm just looking at the SIRA website for impairment ratings, psychological impairment ratings, self-care and personal hygiene. Class 2 is a mild impairment. The person relies a lot on having takeaway food. Is that something that requires a lawyer to have a lot of expertise to understand this nonsense that someone's impaired because they rely on takeaway food? I know this will be joy for the Trump deranged, but the leader of the free world apparently is not impartial to a taco and a Macca's burger, but this is just some kind of joke, isn't it? Class 2?
Well, Class 2 wouldn't be enough to get you, for instance, to 15%. If that was the two median classes that were assessed for your particular psychological injury with which you're dealing. So that would be considered to be a relatively modest impairment scheme under the current system.
Yeah, what about Class 3? Needs prompting to shower daily and wear clean clothes. Well, that'd be most teenage children that I don't know of, and probably most male MLCs. This is just sort of comical nonsense, isn't it? An impairment, a moderate impairment, meaning you've got some limitation in your capacity to work, is reflected here on the SIRA website. Needs prompting to shower daily and wear clean clothes and does not prepare their own meals. Well, thank goodness I'm not part of that. I've got a cook, so I'm quite a dab hand in the. But this is all just comical, isn't it? You guys make money out of this rubbish.
I think you'll find that that's sort of a guideline. The PERS is not a strict. It's not a strict guideline. The questions will be around social and recreational activities and the other classes, but the doctors, it is a medical question ultimately, and the doctors will make an assessment.
It's a medical question about they don't prepare their own meals. Okay, you said you don't coach these people to come up with these things, but what level of imbecile would you need to require coaching on this? Because obviously you just go to the SIRA website and okay, I'm aiming here at a Class 3 impairment. I'm just going to tell the psych and my lawyer I don't prepare my own meals, and someone has to tell me to shower daily and wear clean clothes. And this is apparently costing taxpayers and businesses money. You don't need to coach anyone, do you? Because any old imbecile could qualify for understanding this and coach themselves.
Well, no coaching is required, and the PERS.
No coaching is required.
Is required.
You people got law degrees to make big profits out of this nonsense.
But there's no coaching. There's no coaching required. There's no coaching given because the PERS is a publicly available document.
But you don't require coaching, do you? Any old imbecile, read the SIRA website here and say, to qualify for Class 3 impairment, I just need to tell the psych and my lawyer, who'll be charging on a time basis, having got a law degree and must feeling themselves like a goose, that I don't prepare my own meals and my mum needs to ring me up to tell me to shower daily and wear clean clothes. That's how the system works, isn't it?
Well, I think any worker is entitled to go and look at the material available on the SIRA website and form their own view as to their rights and obligations. They get advice from us, but ultimately it's the doctors that do the assessments. And there was evidence before this inquiry on the last occasion about from some of those doctors about the peer scale, and there's been some criticism of that scale for many years. But it's a system we have, and workers are entitled to know how that system is going to treat their claim with the evidence that they give.
This is money gouging on a scale even beyond the NDIS, isn't it?
We strongly
You know,
disagree with that.
NDIS is world's best practice money gouging and fraud. This thing about having a shower, wearing clean clothes and preparing our own meals, people who've been to university for 5 years, psychs, lawyers for 4 or 5, make money out of this. I mean...
We run claims for clients who exceed the 15% threshold, and I think the evidence before this committee on the last occasion was by Associate Professor Robertson and the other doctor whose name I can't recall right now, was that a worker who gets to 21% is effectively incapable of working. And I think, as my friend Tim Concannon pointed out, the lower level scales that you're talking about in those examples wouldn't get to those thresholds.
Order.
Well, I know one thing, Mookie's nowhere near addressing any of this. He's a joke. Thank you.
I will now pass to the government for questions.
Thank you, Chair. If I could just turn to amendments to the government's bill proposed by Mr Tudorhope and Mr Latham in relation to bullying, sexual harassment and racial discrimination. Are you across the details of those amendments?
Yes.
The amendment includes, well, Amendment 12, the objective test that in relation to sexual harassment, racial harassment or bullying, the alleged perpetrator's knowledge and intent is the primary factor in determining whether a relevant event has occurred. In providing context to that proposed amendment, the opposition leader stated that the changes, and I quote, would still protect workers from ignorant bigots. Would it be fair to say that ignorance would be a significant factor in someone's motivation to racially harass, sexually harass or bully someone else in the workplace?
Yeah, well, on a point of order, Chair, the Leader of the Opposition is not part of the inquiry, and those observations are not part of the amendments. The changes on racial discrimination that the Honourable Member there, Nanva, would know full well are to learn from the errors of 18C and take out insult and offend. I mean, anyone will be offended in the workplace, of course, and get up a claim. So in terms of procedural fairness, he is misrepresenting the nature of those amendments, which don't contain the comments that he attributes to the Leader of the Opposition.
To the point of order, I am directly quoting the Leader of the Opposition through a public press statement that the changes would still protect workers from ignorant bigots. In providing context to the amendment.
This is Speakman.
Yes.
Okay, so in the context of that debate all being on Hansard for the record and having been well aired, I think we can allow the question and allow for it to be answered.
Thank you.
The question needs a little bit of unpacking with respect. The first observation we'd make is that the proposed Amendment 12 provides that knowledge and intent is the primary factor, not the only factor. So that leaves open the protection addressed by the Leader of the Opposition in what you've put to us. The more important aspect of the proposition, though, is, as we've set out in our written submissions, that what really should be sought is a consistent definition of harassment rather than breaking down harassment into different forms of harassment and treating them differently. All that does in our submission is to make the situation worse. If one has a properly drafted and considered definition of harassment, then one doesn't need to go down all the rabbit holes of defining different types of harassment. And all that one does, the other effect of doing that is to create more dispute points. And you might have someone who's subjected to more than one form of harassment. Does that mean that they then have to approach their claim under different definitions for each different form of harassment and how it fits into the injury that they then suffer as a consequence? If one takes the more principled approach that we advance in our written submissions, then Amendment 12 we would think would be unnecessary, as would the other definitions of micro forms of harassment. And there would be a consistency and objectivity involved in the test that applied across the board.
I appreciate that, this may be an imperfect approach and there may be a better approach, but they're the amendments that are currently before us.
That's a concession.
There are amendments before us, and if I could just return back to those, just for the sake of clarity, the matter of someone's ignorance would surely inform whether or not they had an intent or were motivated to sexually harass, to bully, to racially abuse.
That's so. Of course, it depends what the ignorance is of.
And whether it was reasonable.
Whether it's reasonable and what the subject matter of the ignorance. You could have someone who might be ignorant of the fact that they were harassing. They might be ignorant of the fact that the subject matter of their comment is racially based. You might have someone who's ignorant of the fact that it's likely to cause harm. You might have some other form of ignorance. It's one of the difficulties with the deployment of that term at large. But we come back to the proposition and that the knowledge and intent is only the primary factor in Amendment C. It's not the only factor. But the fact that that Amendment 12 lies in the context of the other amendments in relation to racial harassment, reasonable management action, vicarious trauma, sexual harassment, is why I answered the question more expansively in the first place, and that is that if you have that consistent definition of harassment, your street's ahead.
Where a test goes to intent, who meets the evidentiary burden of proof in relation to that?
Well, in the ordinary course it would be the claimant unless the statute provided otherwise.
Is there a risk that legitimate victims would be denied justice, and victims of sexual harassment, racial harassment or bullying would be denied justice under these amendments?
The more and more complex this legislation becomes, the greater the risk that any legitimate claimant is going to miss out on what they're rightfully entitled to, and it's one of the reasons we've supported a wholesale rewriting of the legislation and making it into a cohesive, workable act. But as anyone with a passing knowledge of legal proceedings in this state, in any other state, in the federal courts knows, intent is something that's proved in criminal and civil courts on a daily basis, ordinarily by way of inference from established facts. So, for example, the content of what's said, the circumstances in which it's said, the overall context in which the interaction arises, all of which can establish by way of inference an intent. And indeed, in legislation of this Parliament addressing a similar proposition, Section 3 capital B 1A of the Civil Liability Act, speaks of an intentional act done with the intent to cause harm as a basis for excluding an action from the operation of the Act. Now, all of that's got to be established by the plaintiff in the proceedings, and it can be done. It's done by way of generally inferential reasoning from the facts that are able to be established.
Is the proposed amendment or definition consistent with, say, the Commonwealth definition or the definitions you'd find in other jurisdictions?
I'd have to take that on notice, and the question would probably, with respect, need to be directed to particular areas of discourse, because questions of intent arise in criminal proceedings, they arise in all manner of civil proceedings, and it can take different forms in different contexts, even within the criminal or civil jurisdictions. So I'd be happy to take it on notice, but it would have to be a far more targeted question for us to be able to address it in a meaningful way.
Perhaps I could do that by way of a supplementary question. You'd agree, though, that the changes would likely deter workers from pursuing such claims, particularly if the burden of proof were to lie with them?
I think that's a speculative proposition. There are all sorts of circumstances in which intent of different kinds has to be established. We think that the issue of intent, in a sense, falls away, as I say, if you go for a consistent objective definition of harassment. Then the question of intent becomes less important. And how you frame the intent becomes very important as well. And you'll see that in our proposed definition of bullying, which is not the form that appears in the amendments, but it's in our written submissions at paragraph, I think, 101, we have used the terminology of with the intent to cause harm or distress. Now, that's something that we would envisage would be able to be established by inference from the nature of the interaction and the context in which it occurred in the ordinary way. I don't see necessarily, subject to the way in which it's couched, that having to prove some form of intent would act as a deterrent. It'd act as a threshold, but I don't know that it would act as a deterrent to bringing a legitimate claim.
Okay, thank you. I might just turn to just a line of questioning previously raised by Mr. Tudorhope. I will read to you one piece of advertising from a law firm, just to see whether this is something that your organisations would look dimly on. The advertisement states, and I quote, "If you've been unable to reach the 15% WPI threshold, we also regularly assist injured workers in appeals and medical appeals panels in the PIC and judicial review applications in the Supreme Court of New South Wales relating to 15% WPI threshold disputes." Is this something that is of concern to you in terms of trying to get more injured claimants through a threshold where they might not otherwise have first succeeded?
For our part, no, because the advertisement is directed to appeals and judicial review, which are themselves directed at the correction of error. So an appeal to a medical appeal panel is only going to be good if the original medical assessment was wrong. A judicial review to the Supreme Court from a medical appeal panel is only going to be any good if the medical appeal panel fell into jurisdictional error or error of law on the face of the record. So there's nothing ethically questionable in the advertisement that you've read out. It's all directed at the correction of error, which wouldn't be necessary if the original decisions had been right.
Nothing further from me.
You right?
Looking for the advertisement, but I'll
Okay.
do that by
I'm just going to
supplementary.
ask a real cheeky one in your last 6 seconds, just on the back of those questions. I note that the Industrial Relations Bill that passed at the end of the last sitting fortnight that sets up that bullying and harassment jurisdiction in the IRC has an objective test on its sexual harassment test where it talks about it needs to be reasonable, the offence needs to have been viewed as reasonable in the reasonable opinion of a bystander or something, whatever the test is. Obviously that is different to the objective test that's been proposed, I understand, by Mr. Latham and Mr. Tudorhope, but it's also different to what's in the bill proposed by the government. Given your comments, Mr. Hook, about the trouble of having multiple definitions, do you think that this provision in the Workers' Comp Act should at least be, Workers' Comp Bill should at least be aligned to have the objective test of what's now in the IR Bill? And please take it on notice if it requires more analysis.
No, thank you. I think the simple answer to the question is that the provision in the IR Bill creates an offence. So one's dealing with a criminal context rather than a civil or insurance context.
Yeah.
So the approach is going to be different and should be different.
Okay.
But it also points out why we draw attention to the desirability of a consistent definition of harassment rather than a sprayed approach of defining different harassments in different ways.
That's really useful. Thank you. Okay, so unfortunately, I think I could ask you another hour of questions, but that does bring us to the end of this session. Thank you so much for appearing. We will no doubt have some supplementary questions for you, and to the extent questions are taken on notice, the Committee Secretariat will be in touch. But this concludes our panel with you today. Thank you.
Thank you. Thank you, Chair.
Excellent. All right, let's commence our next panel. Thank you very much to our next panel of witnesses. I will ask each of you, starting from my left, to please state your name and position title, and then swear either the oath or the affirmation.
Yes, hello there. My name is Nick Glozier, Professor Nick Glozier, Professor of Psychological Medicine, University of Sydney, Senior Staff Specialist at Sydney Local Health District, and one of the Senior Medical Assessors for the Personal Injury Commission, member of Medical Appeal Panel, the longest serving psychiatric member of the Personal Injury Commission. But I need to express that I'm specifically not representing the Personal Injury Commission here.
Excellent, thank you. And either the oath or the
I
affirmation.
solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you.
Thank you, and I'm Dr. Rebecca Hoffman. I'm a GP, and I'm the chair of the RACGP, the Royal Australian College of General Practice for New South Wales and ACT. And I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you.
Thank you. My name's Jenny Crane, and I'm the New South Wales representative of the Australian Association of Medico Legal Providers. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you.
Hi, my name's Mark Gibbons. I'm the President of the Medico Legal Association of Australia. I'll take the oath. I swear the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Excellent, thank you. And would any of you like to make a short opening statement? I'll start with you, Professor Glozier.
Can I give you a little bit of background and then where I'm coming from as well? Yeah. So I've been working this area for well over 2.5 decades. I've written hundreds of papers on workplace mental health, impairment assessment, disability in this area. I was an author of the World Health Organization's Guidelines of Workplace Mental Health. I wrote the World Psychiatric Association statement in this area. I developed the evidence base for Safe Work New South Wales, which underpinned the guidelines and then later the regulations, the evidence of all of the stressors, the interventions for those things, developed such things, hold patents in them, and I think also very specifically to some of what's been discussed previously, was commissioned by the South Australian Government to do a formal comparison of the GEPIC and the PERS in the determination of impairment. And I would like to say something later, or maybe now, about why you need to disentangle the use of the particular instrument within the legislation guidelines, which I know has been raised, from the specific percentage of whole person impairment, because you can't tackle one without the other. And finally, whilst representing the college, we would represent that it looks quite clearly that the legislation has been intended to further discriminate against people with severe psychiatric disorders, and the changes from the draft exposure have appeared to have removed the focus on limiting entry into the system and begun to focus entirely on the severity of people with psychiatric disorders, raising the threshold to a level that we see as ridiculously punitive, such that almost no one will ever get compensation for a psychiatric disorder, and therefore almost no one will ever be able to proceed to work damages claims.
Thank you. Dr. Hoffman.
Thank you. So the RACGP is the largest doctors' professional organisation. We represent over 50,000 members. In New South Wales, that's around 15,000 GPs. As a GP, we have one of the most vital roles in work cover, in workplace injury. We're often the only person that the people will see from before their time they're injured, throughout the entire claim, and then onwards and following the injury as well. Not only supporting them, but supporting their families and their community members and their supports as well. I'm not here just as RACGP, but also here as an everyday GP. I've seen work cover patients this morning and look forward to taking any questions. Thank you.
Thank you.
Thank you. Good afternoon, Chairperson and committee members. Thank you for the opportunity to present on behalf of the Australian Association of Medico Legal Providers. We're an organisation that represents over 60% of the providers in Australia in the medico legal industry. Our members deliver independent and impartial medical expert assessments within the personal injury system. And these services help injured workers access timely care, support insurers and employers in decision making, and ensure a sustainable workers' compensation scheme that delivers better return to work outcomes for all parties. Our association supports the government's goal of creating a sustainable modern workers' compensation system that better supports workers, especially those with psychological injuries. However, we are concerned that some proposed reforms could cause treatment delays, reduce access to justice, and impact clinical independence. It is vital that any reform prioritises early access to care and fair independent assessments. When these principles are upheld, workers recover faster and the system benefits through lower long-term costs and reduced premium pressures for employers and the government. There's 3 points that we wanted to emphasise. The first one is the importance of early engagement and return to work planning. So within the first 21 days of a valid claim, workers must have access to qualified independent mental health experts, working closely with their treating GP. This collaboration ensures a clear diagnosis, coordinated treatment and informed liability decisions. Independent mental health professionals bring specialised expertise in accurately diagnosing genuine psychological injuries, ensuring liability decisions are made promptly and based on sound clinical evidence. This prevents workers without true workplace-related psychological injury from remaining in the system unnecessarily, while ensuring that those with legitimate injuries receive early targeted care. Early expert input also importantly determines whether a worker should return to their employer or transition to a new workplace for better recovery. The current scheme strongly encourages returning to the same employer, but for many psychological injury cases, this can prolong recovery and lead to disputes. Our second point that we'd like to raise is concerns with Part 6 of the bill, permanent impairment assessments. Part 6 would introduce a centrally controlled process for impairment assessments, requiring workers to obtain legal advice before an assessment and limiting both workers and insurers to authority-approved assessors. This approach could impact clinical independence and raise concerns about the authority's dual role in managing the scheme and controlling access to experts. It may also limit access for workers and insurers to seek their own independent expert opinions, which are often important in resolving complex and contested claims. Courts and tribunals already have the structure and expertise to manage these disputes and assess conflicting medical evidence. So we believe the existing dispute resolution system should remain the primary pathway for resolving medical disagreements. We recommend that no changes proceed until the impact of new impairment thresholds is clear. Combining restricted access to the independent opinions with higher thresholds risks limiting access to justice and fair compensation for genuinely injured workers. The current approach should be maintained until there is clear evidence that further reforms are both necessary and will not create additional barriers. Now, final point, legislating the role of other expert assessors. Currently in the New South Wales legislation, it requires that a medical doctor, such as a GP or a psychiatrist, must diagnose psychological injuries for the purposes of workers' compensation claims. However, due to high demand, accessing psychiatrists for independent assessments can involve lengthy wait times, often extending several months despite their best efforts to meet the demand. These delays can postpone liability decisions, delay treatment, and ultimately prolong an injured worker's time away from work. To address these challenges, we propose amending the legislation to allow appropriately trained clinical and neuropsychologists to diagnose psychological injuries and contribute to liability decisions alongside medical doctors. Trained nurse practitioners and occupational physicians also should be considered, we believe, giving their understanding of workplace environments and demands, which helps them tailor practical recovery plans. Expanding the pool of qualified assessors would improve access, cut delays, and allow treatment to begin sooner, while enabling specialists to address workplace and psychosocial factors so injured workers can return to function faster, achieve sustainable employment, and reduce the risk of long-term disability or relapse. Just in summary, early expert engagement with GP collaboration, quick return to work planning, and access to qualified assessors is essential for timely care, accurate decisions, and better outcomes. And we believe these steps will support workers, reduce delays, and contain costs for insurers and employers, creating a more sustainable and balanced compensation scheme, while ensuring workers and insurers can still access truly independent medical opinions to keep the system fair and transparent. Thank you.
Thank you. I take it, Mr. Gibbons, that was given on behalf of the organisation. Great. I will hand over to you, Mr. Tudor.
Good morning, or good afternoon now. Thank you very much to all of you for being here. Can I start with you, Dr. Hoffman? Often the first port of call for an injured worker is their GP, and the GP is called upon to make an assessment of the psychological injury and capacity to work, potentially following from that assessment.
Yep.
There'd be varied abilities, would you agree, in relation to GPs to be able to actually make that assessment?
No, I think, there's a number of things there. I think if it's a patient that is known to you, known to your practice, that you've met multiple times before, that you have a good understanding of their supports and their environments, undertaking an assessment of their psychological changes and abilities is well within what any GP should be able to do. The difficulty comes when it's a new patient you've never met before. You don't have an understanding of what their baseline is, and making that decision is far more tricky.
Yeah, so if it was a GP making an assessment who wasn't the normal within the practice of the GP, that'd probably diminish the reliability of the potential certificate which was being given?
No, I think for both cases, the GP has to take what's being told to them. We always believe that our patients are doing their best, they're telling us the truth, and there's no reason not to. I don't think that the certificate itself would be diminished, but I think a quality history and examination of that patient can determine whether or not the patient is having an acute panic attack or is in significant distress or have significant depression. All of those skills are skills of a good GP. If there's any deliberation or concern, we would call on our allied health partners and talk to clinical psychologists or other people in the team before finalising a formal diagnosis. And often that's what happens in these cases is the initial diagnosis may be an adjustment disorder, whilst we're actually trying to determine what the ongoing diagnosis may be.
Well, familiarity of most GPs with the DSM-V scale for the purpose of workers' compensation, would most GPs have that familiarity? They would use?
Yeah, so absolutely. So 70% of GP consults have got a psychological component to them. Most of what we're doing every day at the moment is mental health.
One of the submissions which you've no doubt just listened to is early access to specialist treatment. Would you agree with that as a proposition in terms of recovery and return to work, is that early access is an essential component?
Well, first of all, GPs are specialists. We're specialists in general practice and in family medicine. If we're talking about non-GP specialists,
correct.
I think that there's a cohort of patients that absolutely need to see non-GP specialists. But not every work cover patient I see needs to see a non-GP specialist. Do they need to see a psychologist? Do they need to see potentially an exercise physiologist? Do they need to see me regularly? Yes. Do they need to see a psychiatrist? Possibly, if they're not improving on first, second, third line medication and therapy that we've started together.
Well, in relation to that cohort, which is in the 21 to 31% range, would you say that that is a cohort which is in need of specialist? And I'm not diminishing GPs. My father was a GP, so I would be very loath to do that. Would you assess that those people need very early access to specialists of the sort that you have identified?
Absolutely. They'll need specialist intervention and often even an inpatient intervention as well.
Well, when the Treasurer cited you as supporting his contention that all or most workers with a psychological injury and a whole of person impairment assessment of up to 30% have work capacity, is that your view?
So my view is that everyone has work capacity at some point in time. As doctors, what we're wanting to do is make people better. Are they okay day one post-injury? No. But with therapy, with medication, with inpatient stays, absolutely by the 12-month mark, by the 2-year mark, we want people back in work. Work is good for people, and whether they're going back often to new job, and I completely agree with early identification of people needing new jobs is important, but definitely if they're going back to same job, which is often the minority in psychological injury, we want them re-engaged and returning to work.
Is that your view, Professor?
Which particular part of that?
Are there people between 21 and 31% and their capacity to work?
I think you've got two things here. So firstly is the determination of 21%, and when is that made? Because you only make those determinations much later on. As my colleague pointed out, many people, when they are first unwell, first presenting, almost always to general practitioners, will have a much higher degree of impairment than they will over time through both treatment, the passage of time, other life events, etc. So many people presenting initially will have a much higher impairment that is resolved substantially by the time we see them. In terms of if one uses the PERS rating scale, it's actually almost impossible to get a rating of over 21% without being rated as totally impaired on the PERS rating scale because of the way it works. And as someone who's probably done more PERS rating scales than I, the PERS is the measure that we use. You've probably heard about this many, many times. But because it is almost always the employability that gets the highest score within the PERS, most people, in fact anyone who really gets over 15% is generally rated as having a severe or total impairment. To get to over 21%, you've got to have 3 of the 6 categories rated as over a 4 because of the median class. Actually, not quite, you can just about do it slightly differently. But it's almost unheard of that someone will be rated 21% or higher with permanent impairment who is not rated as having no work capacity. And many of us are looking at things like, do you have the ability to maybe spend a few hours a week doing support work or volunteer work? So I think we're fair, you've got to be fairly concrete that person's symptoms and impairment are such that they cannot work, not just in the open workplace, but actually in supported and volunteer work areas as well.
So a person who had a 21% and above WPI after 2.5 years, would that person have capacity to work in your estimation?
Not at that time, but I've been around this system long enough to see people who've been rated as having that whole person impairment, over 21%, who, for instance, made a claim in the early 2000s. I saw one only about 4 weeks ago, made a claim in the early 2000s, had a whole person impairment at that level, and about 6 years later returned to work for another 5 years. So it's always one of the issues with these is that they're really, the concept of permanent impairment is a bit silly. Yep. It really isn't permanent. It fluctuates. And so all we can say is at that time, from the symptoms, from the overall impairment that person is reporting across all the domains of life, that it is unlikely, or we think that they are totally impaired for the foreseeable future.
So if the test or the scale that is being applied for cutting off people's benefits, you say is not the right one, what would be your suggestion in terms of a replacement?
So I never said anything was not the right one.
Well, you seem to suggest that it's the inappropriate one because it's a point of time assessment. Even a point of time after 2.5 years, you may be 21% and have no capacity to work, and you were trying to make a decision about whether people should be continuing to receive benefits. What would be the test you would apply?
I don't think that definition of the timing is really determined about whether someone should continue. It determines whether people receive benefits, but I don't think it's determined upon their employability or not. And at that stage, most people would have been out of the workforce for so long that the chances of them returning to the workforce are very, very low, and so they would transition onto other benefit schemes such as Centrelink, etc. But they would be taken away from the insurers' payouts.
So you would support, is that what you're telling us, a position that someone would be removed from compensation benefits?
If you're going to provide a sustainable workers' compensation scheme at some stage, given that the flow into the scheme is ever increasing, at some stage you've got to stop paying out benefits without raising premiums to a level that's unacceptable, or, as we've seen over the past few years, raiding the public purse for billions of dollars.
Well, what's the model you would adopt?
I actually don't have a problem, personally, with the idea that actually at some stage you have to limit benefits. This needs to be flagged early, and there will be a stage, and really if someone is that unwell, there's a range of other things that will kick in, including such things potentially as the NDIS, disability support pension. They can access their super potentially. Some people may be able to access total and permanent disability schemes that's actually held within their super. So there are a range of other things that can kick in the benefits. One has to make a balance of, are you going to pay someone that amount of money forever, or at some stage does a scheme like this have to limit itself?
Well, if they're on welfare or NDIS, isn't that a similar sort of process?
Well, it's coming from a different purse.
It just comes from a different purse, so it's really just cost shifting.
Well, it's not cost shifting, because if you look at the proportion of the salary that might be reimbursed under a workers' compensation scheme, for many people that will be quite a dramatic cut in their income.
Well, what about the removal, though, of continuing medical treatment? Do you support that?
It's not removal of medical treatment, because if you think about it, we actually have a public health scheme, and anyone at that level, people can access the public health system. We do have a public health system in this country. There is a better access scheme. These things are not necessarily easy to access, and in certain areas they can be hard to access. But if you've been in the system for 2.5 years, you should be relatively well engaged with a whole set of medical providers. Now, if people choose to cut you off if you are unable to pay for them, then one may look at the ways that those people are reimbursed. But we do have a medical public health scheme.
Can I just ask, in terms of the early access to medical support, which I think is the thrust of the claim by the medico-legal providers, is that readily available? Is there sufficient supply of medico-legal providers?
If you're looking at mental health, there is a wait time at the moment for psychiatrists. There's a huge demand for their services. So it could take months to see a psychiatrist. Having said that, if an appointment was really needed urgently, most psychiatrists will provide an appointment for you. They try to assist in terms of the delay. But going to the third point we raised, if psychologists, appropriately trained, so a neuropsychologist, for example, or a clinical psychologist, were allowed to also diagnose in that early stage, it would help significantly.
Can I ask, are there medical providers, I'm sort of using the I don't know if that's the right terminology, but doctors or psychiatrists or any other medical professional who refuse to take people who are going to claim through workers' compensation? Is there a difference in a medical professional's eyes in terms of who they would?
I'm happy to talk to this first.
Please.
Absolutely. And even within the last 12 months, the number of doctors, the number of psychiatrists that I can refer to and have a work cover patient accepted has dropped by about 50%. We used to have about 6 or 7 that we could reliably refer onto in the region that I work in, and it's dropped down to 1 to 2. And one will only take one particular type of work cover. So it has drastically reduced. But that's not just with psychiatrists, that's with psychologists as well. So psychologists also don't seem to really enjoy or love doing work cover.
Why?
It's for my understanding, it really comes down to paperwork and red tape.
Okay,
So it's not the patients. The patients are great. The patients are lovely.
Yeah.
It's the paperwork.
And it's not to do with the amount of compensation?
No.
No.
And I think it's across the board. It's not just psychiatrists. I mean, you see it in the GP
Yeah.
notes that GPs
Yes.
will refer to other people in the practice or refuse. You see it in other specialists as well. It's an across-the-board issue.
So, given that we, as we all know, we have quite a shortage of psychiatrists and psychologists in New South Wales, and that has been an ongoing problem, if there is then this reduction in supply of people who can do this work from a psychological perspective, how does that then impact on the speed at which patients are being seen when they come through the workers' compensation system?
I think people are generally, if it's coming through the workers' compensation, people are seen relatively quickly. I mean, they see their GPs really very quickly because in order to access the scheme, if you like, you've got to have seen a GP to actually move into the scheme. So it's almost, the GPs are the gatekeepers for a workers' compensation claim, effectively. So they have to have seen one medical professional. GPs actually are very good at initiating psychotropic medication, if necessary, at an early stage. I would suggest but in terms of psychological interventions, that can vary enormously, but there's an increasing provision of telehealth by various insurers, including telehealth providers of both psychiatry and psychology. There's the government's Head to Health digital program. There is MindSpot, which are all evidence-based digital programs that are readily accessible.
The latest iCare analysis in relation to psychological claims liabilities from 4th of December last year said that the average time to first psychological treatment in the nominal insurer is 47 days from the date of first report, and for the TMF it's 48 days. And they then say for both the nominal insurer and the TMF, 25% of claims have longer than 80 days before that first psychological treatment. We've also seen statistics that show that the sooner the psychological treatment is given, the quicker people return to work. I guess, well, that's what the data is showing us. So what is, I guess, my question to you is, what is stopping people from seeing someone quicker then, if it's not the problems with the workforce?
That is a supply issue. You are correct there. I mean, some of those people will have seen EAPs and other providers as well before they're seeing the person who is identified through the system, remember, because you're only seeing the ones who are identified through the system. So a month and a half, and to be perfectly honest, that's not unusual in many cases. There are some practices that will have psychologists embedded with them, but that will vary enormously to where you are. So yes, there is a bottleneck in the system. There is a limited number of providers of evidence-based care, and you're always stuck with this. If you broaden the number of providers, you will reduce the effectiveness of the care that they provide.
If we're taking people out of workers' compensation and saying, well, there's another system that they can go on to, but we know that the public health system has even more severe problems when it comes. We've just had a mass exodus of public psychiatrists from
They've pretty much all come back now as VMOs. They're just costing a lot more money in the system,
which is ridiculous in
Yes,
itself. But if that's what's happened, like what's going to happen to people? It's not really addressing the problem, is it? If people are getting injured, whether they're being dealt with in our public health system or under workers' compensation is not really the point. I guess how much of this could be solved by the government instead focusing on improving the workforce conditions and attracting more psychiatrists, psychologists into New South Wales?
Psychology is almost one of the biggest growth industries in the country. It's probably the psychiatrist numbers are limited. We actually have a cap on the number of training placements. That's actually a federal cap. New South Wales government could do nothing about that. That has been increased ever so slightly next year with federal funding. The psychology training is a more fluid, expandable number of those. And so you could increase more supply of those. We have increased numbers enormously. If you look at the numbers, they have increased enormously over the past few years. It's that the demand has increased, and if you look at for instance, the Better Access Scheme reports, you'll see that what's happened is people are staying in treatment for a long time. So it's harder for people. So the Better Access Scheme was set up as a short-term treatment. Get this, you're meant to move on. If you read the two Better Access Scheme reports, what you'll notice is that people are staying in for year after year after year in chronic treatment. So we're providing a lot more treatment to a lot more people, but the demand is outstripping supply.
Just before I move to Mr. Latham, I just wanted to give the other witnesses a chance to respond to those questions as well. Dr. Hoffman.
Sorry, so yes, the 6-week wait to see a psychologist isn't uncommon, and that's particularly if we're looking at 6 weeks for a CBT or an EMDR, specific types of therapy. If we have a patient before then, quite often we'll be doing the therapy, we'll be doing the supportive counselling, we'll be seeing them weekly or fortnightly until they're able to get in to see the specifically trained therapist that we're wanting them to see. And many GPs have had additional training in FSP and focused psychological strategies to be able to do that additional training as well. But for most of us, we're the ones that they see in that time slot. The specific training, we're very, very particular on which psychologist, which therapist we want them to go to, because often we're looking for a match, whether that on age or personality or what we think will be successful, and that's where the wait often comes in.
Thank you. Did you have anything to add on those questions?
Look, I'm not sure what the drivers are for psychologists or psychiatrists providing their services in either the clinical pathway or the workers' compensation return to pre-injury capacity journey. However, the gazetted rates for assessments in the New South Wales scheme has been provided to me as the single most restrictive reason why psychologists and psychiatrists are dropping out of the system. So the number of psychologists and psychiatrists we have on our panel and of our members' panels have been significantly reduced, and in discussions with them, it comes down to, well, I've got greater demand in a different area where I can make more money. Why would I do that? Now, that's anecdotal. It's with our members, and that's what we're hearing. There are probably other drivers for that behaviour and the reasons to withdraw supply in the workers' compensation scheme, but anecdotally, that's what we hear.
But that's that's the gazetted fees for assessments rather than treatment.
Correct.
So those are two different systems you're talking about here.
Correct. Yep.
Thank you. Mr. Latham.
Thank you, Chair, and thank you to the witnesses. To Mark and Jenny, excuse my ignorance, but what is a medico-legal provider, please?
So we provide independent medico-legal reports to remove any conflict of interest in either specialist doctors or non-specialist doctors providing evidence for both sides of the adversarial system.
Right, and wearing your legal hat, have you looked at these amendments described earlier as Tudhope-Latham amendments? They're actually the other way around, Latham-Tudhope amendments. Have you looked at those in any detail, please?
Yep.
Right. Well, can I take you to the one about racial discrimination? Because it takes out the folly of 18C, insult and offend, but leaves in harass and intimidate. So to give a case study here, an example that Mr. Nanva knows well, someone who tried to make the Premier of New South Wales and now very much tried hard to make the Attorney General with success. If you're working at a company, say like No Borders, which has got Asian directors and Asian workers, and apropos nothing, you barge in one day and give them a good old spray saying that Asian PhDs are taking all the jobs in Sydney, an obvious act of racism that harasses and intimidates, wouldn't you be eligible for a psychological injury workers' compensation claim under this amendment?
I'm not a lawyer, so I'm happy to take questions on notice and respond at a later date.
If you can take it on notice and get some legal advice, but I would have thought barging in at No Borders, full of Asian workers, Asian directors, a few others there that we know well, and you say that all the people like you, Asian PhDs, are taking all the jobs in Sydney, that would be seen as harassing and intimidating those workers in the workplace. Let's take a second example. Again, someone where Mr Nanva worked very, very hard to make him the Premier of New South Wales, a case study from a Christmas party. This was in 2016, but let's hypothetically say it was a Christmas party coming up later this year, and you stand next to a reasonably attractive, thin, blonde woman, and you put your hand down her dress and her underwear. Wouldn't that still qualify under this definition of being knowingly unwelcome in terms of sexual harassment? And even worse, you'd say sexual assault, and you'd qualify for a psychological injury under workers' compensation?
We provide independent medico-legal assessments and reports for the insurers and the plaintiff lawyers. We don't provide legal advice.
No, well, in the first instance, you can do that and still be the Labor Attorney General. In the second instance, you get close to being the Labor Premier of New South Wales, but clearly knowingly unwelcome. To stand next to a woman at a Christmas party and put your hand down her dress and underwear in an uninvited, spontaneous moment of sexual harassment. And just to come to Mr Speakman and this description of ignorant bigots, what if you had colleagues, in his case, former member for Pittwater and soon to be former member for Kiama, who've raped people, allegedly in the first instance, convicted in the second? It doesn't really matter, does it, under what threshold of sexual harassment you've got? Obviously, this is a lot worse, but this too would qualify, wouldn't it, under the amendments that we're talking about?
I'm going to take your question on notice.
Okay. Just saying there's a lot of bad people around, and perhaps those in glass houses should be a bit aware of the stones that can be thrown. Thank you. Thank you, Chair.
Thank you. I think I will throw to the government.
Thank you, Chair.
Come in on those examples, Bob. People you've worked hard for.
Not defending any of them.
No, you're not. Oh, no, it wouldn't be, mate.
All right, order.
And can I just, on notice, more to come?
Thank you, Chair. I might just go briefly to evidence that we received in the last session, just in relation to, I suppose, the subjectivity around the assessment processes and provisions that might not be objective and clear in relation to workers' compensation benefits. There are concerns that have been raised by witnesses previously around, I suppose, gaming of the system and finding ways to incentivise threshold beating evidence in order to receive some sort of financial outcome. In the previous session, that was a question that we put to the lawyers panel, and they said it really wasn't a matter that they had come across, but that we should perhaps put the question to the doctors panel. Do you have a view on any of that, particularly given there is just an inherent subjectivity in assessments using the peers scale and qualifying for, benefits in order to reach a certain WPI?
So the subjectivity is definitely an issue that we see as GPs, and that's one of the things that we would be calling for, is a really clear identification both for us and for our patients around what the impairment severity is, and then therefore what the insurance coverage is, so that we can start working early as we can with our patients, so that they have clear understanding of, we need to be getting you back to work, or we need to be looking at other options like a Centrelink or other ongoing options. But at the moment, there's too much breadth in it.
Right, and ambiguity. Any other observations?
Yeah, I'll come to this. So you're talking about the assessment of impairment, and I assume you're talking about psychological, psychiatric injuries when you talk about subjectivity. The first thing I'd like to say actually is there is considerable subjectivity in the assessment of impairment in every single one of the other scales as well, using the AMA4, AMA5, and we see that in the disputes quite frequently, where different orthopaedic surgeons, for instance, will rate very differently, because they are also using subjective approaches to supposedly objective measures. So it's not just an issue for psychiatric, psychological injuries. So I think it's across the board. Any assessment scale you use for anything will have a degree of subjectivity in it, because you are always reliant upon individuals. If you look at the particular ways of assessing psychiatric or psychological impairment or disability, the further you go towards actual impairment, and I was part of the WHO team that devised the definition of impairment, the further you go there, the more you actually are reliant upon subjectivity. So the GEPIC is actually more subjective than the PERS, for instance, because the PERS actually doesn't really rate impairment.
Sorry, GEPIC being the scale they use in
GEPIC
Victoria.
being the scale that's used in South Australia and a couple of other jurisdictions, was used in Victoria. It systematically rates 10 to 20% higher. So that's why South Australia have been able to move to a much higher level for psychiatric injuries, because the actual measure of impairment that they use is a far more generous measure of impairment, which is one of both mine and my colleagues' key concerns about the 31% threshold, because if it's based upon comparison with other legislations, you're comparing apples with oranges in terms of determining thresholds. So it's a real problem utilising some of the other jurisdictions as your benchmark, because they actually have a very different metric for doing that. That being said, so if you look at the rating scale for the PERS, now the descriptors are by no means perfect and it needs rewriting because it is substantially out of date. But actually the point of where the thresholds were, and I think Julian Parmigiani spoke to you last time, is the idea that once you reach a rating of 3, it has a degree of objectivity. Other people can rate it, it will be rated by GPs, psychologists, etc., whereas the rating of 1 or 2 tends to be a more subjective rating. That is, of course, not perfect. Everyone agrees it is not perfect. And none of these scales have actually been subject to standard psychometric tests. So, yes, people can game it. Yes, people can actually do that. Well-trained assessors, and it's what I've been doing for years, you learn ways of asking to find out the degree to which that is there. But of course, the newer you are to this system, the harder it is to do this, because you learn with experience. It's not, we don't have a machine that goes bing, that gives you a number. So some people gain the system. It is quite clear that some people turn up with statements that have been written basically copying out the PERS as their statement to give them a certain set of classes.
Isn't part of the issue that the worker presents themselves on any given day, on that day, and they are effectively assessed on that day?
They are, but so that's in the statement. But the point of when they come to the whole person impairment assessment that I do, or medical panels, we are looking at all the evidence. And you can choose, as an assessor, the degree to which you weight the evidence of the individual's statement, their partner's statement, what you assess on the day. And there actually is now a new course being developed at Monash that I'm involved in, which actually is aiming to train people to do these assessments better, to look at not just what the person tells you, and we spend a lot of time asking about questions, asking about things that the person doesn't necessarily tell you, or asking about what you can do, because the injured worker will always tell you what they can't do. And so we spend a lot of time. That being said, the other issues around gaming actually are, I do see within the legal profession, which is the redaction of the notes that get sent to us. So the classic one being that the GP notes have only been requested from the date of the assessment, thus removing any information that we might have about a pre-existing injury. So but that being said, in terms of what I see, and I see a lot of these cases coming through the Commission, it's a minority.
And the reason for that would be in order to aid surpassing a particular threshold to receive, the benefits over time. Is that?
So let's say it is a small. I think it is a minority. It's a small minority of people. It occurs probably in certain types of workers and certain types of law firms, depending on where they specialise. But it is a minority that do this,
but it does
and the aim is to try and increase the whole person impairment assessment. most of us have been doing this for a long time. We are very aware of this. When you get to the Commission, we are very aware of this, and we generally have a lot more evidence, because sometimes with the firms, you're only given the evidence from either the worker's lawyer or from the insurer's lawyer. By the time they get to us, actually the determination of the whole person impairment assessment, we actually have both sets of evidence that comes. And, you know, I think most of us make a pretty good job of looking at both of those, and actually, in order to afford procedural justice and procedural fairness, talking to the worker about when, if they say something that's different in the evidence, actually bringing that up at the time and trying to tackle inconsistencies. And we are specifically asked to address inconsistencies in the template and in the rating.
Okay, thank you. Just coming back to the use of that concept of WPI, it's obviously not a measure of a worker's capacity for work. The former Workers' Compensation Independent Review Officer, Kim Garling, has given evidence to this committee. I'm just going to read parts of his evidence. I've formed no value judgment on it, but I just want to put the proposition to you and get your views on it. Mr. Garling has said, and I quote, "Whole person impairment has nothing to do with capacity for work. There are plenty of people who can work who have very significant whole person impairment ratings. When you talk about capacity for work, that has nothing to do with impairment. We have plenty of impaired people with high ratings of impairment who could work that choose not to. That is a bigger issue that overrides these reforms." Is that a view that you would share?
Completely, yeah. The whole person impairment is not purely a rating of capacity to work. I don't think it was ever intended to be a rating capacity. It's an assessment of impairment. And if you look, some of the, I can give you the ridiculous extremes. So the classic being the concert violinist who loses the tip of their ring finger. Now, to anyone here, that would have no bearing whatsoever on their ability to work. It completely removes that person's ability to work, yet to all intents and purposes, they have no impairment whatsoever from a whole person impairment perspective, but they can't work. And we can do that vice versa. So the two have a small degree of correlation, but I don't think there's any expectation that the two should be completely correlated.
So I think it goes...
that as well.
Oh, sorry.
We would support that as well.
Okay. It obviously goes without saying that getting people back to work earlier, as quickly as we can, is probably the best form of rehabilitation. That's a view that you would share.
Not necessarily, no, because if you're sending someone back to the workplace that actually is seen as punitive, bullying, discriminatory, then you're just creating more and more problems. There is a real issue in terms of deciding very early on, and here I think the evidence is more clear. There's a wonderful paper from Scotland about this, that ask people if they want to go back to that workplace. And there is a focus on rehabilitating back to their employer. Frequently the employer doesn't want that person back. The person may not want to go back. Quite often they do want to go back, but the system has a particular focus which may not necessarily be in the best interests of the worker or the employer.
As a general proposition, though, could I put to you that those who do suffer from a mental health condition would do better from an earlier return to work, which could result in an earlier recovery, as a general proposition, bearing in mind those sort of guardrails that you've put to the committee?
There's an issue around causation here, so the data around that is observational, in that those who return to work earlier tend to do better. But actually, what you can't say is that that is causative. And in fact, I cannot identify, and I know this literature very well, I cannot identify anything causative that shows that. It's probably...
But there is a correlation?
There's a correlation, i.e. those who are able to go back are doing better and are able to go back earlier. But I would challenge you to find me the definitive causative evidence that shows that that is the case.
Perhaps,
and I know it really
perhaps
well.
I'll take that on
You
notice.
could take that.
Would that general proposition that I've put to you apply to those with severe symptoms but less than a 31% WPI?
I would say anybody with really severe symptoms of that level,
less than 30. less than 30 points.
I'm not going to put a particular figure on it because I think that's pretty pointless, because a figure of 15 or 21% can be caused by very different levels of impairment in different domains.
Sure.
But I think someone who is highly symptomatic, let us say, with significant anxiety or panics, sleep disturbance, lack of energy, lack of focus, lack of concentration, sending them back to the workplace will be bad for them. It will be bad for their colleagues. It will be bad for their employer in terms of their outcomes. And you need to wait until people have a degree of symptomatology that they can actually tolerate going back to work, even on a part-time basis. So the simple proposition that everyone should go back early is really determined a lot by the person's choice, what their experiences were, what the context is, and their symptomatology.
Final question from me is that there's obviously a range of concerns around the financial sustainability of the scheme in its current form, and a sustainable scheme has to place some limits on it, and it's open to the Parliament to place those limits. Is it a legitimate position for a government to have that it pursues a structural or legislative reform to tilt the scheme towards those who have the most significant injuries, to make the scheme sustainable in the longer term?
Well, point of order in relation to that. That's asking the witnesses to form a political view in relation to what's before. They can comment on the structure of what is in the bill, but not the political view about whether it's appropriate.
Well, to the point of order, I'm asking if it's legitimate.
With that guidance to the witnesses about what they are required or not required to answer, I think they can be asked to answer.
Does anyone want to go first? I'm happy to take it first, and others can join in and tell me whether they disagree or not. I completely agree that we need a sustainable workers' compensation system, and it is becoming unsustainable, particularly in certain sectors. And I was in the Fin Review only the week before last, talking about how it is becoming unsustainable within the TPD and IP sectors as well. It's becoming an existential risk for some of our life insurers. My particular concerns is that from if you like, my expert view, is that the focus on the pointy end and the levels that have been chosen are so extreme that, given the current way that we rate impairment, you're not even going to be compensating people with really, really substantial impairing psychiatric injuries. Almost no one will ever receive compensation and be eligible for work damages claims. And what I have not seen, and have not been made publicly available, and it's an area I work in, is any information about why the legislation has not done more to address the inflow into the system, which actually would have a much greater effect on limiting those with mild injuries that might resolve more quickly, and focusing solely on what we see as being extremely punitive against people with really quite severe injuries.
Brilliant. Great answer.
Pretty conclusive.
Well, I'm glad you
all right.
I could go on if you want. But
okay, I think that does bring us to time. Thank you very much for coming along and providing your expert advice. I will check. No one piped up to want to answer in addition, but if you did have something you wanted to say and I've not given you the chance, please do.
No, I do think that as a GP we would always say we need prevention rather than cure, and any attempt to stop workplace injuries would be wholeheartedly supported by us.
Here. Okay. All right. On that note then, we will now take a break until 1:45. Thank you very much for attending. Committee Secretary will be in touch in relation to further questions. Thank you. Welcome back. We now welcome our next witnesses. If I could ask each of you to please state your name and position title and then swear either the oath or the affirmation. I'll start on my left.
Thank you, Chair. My name is Louise Cadby. I'm the Co-Vice President of ARPA New South Wales, and I'll take an affirmation today. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
My name is Noni Byron. I'm the ARPA New South Wales President, and I'll take my oath. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Excellent, thank you. And would you like to begin with a short opening
Yes.
statement?
Firstly, thank you on behalf of ARPA for having us today to participate in the inquiry. The Australian Rehab Provider Association, also known as ARPA, represents over 90% of workplace rehabilitation providers within New South Wales delivering return to work services to support workers with injury or illness. All workplace rehab providers delivering services within the New South Wales Workers' Compensation Scheme are accredited by the State Insurance Regulatory Authority and must adhere to strict professional standards, including minimum return to work performance benchmarks, holding relevant allied health qualifications, maintaining membership with professional associations, and demonstrating compliance with regulatory and legislative requirements. Our membership brings extensive experience in vocational rehabilitation, particularly in supporting individuals with psychological injuries to achieve return to work outcomes. Workplace rehab providers operate independently and collaborate closely with general practitioners, psychiatrists, psychologists, counsellors, social workers, insurers, legal representatives, unions, brokers, employer groups, and most critically, workers with injury themselves. Our unique positioning in industry is that our membership work on the ground with all stakeholders in scheme to facilitate recovery and return to work. Our workforce is mobile, attending to referred workers at home, in the workplace, at medical or allied health practices. We have a direct interface with stakeholders and are the conduit to supporting the worker achieve meaningful recovery in return to work in a sustainable manner. This unique position enables ARPA to offer insight into the practical challenges and opportunities across stakeholder groups within the scheme. ARPA supports the New South Wales Government objectives to enhance scheme outcomes and ensure scheme viability. However, the approach to how these changes are made must consider the risk to workers of some of the most vulnerable participants in the scheme. One of the most significant concerns of ARPA, both within the current legislation and proposed amendments, is the impact of adversarial processes for workers with primary or secondary psychological injury. Our membership has observed an increase in self-harm and high-risk concerns for workers with injury. For example, workers may have capacity that enables a work capacity assessment and work capacity decision to be made. This does not, however, mean that the worker is void of symptomology or their diagnosed psychological injury. As such, we hear frequently of reported cases of self-harm behaviours, whether this be suicidal ideation or suicide attempts, where a reduction in benefits or change in claim status occurs. Often workplace rehab providers, and more specifically the rehabilitation consultants that work within the organisations, are the very allied health professions providing intensive support to ensure the worker has access to appropriate care and support at this time. Where an adverse decision has been made, the focus changes from delivering return to work supports to keeping the most unwell and vulnerable alive. With an understanding of some of the risk to workers in the current legislative framework, it is pertinent that future amendments consider the vulnerability of those with psychological injury, ensuring safeguards are in place throughout the claim to protect workers from further psychological harm as part of the claims management and/or legislative decision-making process. These safeguards are achievable through early access to medical care, assessment and treatment to facilitate recovery from psychological injury prior to and during liability determination, early return to work, workplace rehabilitation support,
Returning workers to full sustainable employment remains the most effective way to contain claims costs and meet the ethical and integrity responsibilities of the workers' compensation scheme. There is no substitute for targeted investment in early effective intervention and workplace rehabilitation to improve return to work and recovery outcomes. Consideration of independent pre-liability psychological assessments conducted by suitably qualified and experienced psychologists to ease the burden on psychiatric independent medical examinations. For further recommendations are continuity of care and support at 130 weeks where a worker may not meet the WPI threshold, with an understanding that many workers we support are very unwell and are not at the WPI threshold identified in the draft amendments. We further recommend review of SIRA-approved psychologists, counsellors and social workers' fees, acknowledging many are exiting from the scheme due to administrative burden, financial impact on business and negative stakeholder interactions, questioning the value of their profession and their clinical opinion. And ensuring at all times suitably qualified and accredited allied health professionals are supporting workers with psychological injury, ensuring no further risk of psychological harm. Our unique role, working in the field with workers and all other stakeholders alongside our allied health qualifications and clinical experience, enables us to share today our observations, learnings and recommendations to enhance scheme outcomes whilst safeguarding the most vulnerable members in the scheme. Thank you.
Thank you. I'll start with the opposition.
So how many members do you have?
How many members do we have? It's a really good question. So the membership is nationally with ARPA, but the members that would sit easily within New South Wales would be upwards of 60 members, and they are made up of workplace rehabilitation providers with different numbers of FTE staff within each organisation.
So at what point in the process are you engaged on behalf of the worker or the insurer? Are you engaged by the insurer or the worker? The insurer or the employee?
So we're engaged by the insurer. The referral will come from the insurance company, but the way in which a referral is instigated can be choice of worker, so a choice made by worker. So the worker may select their workplace rehab provider, which is their legislative right to do so. The employer may have a preferred workplace rehab provider based on quality of service delivery, assisting those individuals to return to work, or the insurer may choose the workplace rehab provider.
And you charge a fee for the service you provide, obviously?
Yes.
How do you work that fee out?
The fee is a gazetted fee that's given to us that we all abide by through iCare.
So what's that currently?
$233.67, I think it is, but I can take that on notice and come back with that one. $216.33.
There you go.
Per hour.
Per hour.
The quicker you get people back to work, do you get any bonuses for any quick rehabilitation? Get people back into the
not
workforce?
Bonuses as such, but we're certainly encouraged to meet the requirements of the deed and encouraged to return as quickly, safely and effectively as possible.
Yeah. So do your members sign contracts with iCare or with the actual individual insurers? Who's your contract with?
Some providers are under the iCare deed, so that's a contractual requirement. Other providers choose not to go onto deed or aren't accepted onto deed. So there are what we call deeded providers and non-deeded providers in the scheme.
And the non-deeded providers, they would then be engaged by the case managers, would they?
Sometimes through the insurer, but oftentimes through employers as well.
Through the employer. So just talk me through the process. The claims manager contacts you or one of your organisations for the purposes of managing a claim?
Most often they would send us a referral, yes.
Yeah. So at any one time, how many claims would you be managing?
That would depend on the size of the organisation and the number of employees within each organisation. We can probably talk to caseloads by rehabilitation consultant, but each provider would be different based on the size and volume of their workforce.
Right. Have you got any idea about the average cost of a rehabilitation program per employee who returns to work?
At the front end of the claims process, it would be considered to be a successful claim if the worker had returned to work within a 26-week period for a same employer claim, and ideally at a cost of under $5,000.
In relation to that, what's your success rate in relation to psychological injuries, or what are your members' success rate? You may not have this data. Success rate for return to work in 26 weeks for psychological injuries.
We'd have to take it on notice on behalf of the members. I think we could talk individually for our organisations in saying that we're successful in returning to work, people back to work with psychological injury above the SIRA benchmark requirements. It's also noting that workplace rehab providers aren't shared collective data across all workplace rehab providers delivering services within New South Wales. So we will know our own data, and iCare and SIRA and the CSPs will be aware of our data, but we don't have access to other people's performance.
SIRA has conducted a review of the rehabilitation providers, has it not?
Correct.
Has that review become public, or are you aware of the terms of that review? When was it completed, are you aware?
We've been involved in that review, both of us individually and through ARPA. We believe it's been completed and we believe the results are imminent, but we haven't been provided with them as yet.
Do you recall when it was finalised?
I believe March 2025, but I would not be confident of saying that absolutely.
So in terms of the manner in which that review was conducted, was it a focused review in terms of the manner in which rehabilitation providers were actually getting workers back to work, the programs they had in place, the potential work health and safety issues attached to providing rehabilitation services?
It was looking at the effectiveness of providers in the scheme across many factors, yes.
Including costs?
Costs,
it would be costs, return to work outcomes,
duration,
services. Also just the interaction and the efficacy of workplace rehab provision in general.
One of the things we've heard in the media today yesterday and today, is in relation to disability services and the impact of large premiums on disability service providers, and potentially some of those disability providers facing insolvency as a result of workers' compensation premiums. Have you got any insight in relation to the specific aspects of disability providers relating to the work health and safety around disability workers?
I think that would be outside of our area of expertise. Apologies.
Well, it would be within the, I suppose, scope of the rehabilitation services you provide in circumstances where you're providing rehabilitation services to the disability industry, would it not?
We wouldn't have the interface in terms of the claims cost to that disability industry. We would only have the interface in terms of the individual worker and their supported recovery and return to work.
Well, in relation to their supported recovery, do you have any observations to make in relation to the particular manner in which disability workers are being supported in their workplace and the risks related to being a disability worker which attracts to itself an additional workload or alternatively stress or psychological injury with being in that workplace?
Don't think we'd have the scope across the industry. No, I think we certainly deal with individual claims for disability support providers, specific to their individual workplaces, but I don't know that we.
What are the risks in the disability industry?
I couldn't speak to that, Mr. Tudor-Hope. I think that's outside of my area. I'm sorry.
Would it be within the scope of one or other of your members who would be, in fact, providing rehabilitation services to one of those industries?
We would be able to talk to the risks that we see in the nature of the types of injuries that occur within the disability sector, like we would be able to, for example, with first responders or within health. So if that's the question that you're asking around what the risks workers with injury are faced with, we can talk to, I guess, the work health safety risks they're faced with, but we wouldn't be able to talk to anything additional to that.
I may formulate some questions later. At what stage in the process are you engaged?
Ideally, as early as possible. We tend to
I
get.
agree with that. That was my next question. But on average, when are you generally engaged?
Ideally, When? I can't speak to the whole of scheme from that perspective. We certainly encourage CSPs to refer as early as possible, and in fact our recommendation is usually that if a worker hasn't returned in the first 4 weeks of a claim from date of injury, that we would encourage our involvement so that we can get the best outcome possible.
So how often are you engaged within the first 4 weeks of a claim?
Not as often as we would like.
Can you take that on notice and potentially from the data available to you, provide us with evidence about the manner in which early engagement of rehabilitation providers is part of what claims managers are requesting? It's the claims manager which contacts you? Is that the general process? The claims managers engage you for the purposes of a particular worker?
Yeah, they'll make contact with us, and as Louise described, generally speaking, that will be through a referral made, and then contact is established with the case manager.
Do you have a role? Can I just ask this? Do you have a role in assessing work capacity for individual workers, which you then share with the claims providers?
So the role that we would have is in the assessments or the workplace rehabilitation service delivery that we're delivering to that worker. So one of the components of supporting a worker returning to new employment would be to conduct a vocational assessment. The primary goal of a vocational assessment is to identify options suitable to a worker for them to be redeployed into new employment. That document in itself can be utilised for work capacity assessment.
Thank you for coming along today and for your submission as well, which was very useful. I just wanted to talk. I've had some people tell me some horror stories about rehab providers, and those stories seem to focus on the fact that a rehab provider is hired by the insurer rather than the worker, and that there is an incentive really for the rehab provider to pass back to the insurer that the worker is well before they're well. What do you say to, I guess, to that sort of allegation that the rehab providers are sort of agents of the insurer and incentivised to basically almost spy on the worker?
I think we'd respectfully refute that. I think we are all allied health professionals. We operate within our clinical justification. We all have codes of conduct against our professional associations that we operate under, and we advocate heavily for the workers as well as other stakeholders in the process. But ideally our goal is for a safe and durable return to work, and we are not incentivised by bonuses to get somebody back earlier. Our goal is safe and durable, suitable employment for the worker.
So in terms of having, I guess, that relationship with the insurer then, under the agreement with the insurer, how much information can be given by the rehab provider about their patient or the worker back to the insurer?
So I guess probably taking a step back if we go back to the referral process, contact is then made with the worker, and an assessment will be conducted as the first port of call, where we obtain informed consent around what we can obtain and release around that individual. It needs to be related to their injury, and it needs to be related to their rehabilitation. So whether that be the treatment that they're undertaking, an assessment of their workplace, and supported identification of duties, feedback from their treating health professionals, so a psychologist might provide feedback. So really the best way I look at workplace rehab provision is that we are the information gatherers of medical information from the employer, and the worker, and that information is then being married up in reporting and shared with the insurer.
Right. So for example, when people tell me things like they went to see a rehab provider, they had a psychological injury, but on the day that they went to see the rehab provider, they were having a particularly good day. They managed to get out of the house. They went and saw the rehab provider, and then the rehab provider had written the notes. Actually, this person's not that sick, and then that then led to an insurer then denying ongoing payments. That is in line then with, I guess, what you're saying around, we might not call it spying on them, but there is an information flow then.
There's an information flow, but it's not our role to comment on the wellness of an individual or whether they're presenting worse or better. Our role is to be a conduit in sharing information from the GP, psychologist and psychiatrist. So we're not to cast aspersions around whether a worker is or isn't well, or isn't feigning injury. That's not our role. It's sharing the medical information at hand to facilitate a recovery and return to work plan.
Isn't there a sort of inherent, no, not even a conflict of interest, but if the rehab provider is dealing directly with the injured worker, and has that responsibility and that relationship with the injured worker, but then doesn't really owe a duty to them, they're owing their duty to the insurer. Do you think firstly, do you think that's well understood by workers, but do you think that that's adding a layer of potential ethical, murkiness to the situation?
Ms. Boyd, that all of the stakeholders within the scheme, medical professionals, treatment professionals, employers and ourselves, all provide information to the insurer based on what's occurring for that worker at the time within the claim. And so I think that needs to be taken into consideration. It's contextual. All of the stakeholders are part of that.
But the other stakeholders owe a duty to the worker rather than being employed directly by the insurer.
Yeah. My comment to that would be that the perception is that the perception is that we're delivering a service for the insurer. We're delivering a service independently for the worker to support them with their recovery and return to work.
Thank you. Mr. Latham.
Thank you very much, Chair, and thank you to the witnesses. I'm just wondering if you can give us an outline of the main difficulties you face in this area of psychological injuries and getting people back to work. One of the constant themes of our inquiry is that, to use what I suppose is a cliche, that there's an X-ray machine for the back injuries, but there's no real accurate X-ray machine for the human brain as yet.
I think that there's many challenges that we observe. I think one of the largest challenges that we have is small to micro employers who may have, for example, one claim that comes through and that's their only experience with a claim, with limited knowledge of how a workers' compensation claim runs and the supports that they need to deliver. So that would be certainly one area where it's placed upon us to provide that education and support to employers to support their workers with their recovery and return to work.
Probably the access to psychological treatment, the delays that were alluded to earlier today, is certainly a factor in the return to work process, and we find that wherever those delays exist, it can sometimes hamper recovery and the return to work process.
Yeah, I suppose the other variable in this space, if you've got a physical injury, Like I've got a broken meniscus at the moment. Well, it's there until the doctor fixes it. But these psychological injuries, people can be up one week, can't they? Down the next. It's much more fluid, isn't it, than a physical injury?
It can be. It can be. I guess the point around early assessment and early treatment sets an individual up for the most success with their recovery. And it's really dependent on the psychological diagnosis and whether somebody moves through that more fluidly and quickly, or whether it's more sporadic or up and down in nature. So it really sort of speaks to probably some of the conditions that we're alluding to, a more chronic conditions such as PTSD, which can fluctuate more so. And then we see other individuals come through with, say, an adjustment disorder, with early treatment and workplace rehab provision. They're back at work within a short period of time at that 12 to 13 week mark.
Right, and generally you try to send people back to the job that they used to have. Like, with the experience I've had with umpteen people making representations because of this inquiry, is that people have popped out of the system because of some bad person, bad incident, bad treatment of them. And when I say to them, where do you want to go back? And I say, you go back to your old workplace. Oh no, the bad people are still there. So, but then if it's moved to a different job, is that taken as a sign of defeat and adds to the trauma?
Not at all. I think the role of workplace rehab providers is to intervene early, to be on site in the workplace and facilitate breaking down of some of that interpersonal conflict, if required, between the employer and the worker, to try and smooth that process and negotiate, communicate, and try and break down some of those barriers. And where there are the more minor psychological injuries being reported, it is possible to be able to facilitate that return to work and break down those communication barriers and those conflicts earlier. And wherever that is the case, that's our goal. Of course, there are some more serious injuries where that's not feasible, in which case we try and, as early as possible, redirect into a new employer goal so that we can utilise that worker's transferable skills into a similar job with a different employer and do that efficiently for their own mental health. Oftentimes, if it is something specific to that workplace, it's just as easy and faster to be able to redirect that away from that workplace, but use their skills with a similar employer.
Perhaps you could take this on notice. I'd be interested to get some data on what proportion of people you send back to their old workplace successfully and unsuccessfully, like, it collapses a second time, and what proportion of people go to a new workplace successfully and unsuccessfully. Would you be able to give the committee that data?
We would take that on notice, yes. Do you mean specific to psychological injuries, Mr. Latham?
Yeah. PI, this inquiry really is about PI. And what about the role of resilience? One of the modern trends, I speak against it in the Chamber, of course, is employment on the basis of diversity and other immutable personal characteristics, rather than resilience. Like, I'd love to be a prison officer. I think this was my lost calling in life, and I've got a colleague who did it for one day, and he said, well, they throw their urine at you, they swear at you, they tell you what they've done to your mother, what they're going to do to your pets when they get out. It's a really, really horrible work environment, being a prison guard. But we've got 30% of them in New South Wales out on psychological injury workers' comp. We mustn't be testing for resilience, surely. If you're a softer, kinder, gentler person, you wouldn't be suited to that work, even if you got all the personal characteristics that fit DEI employment. So isn't this a big thing, just getting people in the right fit for these tougher jobs in society?
Up to the employer to determine the characteristics that's best suited to their workforce.
But you must see this. You must get people who popped out to being prison guard. They didn't like having urine and thrown at them and being sworn at all day. I'd get the big baton out and whack them right over the skull. But if that's allowed. So, you must see it all the time. I see people who just weren't suited to pulling dead bodies out of a car as a paramedic, or a police officer going in to cut people down who've hanged themselves. This is a real factor, isn't it? They just weren't suited in terms of personal resilience and toughness to that line of work.
I guess because we're seeing individuals post the event, we don't have a baseline measure of what that, to sort of refer to, we don't have a baseline measure of what that individual presented like and their resilience levels prior to. So when exposed to a traumatic event post-injury, people present themselves in a really different way to how they may as part of that recruitment process because they've been faced with that trauma. So I guess that's probably all we could really comment on in that regard. But understanding that we're seeing individuals post-injury and we're sort of not seeing them prior to that time to sort of assess level of resilience. It's more impact of trauma and also what we know of an individual's lifestyle factors and what's happened for them through their livelihood as well, which has led them to where they are.
Good point. Hard to get the baseline. Maybe the resilience was sucked out of them in that work environment bit by bit. Anyway, one good thing about the Latham Two Dates amendments, there's a provision in there. I mean, employers say, oh, we've got too many claims. Well, they do. The one area where they can really help themselves is make sure in terms of if it's tough type work, the resilience profile fits the type of work. And we've got something in there to help employers make it a bit easier in that regard, that if they and their staff are going into this highly resilient type of job and they've made a mistake in that regard, well, you know, perhaps they shouldn't have the same rights of claiming as those in other circumstances. So thanks for your time today and thanks for your answers, and I look forward to that material on notice about the breakdown.
Thank you. Thank you.
Thank you. Government questions.
Thank you, Chair. Just only a few from us. Obviously, I've got a crude understanding of what takes place with rehabilitation of a physical injury or drug rehabilitation. I must plead ignorance, and please excuse my ignorance, but could you give me a flavour of what's involved in the rehabilitation of someone who is suffering from a psychological injury, psychological workplace injury? So I suppose from the point of Mr. Tudorhope's question of when you're engaged by the claim service provider, what does a day-to-day work for your membership look like?
I'll take you through what a referral would look like. It's the easiest way. There'll be variations up and down between different individuals. So an individual will be referred to our organisation. We will then make contact with that individual and arrange to conduct an assessment with them. Generally speaking, with primary psychological condition, we'll meet with that individual outside of the workplace, and there's a variability. If they're fit for work, we may meet with that individual in the workplace. If they're not fit for work or too unwell, we will meet them either in offices of where workplace rehab providers work or at the worker's home if they're too unwell at that point in time. We'll undertake an allied health assessment of where they're at, factoring into consideration feedback from the medical health profession. So we'll assess the individual. We'll then go and meet with the GP and conduct a medical case conference with the worker and the GP to gain an understanding of exactly where that individual is at. So what is their diagnosis? What treatment do they require? What is their prognosis with treatment? What will work look like? When are they able to go back to work, and how can we support them with that? Where they have a treating psychologist or psychiatrist, we'd be making contact with those treating health professionals to obtain information from them with the same types of questions, confirming diagnosis, treatment, prognosis and return to work considerations. Outside of that, we're interfacing with the employer. So we're speaking to the employer around the duties that that individual was performing prior to their injury. And we marry all that information up over that time to then work out when that individual can go back to work and what duties they can perform and what conditions are there in front of them. And again, that might be they're returning to their original employer, or we may be planning for new employment down that way. But probably more to that point, we're out in the field, so we're seeing all of the stakeholders face to face. Yeah.
It seems for a lay person like me, there is a real complexity to the process, and that you're corralling the employer, claim service provider, GPs, psychiatrists, psychologists, and presumably in such a subjective area, there'd be a fair bit of professional disagreement, would there, or between between the medical professionals, the GPs, psychiatrists. How do you find the?
Often it's more that each stakeholder has their view or their opinion of the status of that particular worker or claim, and it's often our role to bring those differing aspects of information to the table. We often see ourselves as sort of the central coordinator to make all parties aware of all of the information, of course with consent, and make sure that we present or propose a return to work plan that essentially meets everybody's goals, the worker, the employer, in line with collaborating with the medical professionals and treating professionals. So it's not about us presenting our opinion, it's about bringing all the information together and trying to navigate and coordinate a path that works for everyone.
Given all the moving pieces and the complexity, I haven't come across too many workers who have found the experience to be positive in the system. That's no criticism of any one party, it's just a very complex process. Would it be fair to say that we should only be bringing the most complex care, the most complex injuries into the system, and potentially keeping as many people out of the system if we can, if they have a capacity to work? I suppose I'm asking, do you support commutations, for example, that would allow workers to deal with things on their own terms in a more structured way that suits them without getting into the complexity of a system like this?
I guess commutations and that's really outside of the scope of our expertise. I guess what we know is that individuals with a diagnosed condition with early intervention and support to return to work, that's where the most success occurs. So I don't think it's sort of out of the scope of our expertise to talk about commutation.
Okay.
Yeah.
There's a submission that the committee's received, and we haven't had an opportunity to cross-examine it, but I'll take it at face value from, bear with me, the Workers Insurance Association of New South Wales. And they've said, and I quote, fewer than 10% of claimants with psychological injury are certified as having any work capacity at initial assessment. In our experience, this is not because they lack any work function, but because the environment around them has not yet supported recovery. Is that an assessment that accords with your experience?
It would not be unusual for a worker with psychological injury to be unfit at referral. Certainly we know that to be the case. Of course, there are others that present with work capacity and they're certified for some type of work on referral, so it is certainly a mixed bag.
In terms of this idea of the environment around them not yet supporting recovery, presumably that includes the work environment. I'm interested as to why there is such a disparity between return to work rates in the psychological injury space and the physical injury space. What do you see as the greatest impediments to improving those return to work rates, specifically with respect to psychological injury? I know you've raised concerns already with respect to micro-employers and their capacity to deal with things. And access to psychiatrists. Are there any other things that could be done by way of reform to improve those return to work rates?
I think certainly if we compare to physical injury, it's much easier for some employers to be able to compare and contrast the level of function of the worker with the duties that they have within their employment, and so it's more visible and therefore easier to understand. And I would suspect that employers with psychological injury claims may have less understanding of what types of employment they need to provide to be able to support that worker, but that's where we come into play to be able to help them to determine what might be suitable for that worker. To answer your question about what barriers we think exist for psychological injury, I think there are many, and it depends on the severity of the symptoms, the diagnosis at the time, what level of treatment and and medical treatment and psychological treatment has been put into place. I think there's many variables there.
You've spoken already about the importance of early prevention. If one of the mechanisms available to a government were to, I suppose, try and reduce delayed decision making with respect to some of these injuries, presumably that'd be something that you would welcome.
Yes.
Thank you, Chair.
Thank you. Any final questions from anyone else? No.
I'll just ask
go
this.
ahead.
I'll just ask this. One of the observations made by the Bar Association was that, in fact, a lot of money spent on the rehabilitation providers is, in fact, money which could be better spent because not so much in relation to, I suppose, the coordinating of reports from doctors, but the vocational capacity reports. Did you see that observation that they had made?
Yes, we did. Yeah.
What's your response to that?
Well,
clearly you disagree.
The multiple responses to that. I guess there was one commentary in there around non-qualified or inappropriately qualified individuals. So I just wanted to make a point there that we're regulated by SIRA and we have to have appropriately qualified allied health professionals that they nominate to conduct those vocational assessments. So they are registered psychologists, provisional psychologists and rehabilitation counsellors. So they are the only allied health professionals required to conduct those assessments. So I thought that was important for the record. The cost of those assessments sit anywhere between $1,800 and $2,400, depending on whether we're also going to attend the GP with the worker after the assessment to discuss the vocational options that we've identified and the appropriateness of those medically. So I think that's an important part. The second part to address, and I guess the vocational assessment for workplace rehab provision predominantly is to support a worker to identify what job options they can perform moving into new employment. It's not, the reason we're doing them is to support that individual to either return to work in an alternate position with their same employer or to obtain new employment. So that's the purpose of why we conduct a vocational assessment, but an insurer can use that document to formulate a work capacity assessment at any time. So I think the purposeful nature of the VOC assessment for us as workplace rehab providers is to support in a placement of somebody into a new role or a similar role with their new employer. But I guess just to make that point again, that the insurer can use that as one part of evidence for a work capacity assessment, not the sole, it's not necessarily the sole document that they're utilising.
We would like to point out as well, Mr Tudorhope, that the costs outlined in previous submissions could be considered a very small aspect of a whole claim cost. In fact, could be considered to be 2 or 3 weeks' worth of wages, and so we don't consider that to be excessive.
There was one other point to make there around the costings of workplace rehab provision. There was a note there that workplace rehab provision can cost up to $30,000 to $40,000. We just wanted to make a note there that there will be outliers where some individuals require more intensive intervention over years' period of time based on their wellness, and it would be expected that those individuals with the right levels of support would be more costly, but they would be outliers in the service delivery that's provided by workplace rehab provision.
Certainly not the norm.
Thank you.
Thank you. Thank you very much for attending and providing your evidence today. To the extent that questions were taken on notice or there are supplementary questions, the Committee Secretary will be in touch. But that brings our session with you to an end. Thank you.
Thanks so much.
Are we missing a witness? Okay. Thank you all. I understand that we are missing a witness, but what I will do is proceed with getting you all sworn in, and when she arrives, she can be sworn in subsequently. So if I could start on my left, if you could state your name and position title, and then swear either the oath or the affirmation.
Certainly. My name's Adele Sutton. I'm the Head of Policy at the Council of Small Business Organisations Australia. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
Mike Summerton, Head of Industrial Relations for COSBOA. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Thank you.
Chris Gatfield, Director of Government and Industry Affairs for the Australian Hotels Association. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
Simon Sorday, Director of Government Affairs at Clubs New South Wales. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Joanne Eade, Legal and Risk Officer for Clubs New South Wales. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Mm-hmm.
Daniel Kikarowski, New South Wales Branch Director of the Pharmacy Guild. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Pepe Rasa, New South Wales Pharmacy Guild Director. I solemnly and sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Lynn Conley from the Australian Childcare Alliance New South Wales. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Thank you very much. That is all of you. Would anyone like to commence by making a short opening statement? And again, I'll start on my left.
Yes, we would. I'll defer to my colleague, Mike.
Thank you, Chair. Good afternoon. I'm here representing COSBOA to outline our position on the proposed amendments and the critical impact on small businesses. Just to clarify our position for what COSBOA supports, we support several key reforms in this bill that we believe will bring much needed clarity and protection for employers. First, the narrow definition of compensable psychological injuries. The new legislation proposes to limit these claims to specific, objectively identifiable incidents, acts of violence, criminal conduct, witnessing serious injuries or conduct formally found by courts to constitute harassment or bullying. We believe this provides the certainty that small businesses need. Second, the statutory definition of reasonable management action. If employers act reasonably and in a reasonable way, their actions will be presumed not to cause compensable psychological injury, and we believe this protects the legitimate interests of business operations. Third, requiring formal tribunal findings for harassment claims. Psychological injury claims from bullying or harassment will only be compensable, it is proposed, where conduct has been formally determined by a court or tribunal. We believe that this prevents speculative or frivolous claims, and we support this on behalf of small business. Finally, the exclusion of work pressure claims, while still providing 8 weeks of medical support, recognises that normal business pressures, particularly for small businesses, shouldn't automatically become compensable claims. We do, however, strongly oppose some aspects of the proposed legislation, which talk to the massive benefit increases proposed in this bill. Death benefits are proposed to jump from $750,000 to nearly $956,000, an increase of 27%. Equally, maximum weekly compensation rises by 40%, and permanent impairment compensation increases by 28%. COSBOA believes that these increases will have a detrimental impact on small businesses through premium spikes. The bill also removes certainty around excess payments by shifting them to regulations rather than guidelines, which we believe create an unpredictable financial obligation upon small employers. COSBOA's view is that as part of this bill, we recommend that a small business premium protection mechanism ought to be in place, capping year-on-year premium increases for small business at 5% for businesses under 50 employees. We also see any benefit increase, if it's required, phased in over a longer period of time, not immediate, and over a 3 to 5 year horizon. We also support the need for a small business mental health support program, providing practical tools and templates for small businesses to help them manage psychological injuries if and when they do occur in their workplaces. And most critically, we need clearer reasonable management action definitions, although we do support the concept of reasonable management action, but in particular we seek for it to be recognised that small business has realities different from larger organisations, where owners can give direct feedback, make immediate operational decisions, but in some circumstances cannot afford formal HR procedures or access to employment lawyers or HR managers. Small businesses, as you know, employs over 4.7 million Australians. We support worker protection, but these reforms must recognise that a 5-person cafe operates differently from a multinational corporation. We see size-based definitions to protect informal, direct management styles. We see safe harbour provisions for good faith management decisions. The current draft, while containing good elements, risks pricing small businesses out of the workers' compensation system entirely. We urge the government and the Parliament to implement recommendations to ensure these reforms protect workers without dramatically increasing the costs of the small business sector that drives our economy. Thank you, Chair.
Thank you.
Thank you, Chair, and thank you for the opportunity to appear before the committee today. I represent the Australian Hotels Association, which does exactly what it says on the packet. I'll try and keep this short and sweet. AHA New South Wales supports the meaningful reform proposed in the bill, as well as some of the amendments proposed by the opposition and the crossbench. We're not here to support any one side of this political debate, but we are here to support good policy. The workers' compensation framework in New South Wales is a renovator's delight, and we support reform and the intent of the bill on that basis. It's clear from the trajectory of premiums and the increased frequency of psychological injury claims in particular that reform is needed. We recognise that the current scheme is under significant pressure and agree that changes are needed in order to make sure it remains sustainable, fair and efficient for all stakeholders, those being employers, workers, insurers and the community. Our members want to see a system that delivers timely support to injured workers while also providing certainty and affordability for businesses who do the right thing. We welcome the bill's intent to improve financial viability and address systemic issues, and we appreciate our engagement with many members of the committee on this already. We look forward to contributing constructively to this inquiry and to supporting reforms that restore confidence and long-term stability to the workers' compensation system in New South Wales. Thanks.
Thank you.
Chair and members of the committee, thank you for the opportunity to appear before this inquiry. The flaws in the New South Wales workers' compensation system have created serious challenges for the club industry. More than 90% of our members reported that they will need to cut back on employment or community donations if their premiums increase by the projected 36% over the next 3 years. But what I do want to focus on in this opening statement is those clubs that pay far greater premiums due to the substantial compensation claims. We have seen countless examples of clubs paying hundreds of thousands of dollars because a worker has exceeded the 15% WPI threshold for a psychological injury. These clubs all try to support the person's rehabilitation, including by offering them other meaningful work within the business. For many of these WPI claims, no reasonable person would think it's fair for the club to pay such a significant amount. One club reported that a worker was assessed at 22% WPI despite studying full-time and continuing to run her own business. Our submission describes a regional club that has paid $500,000 through higher premiums to a worker assessed at 24% WPI. That was because the club scheduled training on a day that the person didn't work. For a small bowling club, these costs will send the business broke. Yet the threshold for a person to claim these substantial payments is far too low. The WPI threshold urgently needs to increase to ensure that the system rehabilitates workers and supports their return to work while reserving significant lump sum payments only for severely impaired workers. This bill will go a long way to improving the workers' compensation system, and for that reason we support the bill and particularly raising the WPI threshold to 31%. Thank you once again.
Thank you. Anyone else?
Joanne?
Yep, please
Daniel.
go ahead.
Yeah, thanks, Joanne. You're not speaking. No. Chair, members of the committee, thank you for the opportunity to appear as the New South Wales Branch Director of the Pharmacy Guild of Australia. There are over 2,000 community pharmacies across New South Wales, and each one of those is a small business. They are often family-owned, locally staffed, and deeply embedded in the communities that they serve. Our members play a vital role in the state's and nation's healthcare system, and they take their duty of care to their staff very seriously as they take their duty of care to their patients. We support proposals to fix the state's workers' compensation scheme. These reforms are urgently needed to improve protections for genuine psychological injuries, fast-track claim assessments, and curb insurance premiums. The members tell us that increasing premiums are placing pressure on their businesses. We believe that it is possible to create a sustainable and fairer system that both supports workers while removing structural flaws that currently reward extended absences and discourage recovery. The changes should return the scheme to its intended focus on rehabilitation, return to work and prevention. Reforms should strike the difficult but critical balance of supporting injured workers with dignity and fairness while remaining financially sustainable and operationally effective for employers and the public. Members of the Pharmacy Guild tell me that the current trajectory of the scheme is unsustainable. We're already seeing rising insurance premiums, slow claim processing and mounting deficits. For many small pharmacy businesses, this is becoming untenable, and if premiums continue to rise unchecked, there will be choices that need to be made by those small businesses, including the unfortunate options of staff reductions and reduced community services. We believe that reform is necessary to ensure the system can continue to function for the years ahead. The bill includes several sensible evidence-based provisions that we welcome. We see the importance of having a workers' compensation system that functions predictably, affordably and fairly, and we want our members to be able to provide fulfilling, secure employment and not to be driven to reduce staff hours or forego hiring because of unpredictable premium hikes. Not acting on reform will harm both workers and employers. Delaying any changes would risk greater damage to the system and its capacity to serve those most in need. On behalf of our members, I would like to ask for certainty and urge you to progress reforms with appropriate safeguards and monitoring to restore confidence in the workers' compensation system and to protect jobs and services across our state.
Chair, members of the committee, I'm a community pharmacist, self-employed small business owner. I operate the Cincotta Discount Chemist in Wirral, a southern suburb of Wollongong. I'm also a proud member of the Pharmacy Guild of Australia and serve on the New South Wales branch. I'm here today not just as a business owner, but as an employer, a healthcare professional and a member of this local community. We support workers' compensation. Our staff are the heart of everything we do. They are our greatest resource. Our pharmacy assistants are often the first point of contact for triage for people who are sick, vulnerable or scared. We understand the pressure they're under, and we support a system that helps them if they get hurt or experience trauma at work. But I'm also here to say that the current system isn't working. Workers' compensation premiums have increased significantly in the past few years. This financial year alone, we've seen an increase of over 8%. Guild New South Wales members report that our claims are taking too long to process, and the unpredictability of the system makes it harder to invest in staff, expand services, or even stay open in some cases. For small pharmacies like my own, this isn't an administrative issue, it's an existential one. Some of our colleagues report in regional areas facing premium increases of up to 40%. Others are avoiding hiring new staff because they're worried about the long-term financial risks if a claim arises and due to on-costs associated with workers' comp. That's not a healthy system. That's why I support the reforms. These reforms are a necessary reset and a way to stabilise the system before it collapses under its own weight. If we don't act now, we're going to see cuts to services with a reduction in hours of community pharmacies and the support that is far worse than anything being proposed here. The current approach leads to long delays, legal disputes and uncertainty for everyone. We need a system that is clinically focused, transparent and faster. I believe these reforms are a move in that direction. At the end of the day, this is about balance. I want to look after my staff, but I also need to keep the doors open of the business. I want to employ more people, not fewer. I want to invest in mental health training and flexible working arrangements. But I can't do that if a significant component of the revenue goes to rising insurance costs and drawn-out claim processes. This is a tax on business. My understanding is this bill isn't about cutting corners. Rather, it seeks to build a system that works for injured workers, for small businesses, and for the public who rely on services like ours. Chair, I thank you for your time and for the thoroughness of this inquiry. I urge the committee to support a responsible, evidence-based path forward and to ensure the final legislation reflects the realities faced by employers who care deeply for their staff and their communities.
Thank you. Ms Connolly.
Thank you for the opportunity to present today. My name is Lynn Connolly and I'm the President of the Australian Childcare Alliance New South Wales. We represent over 1,600 early childhood education and care services across New South Wales that operate long hours, with some operating as much as 24/7. Professionals entrusted with the education, care, development and safety of our youngest Australians. As such, early childhood educators and teachers are vital to all early childhood education and care services, and how we look after them is of paramount importance to us. Currently, the existing workers' compensation framework can leave us as employers vulnerable to vexatious psychological injury claims when we take necessary and lawful action to address serious performance or conduct issues. Too often we see industrial relations disputes morph into medical issues. This is because it is arguably the path of least resistance for an employee to preserve her or his income. This is also alarming in the contemporary context of the allegations of child abuse. When a provider suspends or terminates a staff member's employment in response to such allegations, often in line with mandatory reporting obligations and child protection protocols, said provider may be met with a workers' compensation claim for psychological injury. And consequently, these claims can result in significant premium increases, even though employers have acted responsibly, legally, ethically, transparently, and in the best interests of children. The public expects and rightly demands that we as early childhood education and care providers act swiftly and decisively to protect children. Yet the current workers' compensation system penalises us when we do. To give you an example of the dire situation we as early childhood education and care employers face, I will tell you of a conversation I recently had with one of our members who told me that in February an allegation was made against an educator who used excessive force on a child. The provider spoke with the said educator and explained that she would be stood down until thorough investigation could be carried out. The provider notified the authorities and proceeded to carry out the investigation, which began with viewing the CCTV footage, followed by speaking with other educators who substantiated the claim. The provider called the accused educator to set up an appointment to discuss the issue, informing her of her right to bring a support person with her. At said meeting, the educator proffered that she had reflected on the situation, named the child she thought it was about, confessed to her behaviour, and expressed remorse. The educator declined to offer to view the CCTV footage, saying that she knew she had done what she had been accused of. The provider had no choice but to terminate the educator's employment. The following week, said educator attended a GP and claimed stress, saying, and I quote, "I was falsely accused of hitting a child. After an investigation, no evidence was found to support this claim. Despite this, my employer chose to focus on an unrelated CCTV recording, which did not indicate any wrongdoing, and terminated my employment the following day." Said statement is simply not true. And this was confirmed later by the Department of Education when in their investigation report they said, "The two allegations have been substantiated. A formal caution regarding these incidents has been placed on her file." In addition, verbally, the department investigator confirmed that the educator had admitted guilt, expressed remorse, and was undergoing further child safety training with the Department of Education. This workers' compensation claim has now been declined following the completion of a factual investigation, but the educator has been paid workers' compensation payments for several months, including a notice period after the declination date, as it had to be investigated by the insurer, even though the evidence proved that she had made false statement to the GP. There are many other cases brought to our attention. This is why the Australian Childcare Alliance now strongly urges this committee to support this bill. The proposed amendments to the legislation to protect employers is a critical step toward restoring fairness and balance in the workers' compensation system. It recognises the unique responsibilities of us as early childhood education and care providers and ensures that those who act in accordance with performance and management protocols, child safety and child protection obligations are not unfairly penalised. Ensuring all children have the most effective and best skilled early childhood educators and teachers should never come at the cost of punishing those who will protect them. Thus, we strongly urge you to support this bill.
Thank you. Opposition.
Thank you, and thank you all for coming. I could probably spend 20 minutes with each of you just to explore some of the suggestions which have been made, but I'll start with you, Ms Connolly.
Yes.
Do you think this bill solves the problem that you've identified?
Well, the current situation, as you read about in the media all the time, and we as educators are terrified, we have to do, by law, we have to do staff appraisals. Yep. So if we do a staff appraisal and somebody is, not that they're injuring a child, I don't mean that, but they need to lift their game in certain areas, you know, quite often it turns into a workers' compensation claim of mental health issues.
I understand that, but the question is this. If you strengthen the employer's position in relation to reasonable management action, would you eliminate the problem which you've identified in your opening statement? If you gave stronger defences to employers to be able to rely on reasonable management action?
Well, I think so, because if it becomes adjudicated by the Industrial Relations Commission as proposed, well then that takes it out of the hands of somebody just trotting off to the doctor and saying da-da-da-da-da,
So the point I think you're making is, though, that much more needs to be made of an employer's right to be able to conduct their business and do it in circumstances where they reasonably manage their staff. And
Absolutely.
In circumstances where there is an allegation of potential child abuse, that should constitute reasonable management action, which in fact should be something which would prohibit a workers' compensation claim. Is that correct?
Absolutely.
Thank you. Can I just now go to the pharmacists in relation to... Your chief concern is the rise of premiums, is it not?
Correct.
Chief concern?
Correct.
And that chief concern relates to increasing premiums?
That's right.
So if there was a system in place which would effectively retain the workers' rights in relation to their workers' compensation claims, but in fact make other changes to the legislation which had the impact of reducing premiums, would you support that legislation and those amendments?
We'd need to look at the legislation.
Well, there are amendments which have been provided to the committee. Have you looked at those amendments?
I haven't seen those amendments in particular that you're referring to, but if looking at the bill, the redrafted bill with amendments included, if they did reduce premiums to a reasonable level or reduce their increase.
So if the actuarial analysis of those amendments was very much in line with what the government is proposing, but at the same time retaining the benefits available for employees,
our primary concern, as you said, has been rising cost of premiums for our members.
What is the workers' compensation industry classification for pharmacists?
I'm not aware of what that is.
Would you agree with me that it's about 1.35% of payroll?
Oh, I see what you mean.
Percentage-wise, I'm not aware of the full percentage myself. I can't speak.
It's about 1.35%,
if you say so,
of payroll. So in the circumstances you're a low-risk industry, in many respects, there are some industries where it's 6% of payroll and higher in relation to the manner in which their premiums are assessed. So you're a low-risk industry. But if in fact, by making amendments to ensure that reasonable management action plans and better definitions relating to harassment, what constituted harassment, were put in place for the purposes of ensuring that this was a more workable bill for the purposes of ensuring premiums were driven down, you would support that, would you not?
As I said, if we would have to look at the amendments and have to look at the new bill.
And if that was the government's analysis of the amendments, you'd have to struggle to disagree with that analysis, wouldn't you?
Whether it was the government's analysis or not would be irrelevant. It'd be our analysis.
It'd be in the members' interest, Mr. Tudhope. In the end, we're talking about a system that's broken. Yes, our concern is rising costs, but also the sanctity of the actual processes as well.
Correct. Exactly the same.
We've heard exactly the same situation here with the childcare. Our members are relaying the same thing.
Yeah. And I think it's the position of COSBOA, is it not, that in respect of the provisions relating to a great number of the complaints that COSBOA face is in circumstances where a claim is made for compensation in circumstance where the employer says there's a reasonable explanation for what I have done. Is that the case?
That is the case, yes.
Yeah. And that's their chief concern, is it not?
It is a concern, yes,
Yeah.
primary concern.
Primary concern, because often you don't have the HR capability of being able to, for small businesses, to be able to deal with that as expeditiously as potentially bigger employers are able to do. That's also a concern, is it not?
Yes, it absolutely is a concern.
So having early intervention with a view to return to work programs, that's often not available in the same way as larger employers. Is that the case?
That is the case. Yeah. We don't have access.
So a system which addresses those issues rather than taking away the rights of very seriously injured people, you'd agree with making those amendments if there was a reduction or downward pressure on premiums, would you not?
Well, again, I think that's a hypothetical.
But if it was the case?
I'd need to look at what's proposed. I understand that you put amendments to legislation put forward, but I'm not privy and haven't had a look at those amendments at this stage.
Well, then I'll go back to my primary position. Do you agree with that if in fact there were amendments which were put to safeguard reasonable management action plans, is that something that you would embrace?
Conceptually, yes.
Thank you.
But we need to see the detail.
Mr. Gatfield, the AHA are generally self-insurers, are they not?
Majority self-insurers, but it's a slim majority.
It's a slim majority, but is there much of a
specialised insurers, I should say, rather than self-insurers.
Okay, specialised insurers. So is the return to work rate for the specialised insurers better than, in fact, the non-specialised insurance industry?
We are very proud of hospitality industry insurance. We have the best return to work rate, I believe, in New South Wales.
Why is that?
93% of our injured workers return to work within 13 weeks.
Why is that?
We, as an association, provide quite a lot of training, particularly in the WHS space, and we ensure that the members that we cover are well trained and equipped to provide a safe workplace that prevents injury happening in the first place.
And in fact, that's a bit of the key, is it not? The WHS environment in which the members are conducting their workplace environment?
I believe we would agree furiously with the public comments of the chair, in that preventing injury is, absolutely the number one issue for us in a workplace.
And do you agree with me that reasonable management action plans are really a bit of the key to what the employer concerns are in relation to workers' compensation claims for psychological injuries?
Along with exponentially increasing premiums for our industry, yes.
Well, to the extent that the reasonable management action plan management action is not successful, that contributes to long-term and pressure on premiums, does it not?
Yes, it does.
Yeah. So if in fact there was opportunities for the employers, your members, to be able to rely on reasonable management action, you would say that is in many respects all the things that you want to see achieved for a much fairer workers' compensation scheme for psychologically injured workers.
I think it would be fair to say that the AHA believes that we can walk and chew gum at exactly the same time, and that if you're going to reform the front end of the scheme, there's no reason why you should not reform the back end as well.
Well, if in fact the evidence was that this bill, the evidence of the psychiatrist was that this bill places too much emphasis on the back end and not enough emphasis on the front end, you'd be saying, would you, or agreeing with me, that we should be putting more emphasis on things we do at the beginning?
As a non-psychiatrist, I'm not entirely sure that I can make that assessment, but look, I agree. If there is reform to be had in this space, we support reforms to make the scheme more equitable, more transparent, and ultimately, hopefully, more financially sustainable.
And I put to the Pharmacy Guild, if in fact that you could make amendments to the workers' compensation scheme without removing workers' rights in the manner that this bill does, you would embrace that, would you not?
We'd have to see the details of the bill. I think I echo everyone else's feedback on that. But conceptually, if there are amendments that can be made, yes, we would support them.
Mr. Sorday, how many people have you ever met with a 31% whole of person impairment by way of psychological injury?
Thanks for the question, Mr. Tudor-Hope. I don't ask people that I meet what their WPI threshold is. I don't know the answer to that.
Have you ever been told of anyone who has been an employee of Clubs New South Wales that they had a 31% WPI?
Not that I'm aware of, but I haven't spoken to the large majority of our workers throughout our organisation's history.
And yet you support a WPI for to be established to, in fact, deny workers' rights until they get to that level of impairment.
We've spoken to a number of our members, Mr. Tudor-Hope, who have experienced...
Two you told us about.
I gave two examples in the opening statement. We've spoken to a lot more than two, probably closer to 7 or 8 of our members who have experienced claims where a WPI above 20% was recorded, and in each of those instances there were sufficient grounds to say that the club should not have been liable to pay the significant sums of money.
Well, one of the cases you identified, in fact, was a case where there was a complaint again about the person being rostered on for a day when they were unavailable. Is that the case that you identified?
That example was provided in our submission.
Wouldn't that be a reasonable management action which should be identified and give the employer an opportunity of rejecting that claim?
If I could just clarify that, Mr. Tudor-Hope, what had happened in that particular case is that training was organised on a day that the person wasn't working, and that particular worker alleged that that was bullying because the training she had wanted to perform was organised on a day.
Well, isn't scheduling of training a reasonable management action?
Well, in terms of when you're scheduling for an entire workforce, it's sometimes going to be the case that someone's not going to be rostered on that particular day. I wouldn't say that that's bullying action.
No. So I've heard that case said a couple of times. Do you have are you able to provide us with the name of that so that we can look it up ourselves?
That case, as I understand, did not go to the Personal Injury Commission, so it's not public, and for privacy reasons, I don't have the details of the club in front of me, and for privacy reasons I can't provide that.
To be fair, it does sound a little bit fantastical. Is there a way that you can substantiate this? Because you have used it a number of times as some sort of evidence that's been put up there as a sort of bogeyman example. We really do need to know that that's actually what happened. Particularly, you refer to 24% WPI. These are quite specific, serious allegations you're making. Do you have any backing for that?
We're representing our members who are registered clubs across the state, and in appearing before this inquiry, we clearly want to give evidence that will support the committee to understand the impact of these reforms on the ground, given that our clubs are at the forefront of dealing with the workers' compensation system. And I have qualified in the submission and in my opening statement that we are speaking to our members, and our members are giving us examples.
But it would be quite irresponsible to come to a parliamentary inquiry having made those same statements elsewhere in the media to also put them in your submission to this inquiry without having checked the veracity of that claim, wouldn't it?
I don't. We have not put those statements to the media.
Well, you have. They have been put to us then. Let's talk about it in terms of providing misleading information to this committee then, because it is put today in your statement. It's something that I've certainly heard said by Clubs New South Wales before. Are you able to say that that is actually correct, or is it just hearsay and something that was just written in or whatever into your statement today because you felt that it would have some impact?
I am able to say that we've spoken to a number of our members for the purpose of providing information to this committee to support your inquiry, and that I have relayed to this committee some of the case studies that our members have provided to us, which we hope will support the committee in inquiring into this bill.
To be fair to you then, if you could perhaps provide on it, because it's a very serious matter when you're providing evidence to a parliamentary committee, if you could provide on notice exactly how you got that information and who that came from, just so that we can have some comfort that work was done by you before you provided that as evidence to this committee. If I could ask you, Mrs. Connolly, the case that you were referring to, I'm aware of a very similar case where that claim was actually denied. Are you saying that that was not denied in this case, that worker did receive that workers' compensation?
Well, it was denied in the end, but it was after months of the person being on workers' compensation.
Right, but it was denied in the end.
And I can get the evidence for that if you like. I've spoken personally with the provider and she's happy to give it to me.
But it's certainly not your evidence here today then that we are faced with a choice here between either protecting children from sexual assault in childcare centres or passing a bill that would sentence seriously psychologically injured people to a life without support, correct?
Well, the point is, this woman said because there was she had to have a discussion with her about the injury to the child.
Yeah.
It turned into a workers' compensation case.
But
it's not always about that. It's about we are required by law to do staff appraisals.
Yeah.
We look, you know what's going on out there.
Yes, but I also take the point on the reasonable management, and I'm sorry to rush you. I fortunately have very little time.
But we are concerned about this 15% being too low and being used too carelessly. We have to protect the children.
Okay.
And we have to do these studies.
If I could turn to you, Mr. Rasso, is your premiums set by iCare, or are you part of the Pharmacy Guild's self-insurance, or sorry, I don't know if you're self-insurer or specialised insurer?
Specialised insurance.
Right, so you're not part of the pool of businesses that needs to worry about the premiums as set by iCare?
As I understand, iCare doesn't set our
No, iCare doesn't set your premiums at all. It's interesting that this letter that was distributed, this joint media release from Clubs New South Wales, AHA New South Wales, the Pharmacy Guild and ACA are predominantly businesses that don't have their premiums set by iCare, yet you collectively saw fit to come out trying to argue that this reform was necessary to reduce premiums through iCare. On what basis do you think that was a fair way to proceed? Does anyone want to speak to that? Perhaps you, Mr. Sorday. I noticed that you put in here increases up to 36%, and you repeated in your opening statement over the next 3 years. Given that premiums are set at 8% for the next year under the previous government direction, why do you think that there's going to be an extra 28% in the following 2 years? Where'd you get that figure from?
I understand that the government's estimate is that premiums would increase 36% over 3 years due to the volume and the cost of psychological claims. And like all industries, our members are affected quite significantly by those premium increases.
Yeah.
If a not-for-profit club needs to pay more money in premiums, it means that they pay less money to hire other staff, that they pay less money
For your
to support the
information,
local sporting
I do
team.
understand that the government has given a bit of false information as well. It's not 36% when you consider the 8%, but I will let you off on that one. And apologies for being so quick, but it's limited time. I will go to Mr. Latham.
You're on.
I think you're on mute, Mark. Still on mute.
There we go. Could I just ask everyone on the panel, do you believe that the problem you've got with the existing laws, not the bill, but the status quo as it stands today, is that it's way too easy to get a claim up? A lot of these, especially for small entities, are nuisance claims that automatically drive up your premiums, and that's the main thing we need to address in this process of legislative reform. Please.
Well, I'll start first. Yes, I agree, Mark. And not only does it drive up premiums, but it also affects our clients. And with ACA New South Wales, it's children that are affected and their families who are, got to have their children cared for and educated while they work. So for us, it's a yes.
Is there anyone who disagrees with that proposition, that it's way too easy to get a claim up at the moment, and this is a major nuisance to scheduling workers on timetables, and of course when you've got to handle these claims and the premiums go up? Does any? So I'll take it that we've got a bit of consensus on that. Does anyone believe that the Mookie definitions in this bill at subdivision 2 could be tightened to make it more realistic and stop these nuisance claims being made? Let me just give you an example. Say someone asks a woman out for a drink and she's offended by that. Under the meaning of sexual harassment, she can make a claim. Am I wrong in saying that? Sexual harassment in relation to a worker means a person who makes an unwelcome sexual advance. Not 3 or 4 times, but just once. I don't know, maybe some people don't like going out for a drink, don't ask for dinner or whatever it is, or they don't like the joke that was told, or they don't like being told, that it's a nice dress. So do you think that's a low bar? Just once can be an unwelcome sexual advance and trigger a claim, just like the nuisance ones you have right now?
I think that's a level of detail that I'm not across what the legal interpretation would be of the proposed amendment, and it would be very difficult for us to put a position forward on that basis, Mr. Latham.
Well, I don't know. It's the bill that you're here to talk about as part of this process. And what about racial discrimination? Part of it is nationality. Nationality is not race. Of course, in our nation we have scores of different races and people of ethnic background. And if you insult or offend someone in the eyes of the worker, they can lodge a claim. So do you think this is a low bar? To say you've got someone who's a Kiwi working in your club or your small business, and you tell them a Kiwi sheep joke, perhaps in bad taste, because of their nationality, New Zealander, and they're insulted and offended, they can lodge a claim. That's a very low bar, isn't it? Anyone think that's going to work out for you in practice? That
well, I haven't come across that, so I can't
Irish,
comment.
English, Kiwis, Indians, Chinese, who take offence at a well-meaning joke that missed, are going to be insulted and offended and lodge a claim against you?
Well, I haven't come across that, Mark, so I can't comment.
Well, it's in the bill. It's possible.
No, but I mean, I haven't come across.
What about the pubs and clubs guys? You must get this all the time, surely.
Mr. Latham, we don't shy away from the fact that psychological injuries can and do occur in any workplace, including in the hospitality industry, and that genuine workplace-caused psychological injury that prevents a person from working again should be compensable. However, I think the issue is that it's currently extraordinarily subjective as to what extent a psychological injury was caused by events that actually happened within the workplace, whether there were pre-existing conditions that might contribute to that. And generally the onus at the moment is on the employer and or their insurer to disprove that the injury was work-related.
I would concur with that statement.
Right, well, I'm glad you read that out. But Simon, yes, bullying matter you had up in the club on the mid-north coast, the woman who didn't work on a Monday, the training program was scheduled for the Monday, and she said it was bullying, that she was excluded. In the meaning of bullying here in the Mookie bill, if that happens twice, so it's repeated, she's still got the claim against you. Don't we need to toughen this right up, where there's an intent to intimidate and, strong-arm someone? That's the meaning of bullying, to make them submit to you. Bullying in real life, as opposed to Mookie fantasy world, is bullying to stand over someone, intimidate them, to make them submit to you, to submit to your will, rather than just a couple of incidents where they think the behaviour is unreasonable. So you're still going to have the problem, aren't you, if she's invited a second time on a Monday and she'll still lodge the claim?
Yeah, Mr. Latham, we want we want to make sure that our members who do provide a psychologically safe workplace environment, as many of our members do, and they follow their policies and procedures, that they are not liable for claims where the club bears no responsibility.
Yeah, I'm talking about nonsense claims. I mean, everyone wants a safe everything in this world, but there's a real world out there, pubs and clubs. You know, let's face it, they're knock-around places in many respects, the last bastion of Australian working class larrikinism, and God love them for that. But to say that because a couple of times you missed out on the training program on the Monday, or someone told a Kiwi sheep joke for which you felt insulted, or someone asked a woman out for a drink, asked a man out for a drink. And, you know, these are very low bar definitions. So I just put it to you, the Mookie fantasy world ain't helping you much. Thank you.
Thank you. Yes, your time did expire, unfortunately. We will go to government members.
Thank you, Chair. You may not have this information to hand, but if you can take it on notice, just interested as to what currently the rates are that your members pay for their workers' compensation premiums as a percentage of your wages. Perhaps you've got that on hand, but if you don't, is it something you could take on notice?
I'm happy to kick off. I believe 2.6%, but in the interests of not misleading the committee, I will take that on notice and come back to you.
Okay, thank you. As we've discussed, premiums have already gone up by an average of 8% this year, and some of you have spoken about the impact that has had on your membership base. We have received evidence from the Treasurer that the scheme is currently running at a $6 billion deficit. It is currently got 78 cents in the dollar for current and future liabilities, and that to restore the scheme to some sort of long-term financial sustainability, we will not only be looking at the 8% that's arriving in 25-26, but two 12% increases beyond that, which will have a compounding effect of 36% for employers. Now, we have heard evidence from the former Workers' Compensation Independent Review Officer, who stated, and I want to get your response to this, that increase would certainly be cheaper than getting a common law policy with Lloyd's. If you're an employer, you're getting a good deal. The answer is hello. If that is the financial position, your premiums have to go up. I'd like your reaction to that, but also the impact that a 36% compounding increase in premiums would have on your members.
Well, with a point of order in relation to that.
You'll hear the point of order.
Other than COSBOA, each of these members are not covered by the insurance scheme which you've identified that the Treasurer has identified. Their ability to comment in relation to the impact on their insurance premiums is zero, because they don't set the ICARE does not set their premiums.
To the point of order, I'm happy to hear the response from COSBOA, but this goes to structural reforms of the workers' compensation benefits as a whole, which will have impacts on those that are self-insured and not within the nominal insurer.
I'll allow the question. Go ahead.
I'm happy to respond on behalf of COSBOA. Thanks for the question. Our view is that even the smallest business faces a dramatic increase in workers' compensation policy premiums of 28%. So even the smallest premium that's currently set at the moment is set to increase from $175 to $225, so that's an increase of 28%. The information that we have is that the average performance premium of a business is $30,000 or less, which, as I understand it, constitutes a small business insofar as ICARE is concerned, but that represents the majority of employers, New South Wales employers. So when you're looking at proposed increases in certain aspects of this bill of between 28 and 40%, our view is that those premium increases will obviously result in increases in the premiums that small businesses need to pay. and that money will need to be accommodated from other operations that the small business is currently performing. So, to your point, would we expect, as a result of everything staying the same, premiums increasing? Absolutely. Our view is that change is required for the reasons that we've previously stated.
Thank you. Now, notwithstanding that others may not be in a nominal insurer, these still go to structural elements of the scheme that are resulting in increased psychological injury costs in the workers' compensation framework. Do any of you have a view with respect to the threats that those pose to your premiums?
Well, I can say in relation to increased premiums, so my personal premiums have gone up 67% in the last 5 years, over the last 5 years. So if premiums go up again, which they are as predicted, we also, in the move, at least 80% of childcare centres across the nation, so we're talking New South Wales, so it's the same thing, have had their fees capped by the federal government due to the worker retention payment. So it will be impossible for them to pay these increases.
And I think the majority of our members, as we understand, have specialised insurance, but their premiums are going up at similar rates, so they've gone up 8% this year.
We have a club who's given us an example, a medium-sized club on the South Coast. Their workers' compensation premium has risen 66%, from $72,000 to $128,000. They've had 2 claims in the last few years. One cost them $80,000, but that was ended up being a birth defect, and the other was a bullying complaint where they found no wrongdoing by the club, but it was perceived bullying. So it's been a huge increase, and as community clubs, not-for-profit, that money going to insurance premiums results in less money going to the community for services.
Presumably fewer people you employed or your members employ?
We have conducted a survey also which would demonstrate that clubs are much more likely to have fewer employees and employ less people if their premiums continue to rise.
Mrs Connolly, does that apply in the childcare sector?
Well, of course, because we have to abide by the regulations. However, most services have extra staff on top because that's better for the children. But if it gets to the point where they can't do that, so the children suffer again. And that's how you get it right for the children, you get it right for the nation. And all these financial pressures, plus we've got capped fees by the federal government, what can we do? You know, you can't keep doing this to us. You can't keep doing it to the children and families. Parents have to go to work to pay the mortgage, cost of living. We know all these things. We read about it all the time. We need to be able to protect the children. We need to be able to look after our staff, but it needs to be sensible. We can't keep pushing.
So the government has choices available to it with respect to cost avoidance in the front end and the back end, as Mr Tudor-Hope has referred to. We've received evidence, again, that there are operational and administrative levers, certainly, that the government can pull. Those go with respect to claims management models, investment returns in the scheme, operating expenses, improving return to work rates. But the evidence that we have received is that compared to the multi-billion-dollar challenges, certainly in the nominal insurer, for those that it's relevant to, the savings are certainly helpful, but they are not going to change, they are not going to be game changers with respect to bringing costs under control. And so that will result in the need to explore changes to scheme design and structural reforms. We've received evidence that the single biggest element or driver that is causing the deterioration to the nominal insurer, if one can be specified, is the trend, and I quote, of ever rising whole person impairment assessments combined with the rising number of new psychological claims coming into the scheme. Do you agree with that assessment with respect to nominal insurer, but also with respect to your own insurers?
Yes, we agree with that assessment. And in research for today's hearing, the information that we have is that, albeit changes to the proposed definitions around psychological injury will have some impact and some benefit in terms of cost reduction. It's not the solution to all problems in terms of the scheme, But the fact of the matter remains, with the information that we have, is that the psychological injury claims as they stand at the moment comprise of around 12% of all claims, that constitute 38% of all costs associated with psychological claims. And the actual injury claim for psychological injury themselves has doubled from 1920 to 24-25. So if that trend continues, unless something occurs in terms of change to legislation concerning psychological injury, we can only see that there's going to be further detrimental impact on premium increases if nothing's done.
Our industry insurer, Guild Early Learning, has found the same situation with those same type numbers. The increases in
the
mental
influx
health
of people qualifying
mental health
with
claims.
The current threshold coming into your scheme.
Sorry?
Just the significant number of people qualifying for compensation because of the WPI threshold level. Is that the...
No, the number of cases, the number of claims has increased, but not necessarily when it works out are these claims legitimate is an issue as well. So we feel that that the level should be increased in fairness to everyone, and we feel that it should be a case for the Industrial Relations Commission to decide, not just go to the local doctor and tell the local doctor your little story and have him say, oh sure, yes, you know, mental health claim. It's not acceptable.
As a general proposition, would you all agree that reforms to the scheme should be centred on tilting the scheme towards those that are in serious need of compensation and medical assistance?
Proven serious need, yes. Proven serious need, that's the issue.
I think for us, representing our members' interests, it is, as has been identified earlier, primarily about reducing increases to premiums. I'm sure that there is a way that this committee and the Parliament can find a solution where premium increases are slowed or reduced at the same time as making sure that the safety net is there for the most seriously injured workers.
Thank you.
Thank you very much for attending and giving us the benefit of your insight today. To the extent there were questions taken on notice or supplementary questions, Committee Secretariat will be in touch, but that concludes this session. We will be taking a short 15-minute break and then we'll be back. Thank you. Excellent. Thank you. We are back. I now welcome our next witnesses. If I could ask you, starting from my left, to state your name and position title and then swear either the oath or the affirmation.
Yes, hello, my name's Tom Edwards. I'm the Research and Policy Officer at Unions New South Wales. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
Thank you, committee. My name is Natasha Flores. I'm the Industrial Officer, Work Health Safety and Workers' Compensation, Unions New South Wales. I will take the affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
Mark Morris, Secretary, Unions New South Wales. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. Would you like to commence with a short opening statement?
Yes, thank you, Chair.
Please go ahead.
Unions New South Wales and New South Wales Union Movement continues to oppose the bill in its current form. We believe it exacerbates the harm caused by insurance practices that choke the New South Wales workers' compensation system of funds, delay treatment, ignore complaints and hinder return to work. Instead of dealing with this area of waste and harm, the bill instead seeks savings by limiting compensable psychological injuries and raising the whole of person impairment threshold to 31%, forcing severely injured workers off the scheme and cost shifting to other service providers. Instead, we propose the government reform insurance practices to save money while promoting early intervention and return to work. Our submission identifies more than $332 million annually in savings by stopping the default adversarial approach taken by insurance companies, denying claims and delaying treatment. Evidence from the last hearing revealed the New South Wales workers with psychological injuries who gained access to treatment within 2 weeks see a 94% improvement in work capacity compared to those who do not. Yet, as our case studies demonstrate, insurers are using the scheme funds to run cases with little reasonable chance of success. While the government disparages injured workers, it does nothing to address the questionable practices of insurance companies. The financial benefits to early intervention are clear. Psychological injury claims which receive their first payments within 2 months have a 24% higher return to work rate and cost the scheme almost 20 times less according to SIRA data. Unlike the bill, our submission's proposal offers a more effective and fairer path to financial sustainability, one that does not rely on restricting care and support for injured workers, whether at the outset of the injury or after 130 weeks. Thank you.
Thank you. We'll start with questions from the opposition.
Clearly, it's good to see you back here again in the same for.
Thank you.
One of the components of workers' rights, which will be in fact impacted by the reforms, will be the removal of potential negligence claim against employers, which may be available to workers unless they have a WPI of 31%. Were you aware of that?
Yes. Yes.
Yes.
That's a very significant removal of a worker's right in relation to potentially improving workplaces, but also providing proper remedies for workers. Wouldn't you agree?
Yes.
So for someone who is potentially sexually harassed at work, to remove that right of a potential negligence claim against the employer, the evidence we heard this morning doesn't do anything to improve the workplace, but B, removes an entitlement for a very seriously injured worker.
Yes, I would agree with that, and I heard this morning's evidence, and I would share the views of the Bar Society. My concerns also lie with the impact that may have on general safety in workplaces and the incentives to make your workplace a safe workplace. Safe Work does what Safe Work can do, but they have limitations. But without that sort of stick, for lack of a better word, what incentive is there for a workplace to ensure that it is a safe workplace, that it does not tolerate certain behaviours? There would be a reduction, in my opinion, of any incentive if that were to be implemented or removed, as you say, yes.
Ms Morrie, you've identified in your statement an emphasis or an observation which probably is garnering a bit more publicity in recent times, that potentially the best savings for this scheme are better attitudes by insurers and claims managers. Do you want to identify some of the changes you say should be made in relation to the activities of the insurers and claims managers?
Well, I think there's the macro and there's the micro in this. The macro is self-insurers. What we see in self-insurance is people taking the best parts of the insurance scheme, or the best employers, and then iCare becomes an insurer of last resort and has all their claims that are long tail, hard to manage, and there's a real problem with the way in which that then skews, we believe, the insurance industry. We think that everyone should be in, and that way it spreads the risk across everyone more evenly than people being able to pick out the best parts of the scheme, privatise those, for want of a better word, while the government carries the can on the rest of it. At a lower level, and I think there's a couple of examples in our submission, where workers are injured, they want to get treatment quickly, and the insurance company will deny that treatment. And what we know is, as I've said, the sooner people get back or get treated, the quicker they return to work. And what we find, certainly with workers who we deal with and within our Injured Workers Campaigning Network, are people who, as soon as they enter the system, it's about defending your position, trying to prove that you are injured, getting sent around to numerous doctors, numerous specialists by the insurers. And then when a case is actually run at the Personal Injury Commission, these insurance agencies use the scheme's funds to bankroll their cases against the injured workers. And what we know, the pick is overwhelmingly about 91% of workers leave there with an improved situation, and I think it's around 71% outright win their cases. So you've got a system that's set up to grind people down rather than getting them back to work as soon as practicable.
So what I think you identify there is primarily the scheme is driven by an adversarial nature rather than having a return to work emphasis and doing what they should do to potentially identify opportunities to return to work.
And what we say, I mean, we've said it for a long time, is that the injured worker is not at the centre of the scheme. The scheme is not set up to focus on the injured worker and getting them back to work. It's set up, it's just drifted off into a nowhere land where people actually have to battle just to get through it. And as we know, we're talking about psychosocial injuries, but many people who get physically injured and go through the system end up with a secondary psychosocial injury because of how hard the system is to get through and its adversarial nature.
One of the things that, have you had an opportunity of reviewing the government's return to work strategy document?
I've been involved in that.
We've had a look at it.
I'm involved in those.
One of the things the government says, this is going to take potentially years before these opportunities actually flow through to improved workplaces and I suppose better handling of claims. Why is that?
Look, I think because the current status is so ingrained. I mean, look, I can give you a few examples of the frustrations that workers have experienced in trying to return to work in the public sector. and there were a few legal, I guess, barriers. So an example was a nurse who was told that she could no longer perform CPR. Now, she could do all of her other duties, and because of that, it was determined that she couldn't return to work at the hospital that she'd worked at, which in our view is ridiculous because she could do everything else, and you have a hospital full of doctors and nurses who can perform CPR. So in some instances, there are situations where a particular thing or task might be labelled as an inherent requirement of your job. And if you can't perform that particular task, you're deemed to not be able to perform your job. And this is a real problem in the system because as in that particular instance, this particular nurse was fully able to go back to work and do everything else. She just couldn't do CPR. So that was preventing her from going back to work.
So why doesn't the health secretary?
This is the problem. This is where the barriers are. The health secretary has to change that mindset and say, well, it doesn't matter that you can't do CPR. You can do all of your other tasks, and we'll put you in a hospital where plenty of other people can do CPR, and we'll acknowledge that you've got lots of other skills, and we will use those skills. But at the moment, this is not always happening. I mean, years ago, in another job I did, a teacher was deemed not to be able to perform the inherent requirements of her job because she couldn't do playground duty. Now, I trained as a teacher. Never once did I go to a class about how to do playground duty. But that was the court's decision. So the employer didn't want her back because they said, well, you can't perform everything. You've got to perform everything or we don't want you back.
Well, at the heart of the government's return to work strategy is the responsibility of departmental secretaries.
Yes.
That's at the heart of it.
Yes.
And to drive the sort of strategies. Health secretaries earn big money.
Yes.
Mm-hmm. Why haven't they got KPIs, for example, which says that if you are in fact not meeting your return to work KPI, there's a potential penalty attached to not meeting that KPI?
That's a good idea. Yeah. And I think we'd support that. And to be fair, the Minister Kotzes has displayed dismay at some of these scenarios and is quite appropriately outraged, that these people aren't getting back to work.
I don't question her dedication to this process at all, but it appears to me that if we are really serious about driving a return to work strategy in the public sector, then in those circumstances we ought to be, in fact, actually having circumstances where there are penalties for not reaching the goals which you actually are setting yourself.
And one of the biggest problems is that in the departments, they sit and wait out injured workers, literally sit and wait them out. And as Natasha was saying, if you can't fulfil the full requirements of the job, you can't come back to work. And we have been advocating for a number of years now. The question should be, what capacity have you got for work? And then getting that person back into the workplace, whether it's a day a week, a couple of days a week, but reconnecting them with that workplace and keeping them in contact with that workplace so that they can come back. But at the top, there isn't a drive and there isn't a defending of injured workers have a right to come back to work. They're seen as a problem. The number of departments we've had, and certainly advocating for workers, year, 2 years, just watching the department wait them out until they give up and go. Or they can
dismiss them after 6 months.
In 6 months. So,
well, that's an outrage.
The system is and there are no pressures on people to actually do something in the department. There's no penalties. No.
You're not going to agree with me in relation to this next question, but I'll ask it anyway. In respect of a provision relating to excessive work claims, you I know, don't like, you think that should be ahead of. Isn't excessive work claims something which is generally covered by most agreements that unions enter into?
No, because a lot of this excessive work claims. So when you've got you've got an agreement. You work 8 hours, right?
Yep.
You're assuming at the time you're working in that workplace, there are enough staff to do all the jobs that are required to be done. What we hear constantly are areas where there's short staffing, people are run off their feet, they don't get breaks, they work additional hours, and...
So what do you put in the enterprise agreement to cover that circumstance? You know that.
We do.
So what do you put in the enterprise agreement to cover that eventuality?
Because when you actually go to the systems to report it, say safe work, and you make a complaint, all you get is crickets.
But isn't that where we should be solving the problem?
Absolutely. Safe work should have some teeth and be able to be quite... Safe work hasn't done anything, in my opinion, for the last 14 years. I mean, people are getting killed on work sites. People are having injuries, psychosocial injuries, and you report it and they don't even turn up. They don't even turn up to the workplace. They don't even prosecute these employers. And I'll give you an example. When a nurse was killed in Balmain recently, a couple of years ago, Safe Work argued that they weren't going to do anything because it was a murder and it was a criminal matter. They didn't even go and investigate the systems of work that allowed a person to be isolated in their workplace, because they're out doing their job in their workplace, and they said, we're not going to investigate it. Now that's why we lobbied hard to be able to do prosecutions again, because Safe Work are not putting up any fight. There is no stick, and no matter how good our agreements are on paper, in practice, you can't enforce them a lot of the time.
And in the private sector, you cannot dictate to someone how many people they employ. So in the retail industry, for example, this is a huge problem, and the staff are very young. They are what we would actually call vulnerable staff, and they're running large department stores with very, very little support. That makes the customers quite angry at times, and sometimes aggressive, sometimes violent. So these young workers are dealing with this with very little support, and
no, I understand.
It's just it's a wild world out there in the world of work, and certainly what we see.
Thank you. Can I ask, the Premier on the 17th of this month said to a News Corp journalist on a video interview, quote, "None of our changes have any change or bearing on workers' comp physical injuries. It's solely on psychosocial injuries in the workplace," end quote. Is that your understanding?
No. There is a requirement in this bill that a worker meet some sort of means test. Now, it's not clear to us what that exactly is, if it's a financial means test. This is in relation to the ILAS scheme.
Mm-hmm.
So that would impact all workers, so physical injuries and psychological injuries. So I'm assuming that a worker would have to, well, firstly, there are a whole list of things that they have to, basically their case has to have merit. Mm. Now, that's already the case, but this just places more burdens on a worker to prove that their case is most likely going to succeed. There's a prudent person test, mm-hmm. and that test says, we need to look at whether the prudent person would spend their money on this case. That doesn't apply to insurers, but workers are now being asked to provide or to prove that their case is most likely going to be successful. So that would be all workers.
Okay.
There's also the introduction of "and" in the reasonably necessary test. So this would limit treatment, and
this is medical expenses.
This would be medical expenses. Mm-hmm. That would cover all workers, regardless of. It wouldn't be just physical injuries. Sorry, it wouldn't be just psychological injuries. It'd be physical injuries as well.
And
we
is
believe
that, sorry to interrupt, is that dust disease?
That would also
scheme
cover the dust diseases scheme. Mm-hmm. That's quite concerning because I sit on the dust diseases board. Part of our job as the Dust Diseases Board is to basically look at grants and look at research and research grants, and we're part of the process in accepting or giving those grants the tick of approval. And obviously there are medical people that are doing this as well, but in doing so, what I've learned is that we need to look for really innovative, novel treatments, because if you've got asbestosis or mesothelioma or silicosis, there are no cures. So we are looking for a trial, we're looking for a miracle, and we are looking at what is novel and what is new, what might be the breakthrough that we're looking for to give these people some hope.
So can we just break that down then for people playing at home? So we're looking at this bill changes the test under which people who are under the Dust Diseases Scheme, which is completely separate part and separate pools of funds to what we're talking about normally with workers' comp, it would change a person's ability to get treatment, make it harder to get a certain type of treatment.
I believe it would,
right.
Yes, because the reasonable and necessary test does change all treatment. So it does mean that a worker that we worked with years ago who had a psychological injury, a very serious one, and he was a Four Corners matter, went to Four Corners. Anyway, he was, for his psychological injury, he was doing a very unusual therapy of cold water therapy or something like that. Now, he said it helped him. Under this under this bill, I doubt he would have any access to that. But my main concern, or my big concern, is for the workers who are on the Dust Diseases Scheme, because they rely entirely on new treatments, trials, novel, experimental type treatment that isn't necessarily the norm, because the norm doesn't cure them.
Just apologies for going quick.
That's
I don't have very much time, but the other aspect of this bill that's been given a lot of attention from the Premier in particular is in relation to the definition of sexual harassment and bullying. What is the status quo compared to what the government's bill is going to do in relation to sexual harassment and bullying injuries, or psychological injury from sexual harassment and bullying? Are they making changes to make it harder?
It's undefined.
Yeah, I think. Look, it's probably. I think someone this morning said, we're just placing more complications into the scheme, and there will be more litigation and more arguments around. Well, what does this mean? So I have concerns that we are adding more complications to the bill or to the Act, rather than simplifying things.
Because the status quo is just you either have an injury or you
Correct.
don't.
That's it.
You
And
don't
it's
have to
not-
jump through that additional
Absolutely.
hurdle of
You
proving
have an
harassment.
injury and your doctor determines that. And, this is, as we say, we support medically informed care, and we say if the doctor decides that you've got an injury, whether that's because you were sexually assaulted, racially harassed, whatever, you have an injury. And I've always said throughout this whole debate, a hazard is a hazard is a hazard. And in the world of work health safety, a hazard differs. A chair can be nothing until you trip over it and suddenly it's a hazard. So in my work health safety mind, defining hazards is somewhat bizarre, because you don't do that in the health and safety world. You accept that this chair is fine when it's tucked under the table, but if it's left in the middle of the room, then it becomes a hazard.
Might just add with the issues that are deemed relevant conduct under the bill, so that includes sexual harassment and bullying. There's an additional step for a worker as well. They've got to go through the New South Wales IRC in order to defend their claim if it's denied by an insurer. So that's a new thing as well.
Something that government is proposing.
Correct, yeah. So the government did present the new bill post the exposure draft of being absent of a requirement to first go through the New South Wales IRC to make a claim. Effectively, that's maintained for sexual harassment, people who experience sexual harassment or bullying in the workplace, because you need to first go to the New South Wales IRC to have it determined that you've experienced sexual harassment, and then the insurer can still deny the claim. After that, they can continue to deny the claim, and then you have to go to the Personal Injury Commission after that. So there's multiple hoops that a worker would need to jump through, re-traumatise themselves along the way, no focus on return to work and rehabilitation during that process, and ultimately it keeps them on the scheme for longer.
Thank you. Mr. Latham.
Yeah, thank you, Chair, and thank you to the witnesses. One thing we haven't focused on, and perhaps I'm showing my age here, is a belief that governments should keep their election promises. It's an old-fashioned idea that if you make a promise, implement it, and don't break solemn promises that have been made. So can I ask Mark Murray, what's your understanding in regard to this legislation, and particularly the 31 WPI, Labor's election promise in 2023?
We're very unhappy, very disappointed, and I think I've said that to this committee before, that the Treasurer would seek to basically cut a whole lot of injured workers out of the scheme. It's a broken promise, and hence we have campaigned very hard over the last 3 months to try and turn this around with the aid of the Parliament.
And it's a promise you sought as the industrial wing of the Labor movement for people to sign a pledge before the last election. What was the process there? You just went around and a large number of the ministers signed, didn't they?
Yes, our injured workers campaigning network that we've had at Unions New South Wales for about 5 years put a plan together for the election, getting a commitment to ensure that the workers' comp was reformed for the better. And I think 20 of the current 22 cabinet people have signed it.
And what was that reform for the better? What was the detail of the pledge?
Well, it was around after 5 years not being cut off from support, and after 7 years not losing your medical supports. But overwhelmingly there was a commitment there, implicit in that pledge, that the government would look after injured workers.
And has the government given you any explanation as to why the pledge has been so horrifically broken?
No, I have been told that the scheme is in all sorts of trouble, and it's now a financial imperative, which is very disappointing. And I think there'd be bigger financial imperatives to address in the budget than cutting injured workers off.
Well, I can point hundreds of areas of wasted money. Boy, oh boy, it's going out of fashion, that one. And but do you believe this man Mookie, having terrorised iCare staff and made a public reputation for his work on committees like this and others in the iCare and workers' compensation space, surely he's got no excuse in saying, I got into government and I got a briefing that the insurance schemes were in financial trouble. He had advance warning of this, didn't he? He was actually waving the alarm bell, or ringing the alarm bell, years ago. Isn't that right?
I think the Treasurer was very active around the workers' comp space prior to coming into government. To say I am disappointed in moving to put this legislation up can't be understated enough, and I have voiced that opinion publicly, that the one thing a Labor government should never do is disadvantage injured workers, because it is if the union movement and the Labor Party aren't defending injured workers, I don't know who is.
But did Mookie talk to you before the election and foreshadow any of these changes with his knowledge that the schemes did have financial issues about them?
No, and in fact, I remember the last state conference where a number of industrial and workers' comp resolutions were put up by the union movement, supported, and went into the ALP platform. and they've walked away from that.
So do you see this now as a promise made only to be broken? They were never serious about keeping it?
I don't know. I see it as my role to educate the government and hopefully turn them around to coming to some common sense about this. That's my role now.
And you know, I've had decades-long association with the Labor Party in some interesting positions and roles. Even got a special plaque on my portrait now down there in Canberra. So, Mark, yeah, you know, I was never of the industrial side. I was from the branches. But even I can recognise it's a complete betrayal of Labor values that workers who are permanently injured wouldn't be receiving permanent income support. Isn't that just the core essence of one of the reasons the Labor Party, in fact, was established?
I believe that's the core fundamental, one of the core fundamental principles for the union movement and the political win, to be defending injured workers and ensuring that when they're doing some of the most difficult jobs in our society, some of the jobs that no one else wants to do, if they are injured at work, they should be protected and they should be assisted to come back to work. And if they're unable to come back to work, then they should be supported for the job they've done.
Yeah, well, I agree with that. I just think it's a core Labor value that it's unthinkable that you'd ever challenge it or ditch it in any shape or form. Anyway, people have got certain ethics and values that can change over time. But in terms of best practice, different Labor governments around the Commonwealth have had a crack at this reform challenge. What do you see as the better model, the Queensland one, which I think Mookie's imitating, or the Victorian Labor model, where you're trying to half close the door on the way in, but also for people who are genuinely injured, permanently so, they get permanent support?
The Victorian model now is very problematic, particularly around psychosocial. Whole groups of people have been cut off. I think for us, we've said for a while now that the scheme is fundamentally broken. We don't think WPI was never meant to be used in the way it's using in assessing injuries. We think the system needs to be looked at. It's broken and it needs to be fixed. We've got to stop tinkering around with this because more and more injured workers are staying in the system for longer. It's costing us more and people aren't going back to work. So I would think, given the history of the last 20 years, and this is the third time I've been through this workers' comp struggle, is that a tripartite approach, government, opposition and community, could get together and put a proper scheme together that looks after injured workers that we all rely on in our daily lives, many of them doing jobs we don't see, but are some of the most horrible jobs you'd ever have to do, such as child protection workers. And I think they're the people that we should be supporting, and we should be able to do it in a mature way and put our differences aside, at least for injured workers who, whether you're in government or opposition or back in government, you're actually employing.
Yeah, well said, and thank you for your time today.
Thank you.
Thank you. Over to the government.
Thanks, Chair.
Yeah, I'll be interested in this.
Thank you for your evidence this afternoon. There's obviously aspects of the reform that are causing a lot of controversy, but not all aspects of the reform I would have thought are as controversial. I might just seek your views on some of those elements. With respect to commutations, which you know, a mechanism to commute an ongoing entitlement to benefits into a single lump sum, is the introduction or the greater eligibility to commutation something that Unions New South Wales supports?
I think that's something we actually raised during the consultations with the government. We think there is an opportunity for commutation, certainly with the workers we work with, and being aware of the previous scheme. Sometimes there is an opportunity for a worker to leave the scheme. For want of a better explanation, they've had enough of it. It's ground them down so much that they would prefer to get a payment to separate from the system and just get on with their lives. And I think, you know, that's something that we should be looking at. I know there have been problems in other schemes where it's seen to be excessively using that provision. I think there needs to be safeguards around that provision. But if that provision is used appropriately, has the right set of requirements around it and is managed properly, I think it can be a good thing for workers sometimes to just get out of the system completely.
So we do have a recommendation regarding commutations as well. There is an issue with Schedule 3(6) of the bill, which gives SIRA the ability to trump the IRO in regulating legal fees. And the issue with that is the history of SIRA's involvement in that area is that they have been seen to deregulate legal fees, which could end up with workers having to fund some of their commutations into legal fees, and that could potentially undermine the benefit of the commutation and lead workers not to take up that avenue. You know, if you've got the opportunity to stay on the scheme and keep getting your weekly payments versus a commutation where, you know, a chunk of that's going to be taken out of legal fees, then you might make a financial decision around that.
Right, so, you know, if you were to take out ironing out the kinks with respect to executing it as a broad proposition, you'd agree that commutations provide greater choice, greater flexibility, and facilitate the departure of workers from the scheme at a time of their choosing or in a way that suits them.
Correct.
One other aspect of the broader reform package that I don't think is too controversial is the desire to fast-track decision-making, early supports, and greater prevention. I assume that Unions New South Wales is supportive of broader reforms to the Industrial Relations Act and the Safety Act that went through Parliament in the previous session.
Yes.
You're supportive of mechanisms with respect to the investments in workplace mental health prevention and the workplace mental health package that was part of those reforms.
Yes.
We are.
I assume that Unions New South Wales is also supportive of the workplace bullying and sexual harassment jurisdiction that's been created within the IRC.
Yes.
Could you speak a little to the industries that are most susceptible to sexual harassment, racial harassment and bullying?
The health industry is unfortunately very susceptible to sexual harassment. Unfortunately, nurses often have to deal with that on a daily basis. That's it's very common, and that's something that we hear very regularly in the nursing field. Unfortunately, it's becoming an issue in schools as well, where students are sexually harassing teachers. The unfortunate rise of the Andrew Tates and what have you on the internet have caused all sorts of problems in the education sector, and we're seeing that play out in younger and younger children, unfortunately, and teachers are having to deal with that. So that's a problematic area. It's unfortunately common in hospitality. It's also common in retail. And unfortunately for the hospitality and the retail industry, they are not part of the industrial relations state system, so they don't have any recourse.
Right. I think any position you're susceptible to it. I think whether you've got a forward-facing public position where the public some people just think they've had a bad day and they come in and tee off on you. I think in positions, white-collar positions, offices, these sort of behaviours exist all around the place, and they don't get called out enough.
Would you have a concern about any definitions or access to benefits for psychological injury caused by bullying, sexual harassment, and racial discrimination that might inadvertently or otherwise unduly inhibit claims to compensate for those injuries?
Well, I'd prefer to keep it as it is, where a hazard occur. You've been injured. There was a hazard, and it doesn't matter what that hazard was. The doctor determines that you've got an injury. That's the current status. that's where I'd like to see it stay.
The focus should be on treating that injury and rehabilitation.
I don't think I think if anything, it's going to cause further litigation, further costs in navigating new definitions and new systems where people will still get injured and they will still make claims, but there will be a new need to litigate and determine what the status quo is. I mean, changes have been made since the exposure bill, obviously, but I remember speaking to Shane Butcher, who was here earlier, and said he saw at least 5 years of litigation before things become settled. That's probably improved since we've had the second bill since the exposure bill, but introducing these new terms will create more litigation. And as I said, we also asked in our pledge that we said the scheme should be focused on doctor-led care. So the doctor is the specialist here. The doctor determines there's an injury. It doesn't matter how that injury happened. If it happened in the workplace because of a hazard, it's an injury.
Thank you. Mr. Morey, I'll just turn to you and your previous views about self-insurance. Mm-hmm. You've previously stated to the Standing Committee on Law and Justice that self-insurers can have a dramatic effect on the viability of the nominal insurer because, and I quote, the best bits of the scheme are out, the most profitable parts of the scheme out, and the business as well, that are self-insurers, are the ones that actually provide safe workplaces. Mm-hmm. You've restated aspects of that this afternoon. Just want to elaborate on those views and why you think that's the case. Do you have a concern about the cumulative financial impact of self-insurers and specialised insurers on premium levels for the nominal insurer, given it's a risk-based industry?
Well, as I said before, I think you're taking out the good aspects of the system. You're allowing insurers to take out the parts where there are limited claims, if any claims at all. So they're getting paid premiums and not having to provide any insurance. What then happens is the areas where there is a lot of problems ends up staying within iCare. And the risk, I mean, the whole idea of insurance is you spread the risk out across as many people as you can. Once you start taking parts of the system out, the risk you're spreading gets concentrated and a certain group of people are lumbered with having to pay for that. I mean, one of the things that we've said in our submissions, and it used to be up until about 12 or so years ago, if you were a good employer and you didn't make claims, there was a financial incentive because your premiums were reduced. We shouldn't be just talking about bad behaviour, we should also be encouraging responses for good behaviour and good employers who are doing the right thing. And if you're breaking the system up, you can't do those things because you just haven't got the scale. And so it's privatisation by stealth. People get to make a lot of money out of it because they're pulling the good parts out of the system, and the government ends up having to carry the can on the parts of the system that are most deleterious to the system.
Can I add to that too, that a lot of unions have said to us that what they find with the specialised and self-insurance is, firstly, it's a conflict of interest because you're insuring yourself. So there really isn't a great incentive to accept the claim against yourself. So they don't accept the claims because it's against themselves. They're admitting that they have not been a safe workplace. So they are incredibly litigious, most of the self and specialised insurers, and they deny claims all the time. And I've even had workers say to me, what's the point? I'm fighting against them on all fronts. And a worker will often just walk away. So they may look like they're a good employer, but they're just denying their claims because they don't want to accept their own liability.
just from a previous life and my experience with the process and the transparency concerning approvals of self-insurers, do you have a view with respect to the step-by-step process, the stakeholder engagement that SIRA conducts with respect to...
Yeah, look, I would say that SIRA has been quite transparent with us. One of the problems is we just don't have the resources to dedicate, or unions don't always have the resources to dedicate spending the amount of time that needs to be spent working with the employer and SIRA through that process. I've done it on a few occasions. It's extremely laborious. It takes a long time. It's not a bad process. It's a good process, but it's just labour intensive and requires significant resourcing from the union over a period of time to work with the insurer or the employer to get through the process. So not necessarily critical of SIRA there. They've been upfront with us, but it's just very difficult for us to sometimes be able to resource that as effectively as we'd like to.
I'm more happy to be critical of SIRA. They haven't been regulating properly, and they don't regulate the insurers. They need to do a better job around that.
I'm just talking about SIRA's insurance application process.
We're doing good cop, bad cop here.
Thank you very much for your attendance and for your submission. We do appreciate it. To the extent questions were taken on notice or the supplementary questions, the committee secretariat will be in touch, but that concludes our session with you today. Thank you.
Chair.
Thank you. Welcome back. Thank you to our next witnesses who have been here once before, so do not need to be sworn in today. On that basis, I will ask our representatives from iCare whether they've got a short opening statement at this time.
Thanks, Chair. We don't have an opening statement. Happy to take your questions.
Great, thank you. We'll go straight to the opposition.
We seem to be forming a wonderful and close relationship. Can I just ask this? When, Mr. Wersling, did you first become aware that the government was considering legislation to limit payments to people with up to a 31% whole of person impairment?
I'll try to answer your question, Mr. Tudor-Hope. The discussions on reform, I think, have occurred since the new government came to power. In the conversations that I've been in through the back end of last year, there was further discussions on reform. It's called a working party. A working party was established, was that earlier this year? Where the task force, where the details of that reform. So I would say, to the best of my recollection, earlier this year.
Well, when you say earlier this year, January, February, March?
Well, so to be clear, I wasn't part of the task force. So did you want to answer that, Mr.
Yeah,
Lee?
so Mr. Tudorhope, as part of my role, I briefed the government with regards to costs in terms of claims and cost pressures. So to Mr. Wesling's point, we've been talking about costs for quite some time. In terms of threshold and the threshold of 31%, that came about after the task force was formed. So it would have been late March, I would say.
So before then, what was the advice being given in relation to, or the modelling that you were being asked to do before that date?
We looked at the various cost drivers in workers' compensation, so both the increasing volumes of psychological claims as well as the threshold erosion. There were scenario analysis done around what the threshold could be, but there was a wide range that was done, so there was not a specific threshold.
So there were various models put to the government over that period of time?
I wouldn't say models. They were more just scenario analysis around the cost pressures and where the costs are coming from.
And when you say when you were dealing with that material, there were advices provided to the government, were there?
As I kind of started with the answer, I regularly provide advice to government around the cost in workers' comp and what's driving the cost.
And that was written advice, was it?
There were briefings.
Briefing notes and...
there were briefings, presentations.
Yeah, that you provided to the government. So if there were documents produced pursuant to a Standing Order 52, I should expect to find all those documents, should I not?
I can't answer that question.
Mr. Wesley?
I couldn't answer that question either.
Did you have any involvement in answering the Standing Order 52, which was directed to iCare and the government?
Well, I mean, a large number of people at iCare provided documentation for that Standing Order 52.
What work has iCare done since April 2023 on reviewing the list of presumptive cancers for firefighters?
We've done a few versions around the costing of presumptive firefighters. So in terms of costing advice.
You've done some work in relation to that?
Yes.
So again, if you've done work in relation to that, are there any documents that you've produced in response to the Standing Order 52 for the production of documents relating to presumptive cancers for firefighters?
We've done a search, but again, I'm not in a position to answer in terms of which bits of information is...
When you said you did a search?
So as per
there are documents which
yes.
evidence the work which you have done.
Yes.
I should expect to find them, should I not, in response to...
Again, I can't answer that question because I'm not familiar with the rules, and some of these could be considered cabinet in confidence.
Well, you're aware of that rule, are you?
Yes.
Well, was it a document provided to cabinet?
I don't remember on that front. It was provided for the purpose of policy, so I would assume so.
Have you done any work in comparing? Have you done any work in comparing the rules relating to presumptive cancers for firefighters with other jurisdictions?
Yes.
And that wouldn't be a cabinet in confidence document, would it?
No.
Would I expect to find that document amongst the documents to be produced pursuant to an order for under Standing Order 52?
If it was requested, yes.
So why wasn't it produced?
I'm not sure, Mr. Tudor.
Are you aware,
Mr. Tudor, we haven't seen what documents were.
Well, it was a standing order 52 directed directly to iCare. Why haven't you seen the documents, or at least an index of the documents that have been produced?
I haven't got that list, Mr. Tudor.
Where are we up to in relation to a policy formulation in relation to presumptive cancers for firefighters?
That's a matter for government, Mr. Tudor.
Have you provided any briefing in recent times in relation to that?
As I've said with my previous answer, I'm in regular providing advice to government around various cost matters.
When was the last time you provided advice to the government in relation to presumptive cancers for firefighters?
It's ongoing.
When was the last time?
There's a recent request that we're working on at the moment.
Sorry? A what request?
There has been a recent request that we're working on.
Recent being how long ago?
This week, I think.
This week? There has been a request from the government for you to do what?
Continue the costing work on presumptive firefighters' cancers.
And continuing means what?
Different scenarios being costed.
Haven't you already done that work?
This was a new set of scenarios.
A new set? What are those scenarios?
I think that's a matter for government. Again, I'm not sure about the rules around cabinet in confidence and whether I can talk through those.
And I've just refrained from taking a point of order, but I do question whether this line of questioning is consistent with the terms of reference of this inquiry, which is specifically in relation to the Workers' Compensation Legislation Amendment Bill and the examination of the Bill on business and economic conditions in New South Wales. I understand the substance of the questioning, but I do question whether it's...
I'm in fact proposing to move an amendment to the Workers' Compensation Bill to include presumptive cancers for firefighters.
There we go.
So what are the scenarios you've been asked to model?
I think, as I mentioned previously, I'm unsure I can disclose that given the cabinet in confidence. I can talk about it in general terms,
yes.
Looking at different combinations of eligibility and different combinations of cancers is what the work has always been on.
Yes.
Yes, that's kind of the various different scenarios we are working on.
Mr. Wesling, you'd be aware that there is a requirement to certify that all documents required to be produced pursuant to the Standing Order 52 have been provided to the Parliament, and that in fact certification was provided by the Chief Executive Officer. Were you aware that she in fact signed off on that certification?
I'm not involved in the final stages of that process, Mr. Tudor.
Can I ask you, we've had a significant amount of media recently in relation to disability services and home care services. What are the WICs in relation to the disability service providers?
Do you have those? Look, we haven't brought all the WIC codes. Yeah, are you talking about the
the WIC
rates?
codes, yep.
Are you asking which WIC codes?
Yep. Well, I'll tell you, the WIC code is 872910 in relation to home care services.
Yep.
And 872920 for non-residential care services.
What information would you like, Mr.
Well,
Chair?
what are the percentage rates for?
There are 500 WIC codes. I would have to get that information.
Can you take that on notice and provide me with that? If one of the issues which arises in relation to that are their premiums appear to be going up at twice the rate of other industries. What are the factors which are impacting on their increases in premiums?
Okay. I'll answer it at a high level, and maybe Mr. Liu can provide the detail. We look at the performance for each WIC code. So as I said, there's about 500 WIC codes that cover each industry, and the way we rate is based on the performance of those industries, and that's an attempt to maintain community rating but have industry rating within that. The drivers of that primarily relate to the claims experience and the expectations on that claims experience going forward. And we obviously calculate a break-even premium for each WIC code and then create the premium rate off the back of that analysis, which the actuarial team undertake.
So what are the risk factors which you've identified as to the disability service providers which have impacted on their increase in premium rates?
It's a credibility rating factor approach where we look at the individual WIC code's actual claims experience, both in terms of claims frequency as well as claims cost. But that is credibility weighted for the size of the sector. Some sectors are too small to be rated purely on their own claim experience, so then they're grouped up with like sectors and they're given weight for their own claims experience as well as the broader sector. That's a pretty standard credibility approach in the actuarial practice.
Let me ask you this: Have you done any work on the cost of a potential possible government subsidy to hold premiums for disability providers at a fixed level?
No.
It's open to government though, isn't it? Thank you.
I've got the I've got the premium rates for those two WIC codes. So non-residential care services, which is 872,920, is 3.780, and home care services 872,910 is 6.690. So those are relatively high industries. Yes.
And what are the risk factors which you say attached to them?
We've done a lot of work with care services. There is significant growth in physical claims and psychological claims in that industry. It's been a industry that has had unfortunately a high incidence rate of workers' comp.
A lot of them
injuries.
are not for profits, aren't they?
Yes.
I just asked for a document. Yes, here we go. If we could just hand a copy to the witnesses. Just to let you know, this is extracted from the SIRA open data system as at 15th of July 2025. It's just a bunch of the slides that get printed out once you select the various things. Mr. Latham, we can email you a copy. Apologies that it wasn't sent to you earlier.
Where's mine?
So, hang on, are you getting one? I think it's coming. You can have this one here. There we go. So what this is dragging out of that system what we think is happening with mental health claims. And I'm hoping that you can explain it to me, because from a layman's perspective, particularly if you look at what will be page 4 of that document entitled Mental Health Conditions.
Yes.
We're looking at, so this is only, even though we've extracted this at July, it's taking us up until April 2025.
Yes.
It looks like there's a really massive decline in the amount of mental health claims coming in. Can you explain what that's about and tell us what the actual situation is in relation to in relation to psychological claims?
Yes, I presume this is, I don't know if you know, the date of injury.
So this, you would expect to see that anytime you cut the SIRA open data this way.
Okay.
Because it takes time for claims to be accepted and then reflected in the data. So there is a lag in that process, and the way this data is cut, you see the lag in the form of that kind of cliff where the numbers come down. But if you just give it a few more months, the numbers for, say, April, March and February, they will increase every month.
So that's liability accepted month by month. Do you have then the raw data for the number of total claims that have come in over that period, so we can actually look at that? What is the sort of trend, if you like, for psychological claims coming in over that period of time since we last spoke?
Yes, we have that data, and I think that was part of the question on notice that we're preparing answers for. generally speaking, the psych claim volumes, we've seen year-on-year increase in the psychological claims volumes, both reported and accepted.
And how's that growth rate look? Because I know we were looking at quite a steep growth rate over a couple of the years, and a lot of those assumptions were based on whether the growth rate would continue at that level or whether it was actually closer to the base case scenario rather than the worst case scenario. How is it tracking along what we thought might be the case when we spoke at the last hearing?
It's still growing close to expected.
Okay, but it's growing, but in terms of that year-on-year growth rate, is it, if you just look at that, the growth rate, is the amount of growth increasing, or is it just the amount of claims in total are increasing? That's what I'm trying to get a handle on.
Do you have my comment there?
I do just... I've got the data up to 2024. I don't have 2025 with me. But the growth rate for the nominal insurer in 2024 year on year for psych is 38%. 2023 was 35%. For the TMF, the growth rate for psychological injuries in 2023 was 33%, and for 2024 was 20%.
So I'm trying to get a handle on what it is now for 2025. Perhaps you could take that on
of course.
Notice. The other thing that struck me out of this pack was there seems to be a huge number of reasonable excuse decisions. Is that consistent with what you would expect to see? So if you go to, I think it's about the third last page of the slide pack, what is the reason for that? Obviously, you were saying before about the data taking a while to come through, but this is actually a much greater number. So we're looking at sort of 263 for March versus 141 for February. What's the explanation for that?
It's a similar explanation. Some claims come in and they are reasonably excused until more information is provided.
Okay.
So as time progresses, some of these claims progress to being accepted or as some other status code.
Do you have the data for what that would look like at a similar time in relation to previous months, a few months ago, if you know what I mean? Like, how do we as lay people get an idea of what this trend should be, or, you know, what it is actually in reality once we consider the points that you've raised?
The best way to do that will be through an actuarial model. The short answer is yes, we have data available, but the other way to do it, really, to do it properly, you need a model where you break the difference between when the accident has happened and the delay to when these actions happen, so you can see the progression of the claim. Short of that, it's difficult to read the data as the snapshot and draw conclusions.
Okay, because when we've looked at this compared to what we did a few months ago, it does seem to be quite a significantly high percentage. But I guess what we're saying is we don't sort of have that data yet.
It's difficult with the snapshot data to draw conclusions.
Okay, all right. Thank you. I think I will hand over to Mr. Latham. Oh, you're on mute.
Yep, there we go. Okay, thank you. Mr. Dailou, why haven't you got the 2025 psych data?
2025, in terms of the calendar year...
First 6 months, we've had half a year, and the Chair's raised legitimate issues about the trend, and it'd be very helpful to the committee if you have that data.
I don't have it with me on hand, but we'll produce it.
Why? Why? Well, you know, this is your job, isn't it? Why?
I can't lug around every single data point there is, but very happy to take the question on notice and answer it.
Okay, you lug around. How heavy is your laptop in front of you?
I do.
You know, like, this is not the first time.
Mr. Latham, if you're happy to wait, I'm happy to look up the number for you, but you may have to wait.
It's not the first time you've come to the committee with a surprising level of ill-prepared approach. Is this part of some strategy the Treasurer has discussed with you to sort of keep us in the dark as much as possible?
A point of order has been raised. Yes, Mr. Nansley.
Chair, just a procedural fairness resolution, courtesy to the witness, but the witness has also undertaken to take the question on notice, as he's entitled to do.
Okay, I do uphold that point of order. If we could just proceed a bit more cautiously and allow the witness time to respond. Thank you.
Well, in fairness, Chair, we devote a fair bit of time and effort to these inquiries, and I know the New South Wales Public Service is not replete with rocket scientists by any means, but you expect the basic forms of information to be provided to us. But anyway, I'll move on. To Mr. Wesling, where is Ms. Applin? This is my third full day hearing on workers' compensation. She hasn't appeared yet. Is this something that's below the remit of the CEO of iCare?
Mr. Latham, when we received the invitation last week, the invitation was for a maximum of 2 witnesses, and we thought the continuity of Mr. Liu and myself made sense.
What about the CEO?
That was part of the decision making, yes.
Right. You weren't allowed to bring a third person, or?
Well, the invitation asked for a maximum of 2 representatives.
When we last met, there was an announcement that day that DXC were being popped out of iCare. Have you got some update as to why that occurred, and why were they contracted in the first place, only to find out a few months later that the goalposts had moved?
There was a decision by the board in June that we would discontinue the panel arrangement with DXC in the nominal insurer, and we made the decision as well. They hadn't commenced taking any claims in the TMF to not proceed with DXC in the TMF. They've been part of it.
What changed after February when they were contracted, and this is a company that says they put on, well, they say hundreds of extra people in anticipation of this work, and now they've been left stranded. Well, what changed between February and June?
The agreement with the panel arrangement was actually struck last year. We didn't announce it until March because we were still finalising with other providers, but we've gone through a process with the board over quite a long period of time at looking at what's in the best interests of the nominal insurer scheme panel arrangements, and the decision of the board in June was to make this decision.
Okay, what was so good about DXC in March that you announced that they were on board?
Well, the process specifically for the TMF panel spanned a period of probably 9 or 10 months last year, and that was a compliant procurement process which concluded with a development of a panel which was not dissimilar in terms of arrangements to the nominal insurer panel. We obviously have similar providers across the 2 panels. As I said, now that we're almost 3 years into the nominal insurer panel, we've done a lot of consideration with the board around what's in the best interests of the scheme going forward, and that was the decision.
Right, so what changed 3 months later? And do you think DXC was acting in good faith to put extra staff on in anticipation that you might honour the contract?
So what changed is looking at the entire scheme, the performance of the entire nominal insurer scheme, the needs of the scheme. We looked at the optimal size of the panel and the nominal insurer, and that was a decision that was made. And we had a consideration of what that would mean for the TMF, and this was the decision that was reached.
Okay, and who did that looking at analysis and made that decision? It's Ms. Applin, isn't it?
Well, these considerations, particularly on the nominal insurer, commenced last year, Mr. Latham. That was well before Ms. Applin joined iCare.
But this is obviously a decision that the CEO has ticked off on, yes?
No, the CEO, Ms. Applin, has a declared conflict of interest and played no role in this decision.
Right, and what was the basis of her conflict of interest?
Well, that's a matter between Ms. Applin and the board, but from what I understand, her prior employment at EML was declared as a conflict, and we've been managing that conflict diligently, that Ms. Applin doesn't get involved in any decisions that would have a direct impact or an indirect impact on EML.
Right, and EML part of what, 3 or 4 claims managers you have, is that right?
No, we have 5 claims managers.
Right.
With
And what share of the work does EML get?
At the moment, in the nominal insurer, they've reduced over the last 3 years from over 80% to now to about 50%. In the TMF, they have probably in order of about 50% market share of the TMF, and that hasn't changed as a result of this decision.
50? Was that 50?
50, yes.
50. So half your work involves an outfit, EML, where your CEO will, one assumes, constantly declare an interest and not be involved. Who appointed Miss Applin?
Oh, that would be a matter for the board, Mr. Latham.
The board think that perhaps in terms of propriety and value for money, appointing someone who would declare an interest for 50% of the workload because of a past association with EML was sort of in the theatre of the absurd.
That would be a matter for the board, Mr. Latham.
Would the board interview Miss Applin and say, well, EML matters are before you, what will you do? They interviewed her and raised this obvious issue?
I believe the process for the selection of the CEO is on the public record.
Order.
Right, and the board makes the decision. Does the treasurer play a role?
This is not an area of my expertise, Mr. Latham. I wasn't involved in the process.
Do you think the public could have any confidence in this hillbilly outfit that's employed someone who can only do half the work?
That's a matter for the board.
No, you're not going to answer that. It's in the area of supernatural. Thank you.
Thank you, Ms. Latham. Government members.
Thank you, Chair. Obviously, the issues concerning the financial sustainability of the nominal insurer and TMF are factors of what's happened in previous financial years as well as the current financial year. There have been a number of reviews into the workers' compensation system and into iCare specifically, through the Door Review, McDougall Review, and the Auditor General's review into workers' compensation claims management. I'm just interested in how iCare has responded to those independent reviews so far as they are relevant to them with respect to its performance and management.
Thanks for the question, Mr. Namva. You're right. Since I think 2020, 2021, we've had the Door Review and the SIRA and the subsequent SIRA 21-point plan into claims management, the McDougall Review, and the associated reviews that went with the McDougall Review along the lines of the culture, governance, accountability, the financial sustainability review, the procurement review, the governance review. We've had the SIRA TMF audit. The TMF audit and review, the Audit Office performance audit, the Treasury review of our operational expense base, and the Law and Justice Committee review into site claims. So we obviously there's been a number of recommendations, hundreds in fact, that we have been progressing over the last 3 or 4 years. As it relates to addressing the issues raised in the Door Review and the McDougall Review, which were earlier on in that period, there was obviously the improvement program that iCare progressed and completed. I recall, I think last year we had the final promontory review that closed out the 107 recommendations there that related to iCare. That included things that came out of the Door Review around raising the capability of our frontline case management. And arising from that, we launched the Professional Standards Framework, which was about setting minimum standards for an assessment of capability of our case managers and looking to raise that over time. We launched that, as you're aware, probably about 2 years ago. We're continuing to roll that out. We lowered caseloads to ensure case managers had time to undertake the work of case managing injuries. And I think we heard from another witness this morning, for example, that the challenges around doing work capacity decisions, capability is a really central part of that, professional standards and lowering caseloads. We heard from EML that their tenure has gone up materially of case managers in the last few years, and their turnover has come down, and we're seeing similar trends in the other claims service providers as well. We've restructured the panel in the nominal insurer. That was part of the nominal insurer improvement plan that arose from the McDougall review and the Dorr review. That include moving away from a cost-plus model with a single provider to what we launched with the panel arrangement in the NI, and that we're subsequently now in the process of revamping in the TMF this year as well. We introduced the specialist model to address challenges with how psychological claims were being dealt, and that was a response to the model that had been in place, a bit like the legislation, which is that it's essentially a one-size-fits-all. We moved to a specialist model that had specialist capability, different caseloads, different approaches to working with injured workers with a psychological injury. We've started publishing performance of claim service providers on our website, which we update quarterly to provide transparency on performance, and that covers return to work, compliance, caseloads, satisfaction. We introduced an expanded choice of claim service providers for employers. So obviously when you have one provider, there's not a lot of choice. Employers above $100,000 of premium now have the choice of providers, which is certainly a good motivator to drive performance amongst claim service providers. And we've had 800 employers or 800 policies actively choose to shift over the last 2 years. And these are larger employers, so 800 making that choice is a good start to, as we've introduced choice. And we've had a big focus on working with SIRA over the last few years to continue to improve case managers, with a particular focus on early intervention, rehabilitation, early rehabilitation, quality of injury management planning, a very big focus on the front end of setting claims up properly. We've also been working with our claim service providers in other areas like commutations. Up until last year, we probably do about 35 commutations per year. They're very time-consuming, and they're very stringent in terms of what claims qualify for commutations. We've actively expanded that process, proactively working with injured workers to ensure they're aware of their options around commutations, even within the existing regulations, and we now do about twice as many commutations. We've had a very big focus on work capacity decision making as well, and I think I heard some witnesses this morning talk about not enough being done. In 2021, we would do roughly 600 work capacity decisions a quarter that had an impact on injured worker wages. That's now doubled to 1,200 a quarter as we've worked with the claim service providers on how and when to do work capacity decisions, because they are a very important part of the program we run. So there is a range of things that we've done as a result of all of those reviews, and we still have recommendations that are outstanding that we continue to work on.
Just in terms of the Treasury operational review, presumably you've taken some executive roles out at head office, for want of a better description, and made other savings operationally?
That's right. The Treasury operational review resulted in a program of work at iCare around addressing efficiency opportunities in the cost base, and that included a reduction of executive roles, I will take it on notice for the exact number. I think it was 15%. There was 25% of the group executive team roles were removed as part of that process, as well as a number of other cost efficiency opportunities across iCare's operating cost base. And part of the conclusions reached in that Treasury operational review was that those efficiency exercises went a long way to demonstrating an efficient cost base at iCare.
You've already referenced some of this in your previous answer, but you are the body that oversees the resilience and integrity of the case management process in the workers' compensation scheme. Perhaps just elaborate a little bit more on the mechanisms that you've got to proactively ensure the KPIs are being met by the claim service providers.
Sorry, when you say resilience, do you mean of the case managers or the
scheme
performance
itself?
of the scheme?
Yeah.
Well, the remuneration model that was introduced in the nominal insurer in 2023 basically had three material components of it. There was the base fee, which was set at 95% of what we thought an appropriate cost base was, and that was really modelling a caseload, a lower caseload than it existed before. That set the base fee. There was then 10% of that was an additional 10% of that base fee was available for hitting quality metrics. So these are quality metrics around compliance dimensions, quality of things like early intervention, data integrity, POE calculations. So we had a set of quality measures that we assess, and that opens up a further 10% remuneration. And then there's outcome fees, which are based on a set of KPIs. There's about 10 or so of those KPIs, Mr. Namvar, that includes return to work. There are some, and those, the return to work targets, which make up about 50% of the available outcome fees, are at different stages of a claim. So we obviously look at return to work at different stages within the life of a claim. So those KPIs are set for each CSP based on their portfolio at those different levels. There's other metrics like medical cost control, which looks at how well we're managing the medical costs of the scheme. There's metrics around continuance rates for older claims to make sure we've still continue to have a focus on claims that exceed 2 years on the scheme. So there's a range of KPIs that form part of the remuneration model. Over and above that, we also...
Are they proactively monitored and enforced?
Well, we monitor them on a either monthly or quarterly basis, depending on how frequently those measures are able to be taken. And we meet with each of the CSPs operationally on a monthly basis, and then quarterly on a aggregate performance basis for each CSP to look at those performance dimensions. I was just going to add, we also have, so beyond the KPIs that impact remuneration, there's a whole raft of other quality assurance KPIs that we also track through our quality assurance program as well, which primarily look at, are we complying with the legislation, with the SIRA standards of practice? And we look at that both in terms of, there are a large number of timeframes that are legislated or activities that are set out in standards of practice. We look at that both quantitatively, so have we met timeframes for certain decision making, but also from a quality perspective as well. So have injury management plans been done to a sufficient enough standard?
Okay, thank you. Nothing further from me, Chair.
Anything further? No? Okay. I think that brings us to a close for this session. Thank you very much for your attendance again. To the extent that there were questions taken on notice or supplementary questions, the Committee Secretariat will be in touch, but that concludes our time with you. Thank you.
Thank you.
That brings us to our final session for the day. Thank you very much to representatives of the State Insurance Regulatory Authority for attending. 2 of you have already been sworn in, so you do not need to be sworn again. But for you, Mr. McCabe, if I could ask for you to state your name and position title and then swear either the oath or the affirmation.
Thank you. Yes, I'm Spencer McCabe, Director of Insurer Supervision at SIRA. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Fabulous. Thank you. You have been here before, but did you want to make a short opening statement at all?
Thank you, Chair. I won't be making an opening statement today. I understand you've received our written submission and we're happy to respond to any questions you may have.
Great. Thank you. We'll start with the opposition.
Thank you, Ms. Young. On page 19, I think, of your submission, you set out a range of activities that SIRA is engaged in improving the handling of psychological injury claims with a focus on real improvement on return to work. You want to turn that up? Yep. You got. Which of those do you see as the most promising, or do you expect any of these measures to in fact exert downward pressure on premiums?
So I think it's important when we think about return to work initiatives that anyone who is experiencing the scheme has an individual experience, and the nuance around this is that there will be a range of things that might help them. And I think what we've shown here are that it's really important to intervene early, and early intervention strategies are the most important. And then supporting people with an injury, and then compliance with obligation in terms of the return to work initiatives that we have in play. I think there's no one that is more important than another, because different things will work for different people.
Yep, I understand. So is there any evidence yet about strategies which might be working?
So in terms of the strategies that might be working, I think I'd take that in 2 ways. So there are a range of strategies that sit within this. So there's and I'm just checking on whether you're speaking directly around the vocational programs or just broader early intervention strategies.
Well, probably both. I'll come to the vocational strategy shortly.
Yeah, so I think early contact with workers, we know, is critical in getting people back to work. We know that the earlier that we can have conversations with people around their needs and what can help them return to work, you will get better outcomes. So that first 4 weeks is the most important time. And the strategies that are put in place around that and injury management will be the key things that will deliver better return to work outcomes. So I think that's probably the focus that I would say.
When were you first consulted in relation to lifting the WPI to 31%?
So
when was SIRA?
SIRA?
Yeah.
So SIRA have participated in the task force that the government set up, which is led by Treasury and DCS. Through that task force process, that task force provided information to government on what that could be. So I wouldn't be able to give you an exact date, but it would have been through that task force process earlier this year.
Well, did SIRA provide any advice to government about increasing it to?
We have continued to provide advice to government on all of the information that has been put forward.
And some of that advice, that's been an ongoing process?
It's been an ongoing process.
So would I expect to see those documents relating to that advice in respect of documents you've produced to the Parliament?
So I would say that the advice that we have given has been through our process of providing advice to the government, to Cabinet. So they would likely be a Cabinet in confidence. So they would likely be protected under those
Did you
measures.
obtain advice about that? About whether it was a document which is Cabinet in confidence? Or that advice was Cabinet in confidence?
So I suspect you're referring to the SO52,
yes,
which was requesting a range of advice. We provided around close to 300 documents through that process. Some would have been considered Cabinet in confidence, some would have been privileged, some commercial in confidence. We would have given that to the government to make the decision more broadly.
So did you just make any decision about whether it was Cabinet in confidence?
So I made the certification in terms of the SIRA documents and whether they would have been Cabinet in confidence or not.
So have they actually been produced? as cabinet in confidence?
I would have to check because we've given so many documents. It would depend on which documents and what, but I can come back to you on notice in terms of specific documents.
It's a bit surprising that if you look at the documents produced, there are no documents evidencing advice provided by SIRA in relation to the raising of the threshold to 31%.
As that advice would have been covered by Cabinet in confidence, as it was advice to the government for the government decision making.
Is it common that advice provided to government is Cabinet in confidence?
I think
what do you understand that to be?
I think that's when it's in related to the government decisions that are being made through the Cabinet process. Yes. Well,
had it been a position relating to a government decision at that time? It was advice you were being asked to give. I just wonder whether there's a policy position about what documents you have which are considered Cabinet in confidence.
It would be hard to say there's a policy decision. It's a decision of the government on whether they were provided as Cabinet in confidence. And we get advice from TCO and the Crown Solicitors in relation to whether those documents are.
Did you get that advice in this case?
I understand that that advice was sought particularly through the relevant processes for providing documents for an SO52.
Well, one of the documents which was requested to be produced is any advice which you have obtained in relation to the SO52. Why wasn't that advice provided?
So a decision was made that was covered by the Cabinet in confidence.
And you obtained Crown Solicitors and Treasury Office advice in relation to that?
I'm finding it difficult to answer your question because ultimately the decision was made that it was advice to government for a Cabinet decision.
And you obtained advice from the Crown Solicitor and Treasury in relation to that?
We certainly consulted with both.
And that advice hasn't been produced amongst the documents, has it? That they have given you?
As far as I'm aware, no, and it would be unlikely that advice from the Crown Solicitors would be part of that process.
Well, the SO52 sought, did it not, to the best of your recollection, any legal advice relating to the legality of the SO52?
That would have been a matter for the Cabinet Office through coordinating the response for the whole of government.
Can I ask this? Has SIRA done any work in relation to, or policy work in relation to presumptive cancers?
So we have provided advice to DCS, so the Department of Customer Service, who's leading that work. And also to Treasury through the process. We've provided them advice on a range of things over some period of time, and I think Mr. Fanker has been around for much longer than I, so he may wish to contribute, but we have provided ongoing advice in relation to presumptive cancers.
The SO52 sought those documents. Why were they not produced?
So again, they are advice for a decision of government. And are protected by the Cabinet in confidence provisions.
So, let me understand this. Is the position SIRA takes is if they're formulating policy advice to government, that's a Cabinet in confidence document?
It's dependent on the particular decision that's being made, and that was a decision for Cabinet.
And
so there's a range of policy that sits right across government. Some will be protected through the Cabinet process, others may not.
Well, I must say this is an extraordinary development in relation to the transparency of government decision making if the Cabinet is in fact being able to, or if the government is able just to unilaterally decide that it is Cabinet in confidence in circumstances where no such decision certainly was taken by previous governments in relation to that. But in any event, there was an independent have you got a copy of the final report from Alan Robertson being the independent inquiry into SIRA complaints handling?
So I have seen the report from Alan Robertson's inquiry. I'm the only one who has seen that within SIRA, or the context, and DCS are leading that process.
Are there any adverse findings made by Mr. Robertson in relation to that inquiry which he has conducted?
So the Minister is due to table that report in line with the GSE Act shortly, and until that point, it's not something that I can speak about.
Well, I'm not asking you to tell me what the adverse finding was, but are there any adverse findings against SIRA contained in that report?
There are a range of recommendations within that report.
Are there any findings in relation to that bill, in relation to that report, which have in fact found their way into this bill?
I think that's a matter for the Minister. I don't think it's relevant for me to speak on that report when it hasn't been lodged, and it's his responsibility to do that.
Well, I want to put this to you. We have sought a copy of that review to be provided to help this committee do its work. It would have been helpful, would it not, for us to have at least had a copy of that bill. That bill will probably be tabled next week.
Mm-hmm.
Do you agree with me that it would have been helpful for this committee to have had a copy of that bill, of that review into SIRA before this inquiry today?
I don't think it's a matter for me to agree with you on whether that is helpful or not, because it's a matter for the Minister on how he tables that report.
Well, considering that you know what's in that report, would it have been helpful to this committee to have had that review today?
Again, I don't think I'm in a place to respond to that.
One of the things that the bill does do is it gives SIRA power to endorse permanent impairment assessors and to select assessors when the parties can't agree. Did you seek that power, or did SIRA seek that power?
It hasn't been that we have sought any power. There's been a range of discussions of options for the government, and then we've provided advice on those options.
Where was those range of options included? Is this one of the documents that hasn't been produced pursuant to the SO 52?
I think, again, we provide that advice to government to make their decisions.
So the government makes a decision to, which is reasonably controversial, to allow the regulator to appoint assessors and to appoint assessors in circumstances to formulate whether capacity of injured workers and the like. And there's no documentation which surrounds the manner in which that decision was made.
So again, we continue to provide advice to the task force, who then provided that advice.
Well, does anyone else want to tell me whether, in fact, SIRA sought that for themselves?
Actually, I'll jump in if I may. SIRA didn't necessarily seek it, but if I can maybe just explain a little bit of what that provision does. So whole person impairment was introduced as a concept back in 2002 to basically sort of be a threshold or a gateway to sort of permanent impairment compensation, commutations, work injury damages. In 2012, it was expanded to provide access to weekly benefits and medical treatment. And presently, the way that works is, you can seek an assessment for any of those. So in many cases, a worker may have multiple assessments, and at present, the worker may seek an independent medical assessor and an impairment assessor. The insurer may seek it, so you've basically got doctors at 20 paces. So the provision here is a single assessment. There's two elements to it, a single assessment and a joint assessment. So a single assessment to determine your access to ongoing benefits with commutations, rather than doing one each time. And then a joint assessment where SIRA will basically control a list. We'll produce a list. We'll ensure the people on the list are qualified, have the experience, meet the training requirements.
I understand exactly, and I can understand that rationale. I was more interested in who sought the role for the regulator. Can I just take you to another question, Ms Young? There is a review done in relation to rehabilitation providers, has there not?
Yes, there has been.
Who ordered that review?
So that review was undertaken by SIRA and is just finalising at the moment. So we're in the very final stages of that. And we got Urbis to do that review in partnership with Monash University. And it's due to be released imminently.
What, the Minister has it?
No, the Minister doesn't have it. It's a SIRA review of workplace rehab providers.
And what, will you be publishing it on your website?
We will be publishing on our website. I can give you a sense of what's in that, if that's helpful.
Yeah, that would be helpful.
So we've completed the review. Overall, the results indicate that the system for workplace rehab providers is working well, and that they fill a really complex and valued role in the scheme. There are good return to work outcomes, durable return to work outcomes, so rates, and there's emerging evidence that they contribute to that. So the report identified some key challenges for us to continue to work through, and some suggested enhancements, and we're working with the sector to think about that. And we're going to be hosting a series of roundtables with the sector in the next month or so to look into some detail into the outcomes of that review and think about how we can continue to improve the workplace rehab providers. So there's 105 approved rehab providers, and they have significant reach across the scheme at the moment. We found out of the review that 3 in 4 people with an injury who engaged with a workplace rehab provider on their claim achieved a durable return to work outcome. And durable return to work is defined as 13 weeks essentially, being back in employment for more than 13 weeks. And it did show that the costs of that are quite cost effective. So for those durable return to work outcomes, the average claim cost was about $8,471. And that is quite a cost-effective way to get people back into work who may have been out of work for some time.
Okay, I've taken up a lot of my colleagues' time. I'm sorry, I apologise.
No worries. Thank you. When you say it's imminent for that report to be provided, I guess our understanding is that from the witnesses we had earlier is that was finalised some time ago, or at least the work had been completed some time ago. What sort of, I guess, dictates when that gets released, and how do you ensure that it doesn't get released at a politically opportune time?
So we don't run our reviews on necessarily the political opportune time, because that's not what we do. We're here to regulate. And when we are doing a review process, part of that process is we get a final draft, and then we look at that, and we may need some changes. We might have some advice in terms of some of how that's later. Not the findings themselves don't necessarily change because it's an independent report, but we have some tic-tac just and fact checking and a range of other things that sit within that. So we've just completed that process in the last week or two, and now we're now working through the plan for release. So when I say imminent, it is in the next couple of weeks.
So, and that will be very useful. I guess is there any scope, or has there been any involvement of any government member in the timing of the release of that report?
No.
Okay. When it comes to the performance review of claims managers, I understand you were doing another one of those as of last, I think, December 24, but we haven't seen that yet either. When will that be released?
So again, that one is in its final stages. It's slightly behind the workplace rehab providers, and that's a broad claims management review, which was a review that we committed to undertaking out of the Law and Justice recommendations. So again, it's in the final stages, so I can give some headlines around what we've found through that. And just to be clear, that broader review included a range of inputs. So it included claims data and the return to work data. It included an independent literature review and some customer insights. It included the findings from our claims management audits, and that was an audit of the TMF, an audit of the nominal insurer, and we have had an auditing program of all of our self and specialised insurers, which is also inputted into that. And we've also worked with insurers to get some insurer insights as well. So the key findings of that report probably echo a range of things that have come out of the conversations that you have had here today. So effective claims management leads to improved outcomes. Claims management performance does need some improvement. Modern work and workplaces have amplified the need for that improvement. Compensable claims management models might not align with the needs of workers and psychological injury. There are opportunities to reduce regulatory complexity and administrative burden. And there is emerging evidence supporting a shift towards a person-centred culture and a model to improve return-to-work outcomes. So no great surprises in the findings of that, and then there's a suite of recommendations that sit around that as well.
Okay, that sounds like something that would be incredibly valuable for the work that we do on this committee. When sort of rough timing for when that will be released?
So we've been working on a timeline. We're finalising, because it's a review that SIRA has done ourselves, we're finalising the draft in terms of its presentation and what that looks like. And we will aim to again release that in the next, certainly within the next month.
Has there been improvement on the injury management plans and the legislative timelines, compliance and things like that that were raised in the 23 review? Has there been any significant improvement?
So I think there is still work to be done, and I'll ask Spencer, my colleague Mr McCabe, to jump in at this when we talk about this. But certainly the issues remain very, very similarly to what they have previously. There has certainly been some improvements, but I think each insurer may have a different area of focus that they are required to do, it's probably fair to say. So self and specialised self-insurers have, particular runway, which things that they're better at than the others, self similarly, and then the nominal insurer and TMF. So there's a range of things that sit within that, and it's quite complex. Yeah. But I think more broadly that the key things that they all have to work on are embedding that person-centred claims management approach and enhancing our support for workers and employers and their role, and some streamlining of our regulation and reducing administrative burden, and a real system-wide cultural and strategic change.
Is it your view that improving those measures and that claims management process will in turn improve return to work rates and in turn then the financial stability of the scheme?
I think so, yes. And I think particularly when we talk about it, for an example would be injury management. If we can have improved injury management, we will get better return to work.
And forgive me, and apologies because I don't have very much time. I would like to ask more questions, but maybe we'll do that on notice. I think it's very frustrating to me to look at every review that we've ever had into workers' compensation in the last 10 years, including the work of the Law and Justice Committee, yourselves, all of the recommendations come out of every report, including the Auditor General's report, that all go to the need to improve claims management and how that will then have that flow-on effect to return to work rates, and then that will help save hundreds of millions of dollars of the scheme. That we're not waiting for that work to bear fruit before the government is coming in with these other proposals. Now, I can't ask you to comment on that.
I would say though, Ms Boyd, I would say that I think it's no one thing. So I think we need to improve claims management. We also need to improve the financial sustainability of the scheme in other ways. Like there's not just one thing, so there's a range of things that we need to do.
But that seems like that would be a rather large factor. Can I just, one last question, and I'm just going to get it in after that bell, but I don't see the Treasurer having responsibility under the allocation of acts for any of the three relevant bits of legislation here, particularly when it comes to the legislation that governs yourselves and iCare. You have been involved in this process of these reforms being proposed. At what point did anyone raise the issue of why is the Treasurer involved in reforming legislation and a scheme that he has no statutory responsibility for?
So the Treasurer ultimately has responsibility for the finances of the state. This is an impact on that, and he does have some oversight, and Treasury has some oversight of iCare and the nominal insurer, which have a significant impact on the scheme more broadly. So,
sure.
The
Premier has an interest too, but
yes.
you know, at what point does Daniel Mookie get to become Scott Morrison and take on portfolio responsibilities that are not his own? I'm just curious as to whether anybody raised that internally as an issue of good governance, that you had a minister not responsible for an area intervening and leading reforms.
We've always approached it as a collaborative issue because there is the financial sustainability, which is a responsibility of the Treasurer more broadly, and that we have responsibility, and the Minister for Customer Service has responsibility for the legislation and a lot of it, and so does Minister Kotsis. So there's three different areas that are all working together to think about the sustainability of the scheme.
Thank you. Mr. Latham.
Thank you. Well, Daniel Mookie's the smartest person in the room. Why can't he be Scott Morrison and run 6 portfolios? But can I just ask our friends from SIRA, thanks for coming along, and heavy criticism earlier on. I don't know if you heard Mark Murray, the head of the Labor Council, but also on the board of iCare, say that SIRA doesn't do its job. SIRA doesn't regulate in any sustainable, effective shape and form. So in fairness, how do you respond to that?
So I would respond to that in that we do regulate. There is always room for improvement in regulation, and SIRA has been very focused on improving our regulation over the last particularly couple of years. One of the ways that we have done that is through its regulatory framework that we set last year, and thinking about how we deliver our regulatory functions. So that's to provide some transparency and clarity on our approach and how we do that, and we continue to work to that today. We recently released our regulatory priorities for this year, and that is, a really principles and governance in our approach, and our processes and tools, and what's considered in arriving to an appropriate response. We talk through that. We're looking at the design, our licensing, supervising and enforcing, and really being deliberate about how we go about that. We run a range of audits, and we do that across the scheme. So we do quarterly audits of iCare for the nominal insurer and TMF, and we're doing a self and specialised auditing program as well. We identify the common themes across all of those, and we respond with our relevant regulatory actions where we can. Those regulatory actions are different depending on the insurer type. So if it's a self-specialised insurer, we actually license them and then can put conditions on their licence or go through a range of other things. With iCare, we certainly work with them a little bit more collaboratively, and we started doing and when I say collaboratively, I want to be clear that we will regulate, and we put them through remediation processes, and we may do the letter of censure or use our other regulatory tools. But we are working with iCare to become very clear about what we expect and what that looks like. And in fact, we have developed a supervision plan of iCare for the next 12 months, and it will be ongoing. But that's really targeted, focusing on their policy and underwriting processes, claims management, their info technology systems, and their implementation of the relevant recommendations and commitments, and through any other reform work that we do. So we are. What I would say to Mr. Murray, it may not seem like we're doing a lot, but there's a lot been going on in the background, and our ability to increase that audit and refocus ourselves on those things has been really important to me as Chief Executive in coming in as well.
Well, I'm sure he's listening, and that's your right of reply. Thank you very much. I'm also interested in a matter I raised earlier in the day, these psychological impairment ratings that you produce. They had me chuckling, I've got to say. Level 3, moderate impairment in self-care and personal hygiene. He's prompting to shower daily and wear clean clothes. I'm sorry, if you're a parent of teenage boys, you can only laugh about this kind of thing and doesn't prepare their own meals. Who prepares this material?
So I might hand to my colleague next to me, Mr. Fanker, who's very much au fait with the policy around this.
Yeah, you're talking there about the PERS scale, and I think there was some of the earlier witnesses were talking about PERS and GEPIC, and there's a couple of different tools to diagnose mental illness, and PERS has 6 functions that it works across, being intellectual, thinking, perception, judgment, mood, and behaviour. And with each of those, they're basically, as you've said, ranked 1 to 5.
Yeah.
And
what about self-care and personal hygiene? Is that in there too?
I don't have it in front of me, so
can you give us the full PERS for the benefit of the committee? The full PERS pack of material as how you do these ratings, and what then happens with them? Who uses this stuff?
So we can provide
claims managers in liaison with medicos, yeah.
Yep. So we can provide that to the committee, that detail you've just spoken about. So basically, that is sort of used by a mental health professional to diagnose an illness and then ultimately someone's level of whole person impairment. That is provided to the insurers for them to make decisions. It's provided to the worker and their legal representatives. If the matter ends up in dispute in front of the commission, that is used as part of the evidence. I think as you heard earlier today from one of the medical experts who's an assessor, they consider all of those materials when making their assessments.
What's the link between capacity to work and relying on takeaway food? What if someone just likes takeaway food? It is designed with certain components of fat and other tastes to hook you in, and we all eat it at some stage, some more than others. But what is the link between work capacity and relying on takeaway food?
As I said, there's sort of 6 functions it's across. There's a score of 1 to 5 in each one, so you can't really look at one individual component of one function by itself. It has to be sort of weighed up against all of the others to show someone's capacity to do things. And I think, as you heard earlier from one of the assessors, part of the conversation that they have with the individual is, how have things changed for you? Did you used to do these things? Did you used to enjoy certain aspects of life that you no longer can? So it's very much not just
honesty.
A single piece.
Yeah, sure. It's an honesty system, and I've only looked at this today. But if I wanted to get a claim going, I'd just tell the psych, I love Macca's, I love KFC, I really don't cook much. I don't comb my hair, I don't like having showers. My mother's got to ring me up to remind me about things. And, I don't go out much and I've got headaches. My life's a wreck. And you'd get on compo, wouldn't it? Just by saying that. Isn't this the problem of sort of Mad Hatter's Tea Party guidelines, where people just study it up, say these things, who can disprove it? There's no x-ray of the human brain, and we've got a massively rorted, expensive system that's going broke. Bingo.
Order, we've come to government questions. I will just check that there's no responses from witnesses to the...
Don't propose. No.
Okay.
Take that on notice. Can you take that on notice? It seems a good summary of where we're at.
Okay. Moving on to the Honourable Bob Namber.
Thank you, Chair. Probably just one quick one from me. You'd have to agree that given, any further operational and administrative improvements, including to claims management in the scheme, are not unhelpful when it comes to cost avoidance, but alone they're not going to be game changers given the multi-billion-dollar deficit that the schemes find themselves in. You'd agree with that?
I would agree, and that's what I was saying before. It's not just one thing that is going to solve the issues of the scheme.
So beyond operational and administrative efficiencies and improvements, we are then talking about elements of scheme design. Is that correct?
Yes, we are.
Okay. Thank you, Chair.
Okay. Further questions?
No, I've got further.
No?
But I just want, it's
Okay.
sort of like my Columbo question, with not the same devastating effect. Have you looked at the amendments which have been proposed in relation to the bill?
Yes.
Did it surprise you to learn that the actuaries have costed the amendments almost as much, or saving almost as much as the government's own bill, without reducing any of the potential workers' benefits which are contained currently?
I'm not an actuary, so I would say surprising me is not.
No,
hard
well, not
to
surprising
do.
you. Well, in view of the answer which you've just given to Mr. Nanva about potentially tinkering around the edges, and your response being that there's not a one size fits all solution to this problem, would you agree with me that a lot more could potentially be done, which makes significant savings at the front end of this scheme as much as at the back end of this scheme where you already have seriously injured workers?
I think there are a range of levers that can be used right across the scheme. And I think when you pull one, it might have an impact somewhere else. So it's really hard to sort of say whether something will work better than another until you put all of those assumptions into the actual costings themselves. So it would be difficult to say that one particular thing is going to work in a particular way until you know how it's going to impact the rest of the scheme as well.
Okay. If there is no further questions, then I think you get an early mark. Thank you very much for giving us the benefit of your expertise again today. To the extent that there were questions taken on notice or further supplementary questions, the Community Secretariat will be in touch. But that concludes our hearing for today. Thank you.
Thank you.
Thank you, Chair. Thank you, members.